Sir, may I mention your lordship's order of last Friday, my lord? The name of the one of the appearing advocate has gone down wrongly, my lord. I have corrected it in pencil, my lord.
To be mentioned next Friday. Oh, well, yes.
I appear for the petitioner, but here, my lord, I had indicated, my lord, day before that, my lord, Mr. Singh is leading me, my lord. He's
Order sheet. Yes.
praying for an adjournment. Mr. Singh is leading me, my lord. He's not in town. In fact, not in the country. My lord.
Should have mentioned in
But
front.
I have.
Yeah.
I had mentioned.
Mr. Shah, then we'll keep it whenever.
Maybe I request for 4th April, my lord, next 2 Fridays.
4th April.
I will be in some difficulty.
Yes, no difficulty on my part. So 4th April.
Grateful.
Learned counsel for the petitioner prays for an adjournment. Let the matter stand adjourned till April 4, 2025.
Grateful.
Thank you. Please just give me.
Item number 2, my lord, in this matter, Ms. Jui Dotto Chakraborty is appearing.
Mr. Yes,
Jui
yes.
Dotto Chakraborty is appearing on behalf of the judgment debtor. She is engaged in courtroom number 34. May I read for a short passover in this matter?
This matter, I mean, she need not need to be present in this matter, your lordship. On 28th February, your lordship had directed them to serve a copy of the GA, which they have failed, your lordship.
A copy of?
Copy of the GA application that has been filed for recalling of the order.
Yes.
Your lordship, your lordship had on order dated 8th October 2024 had directed them to file the affidavit of assets. They failed to do so, your lordship. And they have subsequently filed this GA for recalling of this application in place of filing the affidavit of assets, your lordship. They have not filed it still today, and they have not even complied with the order, your lordship. There's no need for this application, your lordship. They can just file the affidavit of assets in the EC that's running in the list, your lordship.
We'll consider that when they move the application. So today, since she is in difficulty, we will not take up the matter. On the prayer of the applicant, let the matter stand adjourned for the day.
Much obliged, your lordship.
That order still stands then.
Lordship. Lordship, in any manner.
For the day, mane job hai. Yes. So you can praise before the executing court.
Lordship.
Item number 3 and 4, may I please your lord, may I take your lordship's leave to appear virtually. Lordship,
Yes.
I am appearing for the award holder. Lordship will recall item number 3. Item number 4 was an execution application which Mr. Thakkar was moving on the previous day.
I'm appearing on behalf.
Yes.
And item number 3 is a review application which the award debtors had taken out, and they had said they would move it maybe after the execution application is moved. So they had prayed for a accommodation 3 weeks back. So today it's both listed.
Yes. What do you say?
My lord, I'm appearing in item number 3. I'm appearing on behalf of the review applicant. My lord, that the review may be adjourned for a further period of 3 weeks. My lord, we'll argue the 48 applications.
Very well. On the prayer of the review applicant, the matter is adjourned till March 28, 2025.
Grateful, my lord.
You are entitled to give your name.
No. My lord, 4, my lord, is the section 48, which were being argued out. Mr. Thakkar argued on the last date.
Yes, yes.
Lord, today Mr. Bachawat is to start. Lord, I just got a call from him. He's about to reach the court in some time. There's a big jam, my lord, just across Dhakur here. Lordship gives me a short passover, my lord.
Short passover, other matters are also parted. So if you grant a passover, you cannot reach probably. Not
I'll
today.
take my chance.
And very well, short passover.
Great.
Passover Thakkar. Order. Yes.
Mr. Thakkar appearing for the petitioner, my lord.
I
While making not to him.
On the prayer of the petitioner, the matter is adjourned for the day.
It was only for Mr. Thakkar to file his written notes. Last occasion here indicated.
File your notes then.
Yes, not yet prepared, my lord. Not yet prepared, my lord.
Because we already concluded. Mr. Thakkar had concluded.
Adjourned for the day. Yes.
I was addressing your lordship on the last occasion.
Yes.
This is, my lord, regarding the tunnel boring machine.
Yes.
Now, let's just, my lord, to start. proceedings, my lord, your lordship will remember that the incident occurred on the 31st of August 2019. And well, ultimately, the tunnel boring machine was excavated after 909 days, and that too in parts. It had to be dismantled and excavated.
Yes.
Now, your lordship remembers that the petitioner's case, at least as far as its notes is concerned, is really essentially threefold. Lack of greasing in the tail seal brushes. That's number one. Number two, they said that there was improper handling or steering of the tunnel boring machine, which resulted in erosion of the brushes.
Yes.
And number three, they said that this caused the failure, which is edification, the inflow of water. Now,
Pardon? What is the third point?
third point is, as per his note, I'm reading.
Yes, yes, yes.
Failure to stem inflow of water into the TBM.
Right.
Well, that I would imagine is a consequence of what my learned friend alleges is the failure of the tail seal brushes. And
Probably it's dependent on the other two.
That's it. That's it.
Yes.
Now, I had started showing your lordship, what was the case of the petitioner in its statement of defense filed before the arbitral tribunal. Well, I had shown portions of the SOD on the last occasion.
Yes.
Just to show that the assertion was, I shall just read a few paragraphs. The statement of defense, because this will set the tone for the entire argument.
Yes.
The statement of defense, may I request your lordship to please have a look at paragraph 22. I had placed some of these paragraphs.
What is the page number?
Well, this page number is 6140. This is in volume 37.
Yes, 6-1. You placed up to this.
Yes, I had placed some portions I do not.
I'm sorry, Lord, I couldn't make
No,
it
Mr.
up in
Vatsal,
time.
no
I'm very
difficulty. I've given a passover. If you are available, then we'll take up the matter.
I'm here only for this matter. Otherwise, it wasn't
No,
coming.
that was, I thought that, yes.
No, that's
Yes.
I'm apologizing because
No question. Yes. No question.
Lordship will remember I had placed from paragraph 22.
Yes.
Sporadically some of the paragraphs.
Right.
Kindly just allow me to quickly just retrace my steps so that I can have the continuity. Claimant was required to carry out the tunneling work by using two earth pressure balancing EPB tunnel boring machines. Claimant was thus required to deploy two tunnel boring machines in short TBM for one for each track, eastbound track from Shealda to Esplanade, westbound track from Esplanade to Shealda. So, two tunneling boring machines were a part of the contract. Then paragraph 23. Well, these are the requisites of TBMs. And TBMs here were chosen with consultation with the KMRC. The contract requires the TBMs to have arrangements to prevent water ingress. Watertight TBMs were required to be used in terms of the contract. It is pertinent to mention that in terms of the employer's requirements, tunnel boring machine was required to comprise of the following prerequisites. 1. Tunnel shield supplied by contractor shall be truly circular, strong enough and to avoid distortion. 2 is 17, that is item number 17, machine tail skin shall be fitted with adequate tail seal to prevent ingress of water. Well, this, according to my learned friends, were the requisites. Then paragraph 25. Respondents state that for water to enter into the TBM, the groundwater must be higher than the water resistance of the seal. The deepest point of tunnel drive between Esplanade Station and Shealda Station, that is the realigned route, is about 25 meters. Water resistance of the seal of TBM, as per its design, is around 37.5 meters, considering the factor of safety of 1:50. Therefore, at the deepest point of the tunnel drive, there would be no occasion for water ingress. The TBMs deployed by the claimant could withstand water pressure equivalent to 37.5 m. Then please have a look at paragraph 26C. Well, at first, paragraph 26A, he says how the water can enter the TBM through the screw conveyor. We are not concerned with that. Secondly, my lord, it says can enter through the articulation joint, which we are also not concerned with. Then C. Thirdly, water can also enter through the tail seal at the rear of the TBM. The tail seal at the rear is designed to prevent the grout and water from entering into the machine. Then please have a look at paragraph 28. Well, this is important. On and from August 2019, it was becoming evident that there was influx of grout or slush or water in the TBM through the tail seal. Abstract of daily activity reports for the months of August 2019, prepared by engineer and communicated to the claimant on 26 November 2019 is annexed hereto, marked such and such. Throughout the month of August 2019, the water inflow problem had been noticed. Correspondence exchanged between the parties, including with the engineer. There had already been 2 replacements of brushes in TBM 1. For the required 2.5 kilometer run, there should have been no necessity of changing brushes. However, another change of brushes was intended. My lord, may I just pause here for a moment? My lord, what this clearly, my lord, states is that, my lord, change of tail seal brushes is a regular feature. It's a feature of maintenance, it's a feature of, my lord, safety. Now, my lord, here your lordship will see that, my lord, daily activity reports are maintained. That is the admission. Daily activity reports include, my lord, all reports with regard to, my lord, the operation of the machine and, my lord, requirement of change of tail seal brushes. Now, my lord, what is very important is, my lord, my learned friend states here that from August 2019, it was becoming evident that there was influx of grout slush water. Now, my lord, that did not cause them to withdraw the machine or to say suspend operations. Now, my lord, so far as this is concerned, this is therefore a feature which was always brought to the notice, or, my lord, was always within the ken of, my lord, the GC. It was being monitored. And, my lord, in the course of monitoring, they suggested, or, my lord, it was suggested by the contractor, that, my lord, tail seal brushes should be replaced, just to, my lord, prevent an eventuality. And they were replaced on 2 occasions in August. And, my lord, although it was said that there should have been no further occasion to change brushes for the last 2.5 kilometers, my lord, it was decided that another change of brushes would be, my lord, made. My lord, why? Because it was going to pass through a very highly populated, my lord, dense residential area. And, my lord, as a measure of additional safety, it was then decided that we will have another change of tail seal brushes. My lord, what this indicates up to now, from the, my lord, statement of defense itself, is that, my lord, there was regular monitoring of this fact and of this activity. Now, my lord, when tail seal brushes are changed, my lord, one of the essential concomitants of such change is, my lord, the greasing. Because, my lord, that is what is admitted, I shall show you, lordship. And, my lord, daily greasing reports used to be maintained. Now, if your lordship will kindly then see, my lord, paragraph 29. On 31st August 2019, there was an incident where the TBM tail seal started getting breached, and there was a huge inflow inside the tunnel. The result whereof was large-scale ground settlement, resulting in severe damage to structures on the surface of the soil. On that day, the claimant had been advancing the westbound TBM 1 towards Shialda station, and at the start of the day shift, the ring 1, 2, 3, 4 had been constructed. It had been intended to advance and build 4 or 5 more rings to reach, my lord, a predetermined stoppage location by the claimant. It was then intended the maintenance would be carried out or repairs would be done to the tail seals of TBM 1. So, my lord, progressing, there's a predetermined stop, it will reach that stop, and then, my lord, the tail seal brush will be changed. It had been indicated by the claimant that 5 rings would be built in day shift up to ring 1239. After erection of this ring, TBM 1 would be pushed forward and the segment of ring 1239 would be removed to expose the innermost 2 rows of the tail seal brushes out of the 3 rows. Claimant intended that the 2 inner rows of tail skin brushes would be replaced. 5 rings up to such and such had been erected and primary grout was done up to the tail skin back of TBM 1, had excavated and moved forward up to the location of ring 1240, which was the location for the brush change predetermined by the claimant. Preparatory work was commenced for dismantling ring such and such. A flow of water and fine ground material appeared between the last erected ring and the tail skin sill. The material coming into TBM was fine soil, sand, and silt and cement, bentonite particles of grout suspended in water. The flow rate was reasonably high. The claimant ineffectively attempted to contain the flow by grouting, but they failed in their effort as they didn't have necessary supporting mitigation measures available at
What is grouting?
My lord, grouting is, my lord, when, my lord, I understand.
Cement component with water, my lord.
What is grouting as verb?
It's a concrete.
What do you do when you grout as a verb?
Whose soils then become solidifies. Soils are dispersive in nature, but
To contain the flow by grouting.
grouting means
Flow by, it qualifies flow.
yes,
Flow by grouting. That's good.
But I understand it is my lord, very loosely what I have understood, of course not very technically, is my lord, it's cementing up the whole place to
Yes.
prevent my lord ingress
Yes.
of water.
Milord, when you put cement, Milord, it's in an aqueous condition.
Seal.
So you put it, it will get sealed, nothing comes in.
All right. Thank you.
Now, my lord, up to now, my lord, here at paragraph 30, your lordship will see, my lord, that my lord, ultimately they failed to take, my lord, mitigation steps. Supporting mitigation measures were not available at site. Now, my lord, there is no amplification of this term. What were the supporting mitigation measures that was required to be available? What were the supporting mitigation measures that were not available? My lord, this is where it stops. My lord, up to now, my lord, we have a discussion of, my lord, how the machine progressed. My lord, that there were, my lord, incidents, my lord, which required change of tail seal brushes on 2 occasions in August. Predetermined stop for a third change, where it was to reach that stop. Well, it reached that stop, my lord, tail seal arrangements were being made for change of brush. Now, my lord, please see, now, my lord, the allegations start from paragraph 31. TBM 1 consisted of 3 rows of brushes. Between rows of brushes, there is a grease chamber. Before the commencement of tunneling, a thicker pre-start grease should be properly injected inside the brushes to fill up the voids between the wires. This is to protect wires of the brushes and to prevent the grout to compact the brushes. It is very important to note that the flexible nature of the brushes is to adjust its thickness to suit the varying gap widths between the tail scale and the concrete ring. One of the important features of the brush is that the same is required to be flexible and should work with grease, as the brush wires would not be compact and loose, the adjustment ability, which is the key to prevent inflow of grout, groundwater, and soil inside the machine. During the performance of the contract, the claimant had used only a single layered brush before changing to double layered of brushes after tunnel incident. Well, just pausing here for a moment. Well, there was no allegation that single layer brushes were not adequate. Well, after the accident, it is just to increase the safety features that this was in double layer brushes were introduced, but this was not a requirement of the contract. This was not a requirement of the original equipment manufacturer. This was not a requirement of the GC. This was not a requirement of the engineer. Well, this is just a feature that was introduced. Well, just by way of abundant caution after the accident had occurred. And your lordship will remember that, my lord, after the accident, my lord, the contract was not terminated. The same contractor was asked to carry on the work with added safety measures. And, my lord, it is this other, my lord, boring machine that was, my lord, boring the other tunnel that was now brought in use, my lord, for the purpose of completing the boring of this particular tunnel. And, my lord, they are identical TBMs of the same make, of the same manufacturer, from the same, my lord, original equipment manufacturer source. Then, my lord, next paragraph. During every excavation cycle of TBM tunneling, the claimant was required to fill the 2 annular grease chambers between 3 rows of brushes with grease. As the concrete ring is pushed outside the tail skin, while tunnel machine is advancing, an amount of grease may stick onto the outside of the ring, which will be lost to the void behind the TBM. To ensure concrete sealing, the grease needs to be replenished as the TBM moves forward each time. The purpose of the grease chamber is to separate the 3 rows of brushes and allow the grease to fill up the gap between the tail skin and the erected concrete ring. The grease in the chamber is pressurized to ensure that there is no trapped air inside the grease and to have full contact with the concrete ring and the tail skin. It also needs to push the grease around the grease chamber to fill up between injection ports. This will form another protective safety barrier to prevent the increase of the water or grout during tunneling operation. In TBM deployed by the claimant, there was a total of 8 grease lines to feed grease into the 2 chambers. That is 4 grease lines per chamber. Grease was required to travel about 2.5 meters on either side of the feeding point in order to maintain the grease level inside the grease chambers. There are also 2 spare lines installed at 12 o'clock position, 1 in each chamber, which were not used in TBM 1. During the tunneling operation, the grease pressure and grease volume was required to be monitored by the claimant to ensure that the grease chambers are always full and the tail seal could prevent any ingress of water, soil, or grout into the machine. The records of grease filling was provided by the claimant on the Heritage mining report. Now, my lord, this is very important. My lord, there were, my lord, regular records maintained of, my lord, the grease filling into the chambers. And, my lord, I shall show you, lordship, that, my lord, the engineer was a constant monitor for the entire project. The GC was also, my lord, invested with such, my lord, rights and authority. And, my lord, no one ever raised any question with regard to the greasing of the tail skins. Now, my lord, very important is, now, my lord, these are, my lord, something that are underground. You can't really, my lord, go and inspect what is happening. Well, it is therefore, my lord, the record of greasing that is maintained, my lord, which is to be followed. Now, my lord, so far as this is concerned, at the time of the change of the two seal brushes in August, of course, my lord, previously there were numerous changes. My lord, when the tail seal brushes are changed, my lord, naturally, my lord, greasing is an important component of the change of the tail seal brushes. My lord, this is done in the presence of the engineers, with notice to the engineers and under their supervision. Now, my lord, there was no contemporaneous objection raised with regard to the greasing. Now, what my learned friend says, that, my lord, the records of the grease filling was provided by the claimant on the Next mining report. So, my lord, this was something that was regularly, my lord, made known to
Maintained.
them. In case there is not enough grease pumped in to replenish the grease that is lost as the TBM moves forward, the friction on the brushes will increase and accelerate the wear and tear. As the brushes wear down, it creates gaps for the grout material to travel forward into the brushes and into the chambers. Thus, the aforementioned irregularity of TBM resulted in deterioration of the effectiveness of the tail seal. Now, I am just pausing here for a moment. Now, my lord, we say why greasing is important. And then, my lord, we say, thus the aforementioned irregularity of the TBM resulted in deterioration. Now, my lord, we don't yet know from the narrative that what is, my lord, the, my lord, irregularity in TBM, my lord, that is mentioned in the statement of defense. Because, my lord, this is the substratum of the case on which the entire argument is to, my lord, to be laid. There is an allegation that there is an irregularity of TBM, and this resulted in deterioration of the effectiveness of the tail seal. But we have thus far not come forward as to what was, my lord, the irregularity. Then, my lord, will kindly see the next paragraph. Apart from the above, during the operation of the TBM deployed, the brushes became full with grout and they became compacted and flattened to the inside of the shield. Thus, the TBM was unable to adjust its thickness according to the varying gaps between the machine and the erected ring. Since necessary steps were not taken by the claimant, the grout-hardened brushes were ripped out and lost behind the TBM wall. Now, my lord, we don't know again, my lord, for the second time, what were the necessary steps that were required to be taken and what were not taken. This in turn allowed more grout to enter and thus the situation became worse. The brush seal system was no longer effective and the grout material could not be contained inside the void around the rings at the rear of the TBM. Thus, the void was not filled with grout and it allowed a path for the groundwater to reach the brush seal and flow into the TBM. Then, if your lordship will kindly see, the next paragraph is very important. The engineer of the respondent had carried out an analysis of the grease consumption records from the commencement of tunneling ring number 1.
We hope the people inside came out safely. There are people, it's manned.
That unfortunately
happened.
Yes.
Thank
But
God.
no lives were lost. Property was damaged. Property above the ground was damaged. And at that point of time, I had the occasion to, my lord, appear in a public interest litigation that was filed, my lord, before, my lord, court number 1.
For compensation for those people who's
No, they were saying that immediately stop the work because there's ground settlement.
Okay.
The public had come and I was appearing for the
Public.
metro rail at that point of time. And my lord, there I had the occasion to, my lord, ultimately rely on all the reports that, my lord, now my learned friends rely on to say that no, we have contained the situation.
So you're trying to seal the grout both ways.
Yes, that's
These reports were not there.
These?
These reports were not there at that point of time. Several other reports must be.
No, it's on a different.
I'm not getting there, my lord.
No.
I'm now addressing, my lord, my learned friends.
He's just saying that he appeared. The curiosity. He appeared for
Yes,
the public interest litigation.
Correct. I was his junior.
Oh, acha. More interesting.
Yes, but the reports.
No, no, he's not saying that.
No, these are subsequent reports. Those are separate.
Not
set of
saying
reports.
that.
I am quite conscious of that. I shall address
He's
you.
not saying that.
Now, well, this is interesting. The engineer of the respondent had carried out an analysis of the grease consumption records from the commencement of the tunneling ring 1 to the point of tunnel ring number 1239. Now, my lord, when this study was conducted, my lord, is not mentioned here. It was, my lord, apparently done after, my lord, the machine had been excavated after a period of 909 days.
There is a case of Mr. Chaudhary also.
That's right.
Probably. It was done after.
That's right. Now, my lord, here
Analysis could only be done after the thinking.
now, my lord, the question is, my lord, here, my lord, amount of grease pumped into the grease chambers. Well, that analysis is being made, my lord, now. Well, after a period of 909 days, my lord, how that analysis is made, how the analysis proceeds, my lord, is not mentioned here. I shall, my lord, show you, lordship, that report also.
But the report probably says that.
No, my lord, not really. I shall show you, lordship. Now, my lord, then please see. Amount of grease pumped into the grease chamber as recorded by the TBM data log was compared with the theoretical calculation of the required volume of grease to be inside the grease chamber is shown in the table below. So, my lord, what they do is, my lord, not to, my lord, really make an assessment of how much grease was pumped in. But, my lord, at this point of time, there's a theoretical analysis.
No, he says that the amount of grease actually pumped in as per the data log,
That's right.
that
data
has
log.
been compared with the
Now, my lord, the
estimate.
data log is therefore maintained.
Yes.
Now, my lord, when the data log is maintained, my lord, there is no objection raised with regard to the amount of grease that is being pumped in. My lord, this data log is maintained for TBM 1, for TBM 2, my lord, identical machines, identical process. And, my lord, this is, my lord, always available to, my lord, the authorities, including the engineer and the GC. And, my lord, at this point of time, please see that, my lord, there is no objection raised with regard to the tail seal brushes, with regard to the change, with regard to the process followed during the change, and with regard to, my lord, the pumping in of grease, which is a daily feature, a regular feature, for which a complete data log is
But
maintained.
Mr. Shah, can it be contemporaneously monitored from above the surface when it is being done?
No. No,
because
the
that is
the
it is
pumping-
proved not to be possible because they did the data analysis
No,
subsequently.
but the pumping of the grease is possible because, my lord, there are grease
From the
lines.
from above the ground, the GC or the engineer, he's above the ground.
Yes. No, my lord, so far as the pumping of the grease is concerned, my lord, that is, my lord, but there are people who are underground also inside the machine, not monitoring the process.
They are your people.
Well, they are my people, and the engineer has complete access all the time, throughout. Well, that I should show you, lordship, from the contract.
Access how? He could not go in.
No, he could go in.
Okay.
Well, it was not as if it's a capsule sent into space. You can't go in.
Yes,
and come
like
out.
yes.
Well, you can go in. You can come out.
To the journey to the center of that sort of that
Yes.
not that sort of.
No.
So there's constant access. They can have physical access.
Not a Sunita Williams situation.
Sunita Williams. Poor Sunita Williams.
No.
Cannot even imagine.
It's very difficult.
Cannot even imagine. Yes.
Well, they enter the machine every day. They come out every day. Now,
On a lighter note, it's a spaceship underground
Yes.
with I think one or two drivers.
There was an Asimov story that there's a world underground, and for
Yes.
them, the what's thick soil to us, it's air for them. So they breathe there, they fly there, their birds fly there, and they have a higher density.
They had
So the entire thing is just like another Earth below.
another Earth.
The people there, they have higher density, the creatures. So we have higher density. That's why air is air to us. Similar. I mean, underground, our soil is their air.
But if you've done an underwater dive, it looks like a different world. You
yes,
do get
that much I have done.
You do get that feeling.
Yes, but this is much more serious.
Yes, but
soil around grout and soil.
Yes, not the TBM,
not even transparent.
The TBM driver had come. I started cross-examining him. Then both parties agreed.
He should be highly paid.
Yes. So I asked him that, don't you get scared? He said it's a different world.
They have no option. The people who rise on the stilts to maintain our buildings, they don't have any option due to their stomach.
I just imagine.
They don't have any option. It's their job. They have to earn money.
They have to. Inside
Even if they have
capsule.
fears, I went to Kashmir and one person, he was on the houseboat. I mean, he was working in the houseboat, but he's an MA, master's, doesn't have a job. He said that I fear water like anything. I have a panic for regarding water.
And he works
He has
on
to
a
work on the
houseboat.
houseboat and travel by boat to the shore. Anyway, let us talk. If you go into those things, then everything will be grease and grout for you.
Yeah, I had two relatives. One was a fighter pilot with the Indian Air Force, and the other was my lord, in a submarine. Underworld. So,
How could they be your relatives? You are in such a safe job and all.
fortunately, my lord, there are some people I can look up to, not say look down to.
Yes. Right.
My lord, coming back to my lord, paragraph 38. So,
38.
my lord, what my learned friends say in the statement of defense is that
Yeah.
the amount of grease pumped into the grease chamber as recorded by the TBM data log was compared with the theoretical calculation of the required volume of grease to be inside the grease chamber and is shown in the table below. Now, my lord, this is, my lord, a theoretical calculation that is being made, and my lord, kindly see, ultimately they say that, my lord, in the table, to the extent that I've been able to, my lord, understand, my lord, please see, my lord, the fourth column, rings
Yes.
with less than 100% required grease pumped in, 230, then, my lord, 253, 294. Then say rings with less than 100% required grease pumped in, 54, 64, 73. Then, my lord, paragraph 40, I, my lord, don't really know what to make of this, but Herennext's mining report supplied by the contractor, though otherwise inadmissible and incorrect, records the amount of grease that was used for each advance. This data can be used to calculate the applied grease volume in terms of percentage that was pumped into the chambers during each ring building. It appears that such purported report that before the first brush change, 54% of the rings were built with deficiency in volume of grease required to maintain the performance of the tail seal. I'm pausing here for a moment. These rings were built, there was no difficulty. Despite having knowledge of the fact that the brush seal was devoid of grease and was required to be replaced, the claimant then reduced grease consumption between the first and the second brush change, and there was 64% of the rings deficient in grease volumes. Now, my lord, so far as this is concerned, again, my lord, there is no complaint of any failure. Then, in the final section, the situation deteriorated further, and as much as 73% deficiency was found in the grease volume. The aforementioned irregularities would show that the claimant had been consistently pumping in insufficient volume of grease into the grease chamber and had not rectified the mistakes even after previous brush seal changes. Now, the brush seal changes are something that happens with the notice and knowledge of the respondents and their engineers. And up to that, there's nothing. And this is a theoretical hypothesis that is being put forward. Furthermore, 63% of the rings in the total tunnel were deficient in the required volume of grease. Then, kindly see. However, the average volume used over the length of the tunnel was 97% of the required amount. This was due to large volumes of grease being pumped by the claimant, as the claimants over-greased in an attempt to prevent leakages after the brushes were damaged. Well, I don't know. Well, once you say 53, once you say 64, once you say 73, overall 97, and now you are complaining of over-greasing. This was due to large volumes of grease being pumped by the claimant as the claimants over-greased in an attempt to prevent leakages after the brushes were damaged. Now, the brushes were not damaged. 2 tail seal brushes are replaced in August. The third brush is due for replacement. So, my lord, where is the question of, my lord, over-greasing the machine after the brushes are damaged? This resulted in filling the void behind the TBM with grease instead of grout, further impacting the problem. Thus, once the groundwater enters the TBM, the groundwater could easily push the grease out in the void and increase the open path. My lord, this is, my lord, the allegation so far as, my lord, grouting, greasing, tail seal brushes is concerned. My lord, just to, my lord, pause here for a moment. The substance of, my lord, what my learned friends have said is that, my lord, there was, my lord, insufficient greasing. My lord, this ultimately impacted the tail seal brushes, caused them to, my lord, wear and tear, and ultimately this caused the problem. But, my lord, there is a regular, my lord, TBM, my lord, greasing data log that is maintained. That was, my lord, available with my learned friends. They did not find anything wrong with it. The engineers and, my lord, GC had absolute and complete access to, my lord, the TBM and to the work sites. Did not raise any problems. They monitored the change of the 2 tail seal brushes in August 2019. Did not find anything, my lord, that was a problem. They scheduled a predetermined stop for the third tail seal change, which would have meant the brushes would have been changed. The contemplation is that if the brush had been changed, then there would not have been a problem. But before that brush could be changed, the incident happened. And this is what we have by way of allegations with regard to the tail seal brushes and the improper or insufficient greasing. Then the next set of allegations, which of course has not been really ultimately emphasized upon, is paragraph 43 onwards, improper steering of the TBM. This, of course, is something that my learned friends have not really emphasized in the course of arguments.
No, I have.
Very well, he says he has. Now, please see. Now, here, improper steering of the TBM in the curves has caused distortion in the billet rings, which is manifested by steps in the billet rings, which also reduced the 30mm clear gap between the billet segments and tail seal shield. This has resulted into the hard contact of brushes on the billet rings rather than support through brush and grease. So now we are moving away from the greasing aspect, which caused the accident, into improper steering. Now, I do not know, at least I have not been able to decipher from the statement of defense as to whether these are independently to be components of the cause or conjointly to be the components of the accident. If today it is a result of improper greasing, then can steering be an issue? If it is a result of improper steering, is greasing the cause?
Could might not be mutually exclusive.
That's right.
Both may happen.
Problem is here your lordship is seeing, therefore, all the time trying to emphasize before lordship, as my learned friends are themselves pondering as to what was the cause. There is no definite conclusion. So we are now at the stage of conjecture. Perhaps it was the grease. Perhaps it was the quality of the tail seal brushes. Perhaps it was the improper.
Could improper steering be proved in any manner? It cannot be.
At least
Either way, it cannot be.
Not only that,
and not necessarily that it goes in their favor, what I am saying, but even then it cannot be proved as such.
Now, what is improper steering? It is the direction in which the machine moves.
Yes.
Now, there are designated tunnels.
Right.
It has to move within the tunnels. It cannot veer left and right. Now, so far as this is concerned, at every stage, the route is planned. It is the route that has to be followed.
So you say no deviation from the route has been proved?
No deviation route has been even alleged. But now we are ultimately suffused with very technical jargon. And
Yes.
we are not really in a position to now at this stage, before a court of law, in a position to choose between the different alternatives that are being suggested as the plausible causes of the accident. Now, just to give you just one or two paragraphs more before I move away from the statement of defense. It says improper steering, then that says the clearance between the segmental lining and the brush seal is only 30mm. During the operation of the TBM, the clearance around the ring to the tail skein maintained by rotating the ring around the center point to position the maximum taper to give the required steering properties. The clearance is checked in every ring build and the requirement steering is planned and built. In many parts, the underground two tunnel, etc., clearance gap has not been maintained. Now, at this point of time, the question would be, what therefore is the role of the engineer? So far as the greasing report is concerned, which has been commented on by my learned friends, that is RD9, I shall take your lordship to that. But here at this point of time, please see what is the engineer's role in all of this, because this becomes important. When you say greasing is not proper, tail skin brushes not being properly changed or are wearing out, or machine is not being properly steered. Please have a look at the contract once. This is in the GCC and SCC, which I believe was separately handed up to you. Just a few clauses. I'll not trouble you with too many clauses.
GCC application. GCC একটা general conditions of contract ওইটাই বোধহয়
আলাদা করে দাও।
ওটাই বলছি তো দেখিনি
This is
that's not the GCC, must be that এটি পুরোটা contract
page 21 এটা হবে, তো part 1 ই হবে।
বলছি তো ওটাই।
পার্ট 2 তে আছে।
This is
This is it, the general conditions, part 2.
পার্ট 2 তে আছে।
নিয়ে নিও না ঝট করে।
But
21
uh,
GCC 21 GCC stroke
this
21.
is volume 2 at page, I think, 21.
Is this that the contract agreement?
Yes, ma'am.
This is part 2. Acha, pagination at the bottom. 000 then the page.
Well, the pagination at the bottom would be
tallies with the
GCC
GCC
14
this.
at the bottom. The running page is 0014, yes, GCC, when page 14.
Running page, there's no running page at the top. 14 tallies with the 000 page also.
Clause 3, my lord, engineer.
Yes.
Yes. May I just show you, lordship, my lord, 1 or 2 clauses in this. Well, clause 3, engineer, the employer shall notify the contractor.
Engineer is the GC.
Yes.
GC and engineer not in.
No.
Yes.
The employer shall notify the contractor in writing of the appointment and identity of the engineer and of any replacement from time to time. Now, 3.2 is important. The engineer shall carry out the duties specified in the contract. Now, so far as the contract is concerned, the contract is, my lord, a separate GC contract with the GC, my lord, which is also on record. Engineer shall carry out the duties specified in the contract. The engineer shall have no authority to amend the contract. Engineer may exercise the authority specified in or necessarily to be implied from the contract. If the engineer is required to obtain the specific approval of the employer before exercising such authority, such requirements shall be stated in the special conditions of contract. Any requisite approval shall be deemed to have been given by the employer for any such authority exercise. Well, this is, my lord, the broad spectrum of the engineer's authority. Then, if your lordship will kindly have a look at.
Then immediately next subparagraph was placed by Mr. Chaudhary. So that says the engineer, nothing done, not done or done by the engineer shall relieve the contractor.
But that is generally in all contracts.
Yes.
It is ultimately, my lord.
So if you have a liability, that remains.
Yes,
despite
the liability remains. But, my lord, what is important is, my lord, here, well, your lordship will kindly, my lord, look at, my lord, the nature of the contracts. These are all contracts of adhesion. My lord, dotted line contracts. I'm not saying that, my lord, I'll be relieved of any obligation under the contract. But, my lord, these contracts, my lord, as a matter of general rule, say that yes, the engineer will have this authority, that authority, but you will still be responsible.
Yes.
I am not, my lord, seeking to shy away from responsibility if it falls on you. But I am now trying to show your lordship as to what was within the scope of the engineer's authority. Now, well, so far as this is concerned, please now, my lord, please have a look at clause 4.2.3, which of course is, my lord, 4.2.4, I'm sorry. Well, this is at
4.2.3 is the last subparagraph of
no, my lord, 4.2.4, access for engineer. That is, my lord, the page number is 27 at the bottom.
Oh, there is no point in between 2 and 4. 4.24.
4.24.
Because 4. It ends at 4.2.3.
Yes, ma'am.
4.24.
Access for engineer.
Access for.
The contractor shall allow the engineer or the engineer's representative or any other person authorized by him at all times to access to the site and to any place where work in connection with the contract is being carried out or is intended to be carried out, and to any place where materials or plant are being manufactured, fabricated, and or assembled for the works. The contractor shall ensure that subcontracts, if any, shall contain provisions entitling the engineer or any person authorized by him to have such access. So, my lord, it is, my lord, absolute, my lord, unmitigated access that is provided to the engineer for the purpose of course, my lord, overseeing the plant and machinery, the course of manufacture of the plant and machinery, and of course the implementation. Then please see, my lord, the quality control clause, that is 7.1, which your lordship will find at page 39.
Yes.
All plant and materials to be supplied shall be manufactured, and all work to be done shall be executed in the manner set out in the contract. What important is plant and material supplied shall be manufactured as per the contract. So, my lord, TBMs are, of course, my lord, machines that are chosen in consultation with, my lord, the petitioner. Where the manner of manufacture and execution is not set out in the contract, the work shall be executed in a proper workmanlike and careful manner with properly equipped facilities and non-hazardous materials and in accordance with modern recognized good practice. Then, my lord, please skip over delivery to site, see inspection 7.3. The employer and the engineer shall at all reasonable times have full access to all parts of the site and to all places from which natural materials are being obtained, and during production, manufacture, fabrication, and construction at site and elsewhere. Construction at site is, my lord, the rings that are constructed, and elsewhere, be entitled to inspect, examine, measure, and test the materials and workmanship, and to check the progress of manufacture of all plant and materials to be supplied under the contract. The contractor shall give the engineer full opportunity to carry out these activities, including providing access, facilities, permissions, and safety equipment. No such activity or inspection shall relieve the contractor of any obligation or responsibility. Well, that is again a standard feature. Well, I'm not saying that if I'm guilty of any wrongdoing, I shall be relieved of, my lord, those obligations. Then, my lord, please see, well, at clause 3.2, well, this is, I think, of the special conditions of contract, SCC. It's the same volume. Well, that your lordship will find at page, well, at 78. Functions of engineer.
Functions for engineer, yes.
Well, at 3.2.
Right.
In addition to the duties mentioned in clause 3.2 of the general conditions of contract, well, the functions of engineer will be to watch and inspect the works, monitor the test results, examine any material to be used, and workmanship employed by the contractor in connection with the works. Now, the works is the, my lord, boring of the tunnels and, my lord, the erection of, my lord, the stations. Shall carry out such duties and exercise such powers vested in the engineer in accordance with the provisions of the contract. Shall issue instructions which, in his opinion, are necessary for the execution of the works. May issue any other instruction which, in his opinion, is desirable in connection with the works. Now, my lord, this is very important because, my lord, this ultimately, my lord, really says that the engineer will have, my lord, overall authority in the matter of inspecting, my lord, whatever work is to be done. Now, my lord, we come to, my lord, a few obligations of the GC. My lord, this your lordship will find, well, it is a contract that is entered into with the GC and KMRCL, that is at volume 78. Well, at volume 78, my lord, this document is styled document and naam tak. Okay, it's okay. 12272. Well, I want to show your lordship the heading of the contract 12273.
Yes.
Well, this is, well, at page 12278. Well, this is what it is. Well, I don't know whether your lordship has it. Page 12278.
Yes.
Well, this is the Kolkata East-West Metro Project Technical Financial Proposal for General Consultancy Services. Well, this is, well, really the contract with the consultant. I will request your lordship to kindly have a look at, well, at page 12330 now.
Yes, please.
Your lordship will find there's clause 3.10, which talks about obligations and responsibilities of general consultant. Now, it says, everything under the sun is their obligation and responsibility. But, I shall just point out one or two of them. Obligations of general consultant, if your lordship will kindly see, then at page 12331, there your lordship will find, just after 4 lines at the top, the main role of GC will be as follows. Well, it is a little difficult to read. But
No, it's all right.
the main role of the GC will be as follows. Well, I will not trouble your lordship with, I think, since there are no numbers, bullet point numbers. But first, your lordship will, GC will review the details given in the DPR, not important. GC will coordinate the detailed design consultants for civil works, etc. That is also not very important. Then the third bullet is GC will coordinate with civil and EM works for detailed designs, etc. Not important. Fourth is GC will prepare tender design, not important. Then GC will scrutinize and put up for reapproval, for approval of KMRCL designs drawings. Then GC will proof check the work of detailed designs. Then GC will assist KMRCL in keeping the Commissioner of Railway Safety, Government of India informed.
Can come to GC will ensure adherence.
GC will ensure adherence to the standards prescribed by KMRCL by contractors with regard to safety of works, safety of adjoining and overlying structures, safety of workmen and safety of public during the construction stage of KMRCL, as the principal employer will continue to have the overall responsibility as per the applicable law. Now, this is important because here your lordship will see, they are responsible for the overall safety of the works, safety of the overlying and adjoining structures, safety of the workmen, safety of the public. And this will include all the facets that we are now talking about. Then, next item, your lordship will see, GC will certify the quantum of work done, its quality, and the payments to be made. The quality is also their responsibility. GC will coordinate, review, monitor efforts of all contractors, consultants, suppliers. GC will carry out construction, erection, supervision at various levels. Well, there are several others which I don't find very relevant, except maybe at 1, 2, 3, 3, 3.
Yes.
Well, please see responsibilities of general consultant. Well, amongst them, 3.11.1, GC shall at all times exercise all reasonable skill, care, and diligence in the discharge of his duties. GC shall also be responsible for the accuracy and completeness of his works and commissioning of East-West Metro. Then GC will be responsible to ensure that the goods and services used on the project are appropriate, suitable, and at reasonable cost. Well, the rest is not very important. So, the goods and services used would include the greasing. Then, 3.11.5, GC will advise KMRCL for engagement of all contractors, suppliers, manufacturers, other consultants, and be responsible for coordinating efforts and activities of all such agencies. And then, next one, 3.11.6, GC shall maintain full records to all aspects of the work covered by the project. Such records shall be made available at all times to KMRCL for inspection. Mere acceptance by KMRCL shall not relieve GC of their professional obligation to correct at their own cost any error in the work. One more thing that I'd like to draw your lordship's attention, clause 3.6. That yes, my lord. 13327. 12327.
Yes.
Supervision and monitoring, 3.6.
Right.
The GC shall be responsible for supervising all project activities. Suitable methods and systems shall be developed by the GC for ensuring implementation to the desired quality and safety compliance to time schedule and compliance to environmental norms. They shall also design suitable information systems to report to KMRCL with latter's approval. The items will include but not be limited to site visits, inspection, testing, commissioning, information with regard to programming, budgeting, etc., etc.
3.6.11 is very important.
Yes.
Next one.
Well, all that I'm trying to say is, my lord, here, well, if your lordship sees, my lord, undertake visits to site for what purpose? That your lordship was pleased to point out.
Yes, that is what is important.
For quality assurance, for safety assurance, to conformity to the contract and directive.
Monitor the contractor's activity for quality assurance.
Yes.
Safety insurances.
Now, my lord, it is, my lord, here, my lord, where we have to presently, my lord, stop just for a, my lord, small, my lord, understanding of how the situation thus progress. Now, my lord, here, if your lordship, my lord, just harks back, my lord, the allegation is that you did not properly grease the tail seal brushes. Well, there is no allegation that the tail seal brushes were substandard. The allegation is you did not properly grease the tail seal brushes. When, my lord, daily greasing reports were being maintained and, my lord, forwarded, and the engineer had full access to them. Well, and, my lord, ultimately it is said that you did not adequately grease. Of course, the rings were, my lord, properly erected. And then you were guilty of over greasing. Now, my lord, ultimately, my lord, when, my lord, after, my lord, about 900 days, after almost 3 years, when, my lord, it is excavated in bits and parts, my lord, they don't do a physical, my lord, analysis of what was the amount of grease, my lord, found available at any of the chambers. 8 greasing lines. What they do is, my lord, now carry out a hypothesis on the basis of, my lord, what is, my lord, the requirement of greasing and what is, my lord, the amount of greasing done as per, my lord, the...
No, they check what was the actual grease deployed, but they say the hypothesis is on the ideal greasing which should have been there, and they calculate the percentage on that in their chart. They say this should have been the ideal scenario of greasing. They have said in the chart, Mr. Shah, they have said that this is the actual greasing used, but they say all the same it was
That is on the basis of, my lord, the greasing report in Hellingecht.
right.
That is, my lord, the report that we have
Right.
maintained.
Right.
And that is the report that was regularly made available.
Hmm.
And, my lord, this was within their knowledge and under, my lord, their scrutiny.
Did they didn't produce the GC report at the relevant point of time at all?
No. Well, that, my lord, happened much later after excavation.
So contemporaneously, GC also should have had a report, which was
Yes,
never produced.
They did. They did, my lord, have the Hellingecht report, which is a daily greasing report. And, my lord, your lordship has seen that it is the engineer's duty to, my lord, scrutinize these and to instruct and to, my lord, ask for revision, ask for change. Not done. Now, my lord, I can well understand that, my lord, today, my lord, my learned friends are saying that you failed in your duty. Well, but, my lord, today, if the project is of such importance and ultimately involves, my lord, the safety and security of not only, my lord, the people who are working in the project, but also, my lord, people outside. My lord, then, my lord, one must ascribe a role to the GC. And, my lord, here the engineer and GC were vested, my lord, with obligations, my lord, which they were required to perform, because they must have then pointed out, at least contemporary, look, this is where you're going wrong, stop.
So there is no explanation at all as to what was the role of the GC or what he actually did.
No.
His performance. There is nothing on that.
In fact, my lord, your lordship will find attempt is now to distance the GC, that this was not within the GC's responsibility at all. Now, my lord, I asked myself this question. Well, of course, my lord, your lordship is in a 34 jurisdiction. But my lord, your lordship is trying to see as to whether the result that has been, my lord, ultimately reached by the tribunal is, my lord, something that will shock the conscience of the court. Is it something, my lord, that is, my lord, absolutely implausible? Or is it something that is probable? And if there are two, my lord, probable answers, two probable results, then, my lord, if the tribunal has chosen one over the other, then your lordship will normally not interfere with that. Now, my lord, I am now trying to only, my lord, direct your lordship's attention to what was the case of the parties, how they approach the problem, what is their, my lord, allegation. Now, the first set of allegations has nothing to do with, my lord, something that was unforeseen. Because, my lord, he says it is your fault. It was nothing unforeseen. It is because of improper greasing that the tail seal brushes were eroded. It is because of the erosion of the tail seal brushes that water came in gushing. Which means that if the tail seal brushes had not eroded, or, my lord, if there was proper greasing, in that case, this problem would not have occurred. So, my lord, what is foreseen, unforeseen, that cause does not arise here at all. Now, my lord, so far as the unforeseen physical condition, my lord, there is a provision, my lord, although your lordship has found that the contract says that I will not be relieved of my obligation, even if, my lord, the employer is visited with, my lord, certain responsibilities, and the GC has certain obligations to perform. My lord, the question will be that, my lord, is it something that then can be, my lord, ultimately pointed out to be my lapse? Because, my lord, when I was working, when the going was good, my lord, everything was fine, no complaints. It is only when the accident occurred that complaints started, my lord, coming up. And I was not relieved of my obligations. I was not penalized for, my lord, this accident. I was not, my lord, taken off the job. I was, in fact, asked to continue with the work. Now, my lord, here, the second part of it. My lord, what is my lord, explanation for the events that happened? And, my lord, how does the, my lord, how is this countered? But if your lordship will now, my lord, please, before I take your lordship through, my lord, just 1 or 2 paragraphs of the statement of claim, please see, my lord, the contractual condition, my lord, which talks about unforeseen physical conditions. That is clause 4.23. My lord, that is at, in the contract document, what, at page 27. No, page 27, 027. But it আছে, জজের কাছে আছে।
Yes.
My lord, unforeseeable physical conditions. So, my lord, this is an eventuality that is contemplated in the contract. You're ultimately, my lord, working underground. You can only make an estimation of what is to be found, but, my lord, you are not absolutely sure. In this clause, physical conditions means natural physical conditions, which the contractor encounters at site while executing the works, including climatic conditions. So, my lord, physical conditions, including climatic conditions, include, my lord, subsoil water, and, my lord, the pressure of water, my lord, which is encountered also. Now, the question is whether this was unforeseen. If during the execution of the works, the contractor shall encounter physical conditions, which in his opinion could not have been reasonably foreseen by an experienced contractor, the contractor shall forthwith give written notice thereof to the engineer. And if in the opinion of the engineer such conditions could not have been reasonably foreseen by an experienced contractor, then the engineer shall certify and employer shall be pay reasonable additional cost to which the contractor shall have been put to by reason of such conditions. A, for complying with any instruction which the engineer may issue to the contractor. B, for proper and reasonable measures approved by the engineer which the contractor may take in the absence of specific instructions. Well, pausing here for a moment. So, well, at first, the contract contemplates that there may be such an unforeseen eventuality or situation. And this would include physical conditions. Physical conditions would include climatic conditions and naturally, my lord, the physical presence of large volumes of water or water, my lord, coming at a large force or pressure. Now, my
But
lord,
then you had to give a notice.
I have to give notice, my lord, if it is.
You did not have the time here.
Yes, my lord. So, my lord,
this does not help you or go against you in any manner.
But it is only this that, my lord, I would have been, if I had given notice and, my lord, the work had been certified, then of course I could have claimed the excess amount spent in doing the work. That is, my lord, the import of this clause. But, my lord, if a situation arises, my lord, where there is no chance of giving a notice, then also the question would be, my lord, whether the accident was, my lord, of my own doing, or whether it was because of an unforeseen physical, my lord, condition that, my lord, suddenly came to prevail or was suddenly discovered. Now, my lord, only to that extent, because, my lord, here your lordship will find that the tribunal has refused, my lord, to compensate me for any extra cost that I say have incurred in performing the works. It has only said that I shall give you the money that was to be paid to the ultimately, my lord, residents whose buildings were damaged or, my lord, were ultimately.
There's a section 34 by you also.
Section 34 আছে এটা আমার তো section 34 no.
So you cannot get that.
No, I have not challenged that. Well, I have, my lord, I'm happy with what I have got. Well, I won't say happy, but I'm, my lord,
moderately satisfied.
Moderately satisfied. Yes. moderately satisfied. Now, my lord, so far as this is concerned, my lord, this, my lord, they have tried to say is not something that was unforeseen. Now, your lordship has seen that, my lord, the tunnel boring machine was designed to operate under certain water pressures.
Mr. Shah, you are trying to you are trying to prove by showing this clause that there could have been unforeseeable physical conditions which were contemplated in the GCC.
And, my lord, my assertion was that, my lord, the amount of water that we suddenly encountered was something that could not have been foreseen. Now, my lord, if today it is an unforeseen physical condition, then, my lord, I am not guilty of it. I am not responsible. My lord, whether my learned friend, my lord, has to compensate me or not for additional costs that were incurred by me is a different matter. Now, my lord, apart from this, there is also a force majeure provision.
This force majeure, I was looking for that.
Yes. Well, that you will find at page 68 of the GCC.
That would be more appropriate, probably. 68, yes, force majeure, right.
Well, at 16, well, in this clause, force majeure means an event beyond the control of the employer and the contractor, which makes it impossible or illegal for a party to perform, including but not limited to, well, an act of God, war, hostilities, etc. Then, my lord, this is an inclusive clause, including but not limited to. And then after, my lord, A to E, if your lordship sees, if a party considers that it may be affected by force majeure, it shall promptly notify. Well, again, my lord, there was no opportunity of giving any notice. Then 16.2, neither the employer nor the contractor shall be considered in default or in contractual breach to the extent that the performance of the obligations is prevented by a force majeure event, which arises after the date of notice to proceed upon the occurrence of such force majeure. The affected party shall endeavor to continue to perform its obligations as far as reasonably practicable. And then, if your lordship will see, if
but this is after the notice.
Yes, but my lord, here the
but
question
this sort of a situation is not contemplated at all here.
That's right. But my lord, force majeure is, my lord, a situation which is beyond the control of either party.
Obviously, then how do you have time to give notice?
That's right.
Just give a notice before you die, sort of.
Sometimes it is
prior
possible.
notice, unless there's a prior notice, there cannot be
Well, there is
any death
something that we
benefits.
call the doctrine of reasonable foreseeability. Well, all contracts are premised on this doctrine.
That is in any event applicable.
Yes. Now, my lord, as an experienced contractor who has been working in this field, can reasonably foresee some things. And, my lord, that is why we reasonably estimate as to what is, my lord, the water pressure that the machine can withstand up to a particular depth.
Rather, Mr. Shaha, that unforeseeable, that should have been foreseeable. In case of foreseeable issues which might come up, you should give a notice. Otherwise, you won't be given the additional costs.
What they say is everything is your responsibility. Unless you are
unforeseeable, if it's unforeseeable, how can you give a notice? I mean, only if there is something foreseeable which crops up subsequently, then you can give a notice and you can be compensated for that. Like in other contracts, building contracts also, if some other work is required to be done to complete that work, you can give a notice, and if they agree, then they'll compensate you. Unforeseeable, where is the question of giving any notice?
Fortunately, my lord, these are, my lord, standard clauses which are, my lord, incorporated in contracts without, my lord, very much application of mine.
I mean, act of God, force majeure, you're drowning and you give a notice. And even 21 days probably.
Yes.
Great.
Well, the world was created in 4 days. This.
Yes, might have been.
So
might have been.
21 days is a, my lord, very, very long time. Long notice.
Yes.
If the world is created in 4 days, destruction might take even less.
No.
Well, then, my lord, please see 16.2. I've shown 16.2. Then, my lord.
This is ridiculous. If affected by force majeure, you will promptly notify and.
Well, what was probably intended that if you encounter a situation, well, for example, my lord, if you encounter, my lord, in the course of tunneling, my lord, huge, my lord, boulders which impede your way.
Yes.
Then, my lord, that is something that was not foreseen. Then you give notice. Then you get sanctioned to, my lord, blast through the boulders and. But, my lord, not for even such as this. My lord, this is, my lord, more an act of God, or, my lord, act over which, my lord, there is no control of either party, as your lordship has, my lord, very correctly pointed out. Now, my lord, so far as, my lord, the statement of claim is concerned, my lord, there was an attempt to, my lord, make a causative analysis of what caused the accident, my lord, in the statement of claim, because, my lord, everyone is trying to gauge what exactly happened. Well, if your lordship will kindly have a look at the statement of claim, my lord, I shall just, my lord, straight away, my lord, cut to the, my lord, main part of it. That's page 370. That's volume 3.
8 is one. Thank you. Sorry, 300?
My lord, 370.
Yes.
Now, my lord, this is, my lord,
The causative analysis. This
yes, my lord, and this, my lord, really recounts as to what happened at the time
Hmm.
or immediately following the accident.
Hmm.
And, my lord, then, my lord, this has been dealt with by the respondent or by the petition in the statement of defense. Very briefly, I should show you, lordship.
Hmm.
Well, immediately after the incident, the claimant engaged several experts for ascertaining the cause of the incident of ground settlement. Well, these were GeoConsult India, an engineering consultant expert in the ground engineering, rock mechanics, geology, mining, etc. Mr. Charles Mann, TBM expert, which was an independent assessor. Mr. Subarna Jurong Consultants, well, a tunnel designing drawing consultants, and Herrenschnecht India Private Limited, original equipment manufacturer. This was the original TBM manufacturer.
Hmm.
Noteworthy that none of the aforesaid reports even remotely indicated or suggested any failure, default, negligence, or any other variety of omission on the part of the claimant. Then, my lord, there's a brief summary of what they have said. My lord, this will actually save a lot of effort in going through these reports. Dr. Florian of Messrs. GeoConsult India Limited clearly inferred in his report that the properties of the soil at and around the location of the incident is different from that examined or envisaged earlier. Mr. Charles Mann independently inferred that there was nothing to disprove the conclusion that the TBM hit a large water body that was unexpected and unforeseen during the TBM excavation. The Subarna Jurong report inferred that the incident might be due to unforeseen condition at subsurface, such as potential water connectivity which caused leakage into the tunnel tail skill location. All these reports were submitted to the GC and the respondent on 29th October 2019 and 16th November 2020.
Hmm.
Well, that is, my lord, immediately after the incident, studies were undertaken, reports prepared. Then Herrenschnecht India Private Limited, the OEM of TBM, submitted a report wherein it had inferred that there was no fault in the TBM at the time of the incident and there was no operational mistake. Report further inferred that the probable cause of the incident was thought to be some unforeseen geological condition, unexpected high water pressure, or something else which is presently not known. Report was submitted by the claimant to the GC and the respondent under the cover of a letter. Well, that letter is referred to. Then 6.4. Shortly after the incident, a 4-member expert committee was also constituted by the respondent on 2nd September 2019. Well, this is something that appears from the report of Mr. Endicott. As would appear from the report, with Dr. John Endicott, one of the consultants of the GC, as chairman, to provide technical advice to the respondent on the matter relating to the tunnel incident issues, including technical advice on ground settlement. Well, to advise the KMRCA basically. TBM issues and recovery works, as would appear from the respondent's letter dated 20th November 2019. Said committee submitted its report on 14th December 2019, which contains chapters on the issue of resuming the tunneling work and to complete both the tunnels. The procedures which were to be followed during the tunneling work have been meticulously recommended in the said report, which includes monitoring of settlement twice a day. Most importantly, all tunneling work was to be carried out under the surveillance of the committee. It is noteworthy that the said report also did not indicate or suggest or contain any firm or specific cause of the incident or default or omission on the part of the claimant which might have caused the incident of ground settlement. Specific task was given to the expert committee by the respondent to prepare an expert report, ostensibly for submission to the High Court in a pending PIL. This is the PIL we've been talking about, yes, which would address the Honorable Court's concern about the assurance of public safety, technical issues relating to ground conditions, TBM maintenance and enhancement works, risk analysis, method statement for the remaining tunneling works, recovery, etc. Also noteworthy that Dr. John Endicott Committee report was one of the reports which was placed before the Honorable High Court at Calcutta for resuming the work of tunneling. The report heavily relied upon the report submitted by the claimant, which formed significant part of the submission to the best knowledge of the claimant. No other fact-finding committee was constituted by the respondent to ascertain the cause of the ground settlement and fix responsibility thereof. It is also noteworthy that by a letter dated such and such, requested the respondent to supply a copy of the report to the expert committee constituted by the respondent immediately after the incident of ground settlement to provide technical advice in respect of the matter relating to the said incident. Finding no response from the respondent, the claimant issued yet another reminder on 4th August 2020, once again requesting the respondent to supply a copy of the said report to the claimant.
Mr. Shah, how did the PIL end? I mean,
The
it was
PIL ends
disposed of,
ultimately with the court allowing the work to proceed.
but there was no specific direction that you would be you'd continue with that.
No, my lord, it was, my lord, submitted that, my lord, we would be the contractors because, my lord, we were not found.
Was there by an order of the court? Did they object, but still the court
My
directed?
lord, initially the court stopped all work.
Right.
And, my lord, then the court, upon being satisfied, my lord, with the Dr. John Endicott Committee constitution and the report of the committee, and at being assured by the committee that, my lord, all safety features had been.
I'm asking this because, Mr. Shah, this may hit your other point that they still continued with you.
Yes.
That might, if that was by the direction of the court.
No, it was not, my lord, by direction of court.
Not any specific direction that you have to continue.
I had not gone to court saying that I should be allowed to continue the work. It was a PIL filed by, my lord,
the court order did not in any manner prevent them from discontinuing you, and the work was to continue. That was
because, my lord, there was no attempt, my lord, to discontinue with me at any point of time.
Yes.
Then, my lord, I was reading the second paragraph of this page.
Yes.
Noteworthy that by letter dated such and such claimant requested, my lord, so we called upon them to furnish us with copies of whatever reports they had. Letter dated such and such claimant requested the respondent to supply a copy of the report of the expert committee constituted by the respondent immediately after the incident of ground settlement to provide technical advice in respect of the matter relating to the incident. Finding no response from the respondent, the claimant issued yet another reminder on 4th August 2020, once again requesting the respondent to supply a copy of the report to the claimant. Conspicuous to note, the respondent did neither supply a copy of the said report to the claimant nor made any response thereto. This necessarily implies that the cause of incident of ground settlement was only due to unforeseeable ground physical condition and not for any other reason or default on the part of the claimant. And then, well, at 6.5.
These are your allegations, could not be a part of the.
These are my causative analysis.
Yes.
Well, I am not making any allegation.
No, understand. But this is not a part of John Endicott committee, could not be.
No, this part is, my lord.
The second paragraph is yours.
Then, well, at 6.5. Pertinent to mention that writ petition was filed by, my lord, this is a PIL. And, my lord, Division Bench of the Honorable High Court praying for suitable direction and to orders to ensure safety of human lives and properties during tunneling operation. In the writ petition, respondent, apart from the report of John Endicott Committee, also submitted a report of IIT Madras for recommencing the work. Upon considering the said reports, Honorable High Court was pleased to pass an order allowing the recommencement of work. Immediately after the passing of the order of the Honorable High Court at Calcutta on 11th February 2020, respondent with its letter dated 14th February 2020 instructed the claimant to recommence the tunneling work in respect of the remaining portion of the route in both eastbound and westbound tunnels. In the said letter, the respondent specifically tasked the GC to ensure adherence to the recommendation of the expert committee and IIT report. Then, the inference, that is paragraph 6.7. This is the inference that we are drawing.
Yes, yes.
Well, following inference emerges from the facts submitted. Expert reports conclusively prove the cause of incident of ground settlement was due to unforeseeable geological condition, unexpected high water pressure, or something else which was presently not known. The properties of the soil at around the location of incident is different from that examined or envisaged earlier, or envisaged in DPR prepared by rights. There was no fault of the TBM as would be substantiated from the site inspection report duly checked and approved by GC. There was no omission or default on the part of the claimant which might have caused the incident of ground settlement. This is, the causative analysis that I, make on the basis of what I have stated. Now, so far as this is concerned, this is, dealt with in paragraphs 86 to 88 of the statement of defense. Which is in volume 37. What I say was the cause of, the accident or the incident, that is, now dealt with. In the sorry.
Where is that? Which?
Page, running page 6177, internal page 48. That is in volume 37, paragraph 86.
All right. Yes. Got it.
3 paragraphs. They have dealt with this whole thing. 86 to 88.
Yes, got it.
The third line. The report submitted by Geoconsultant India Private Limited, Mr. Charles Mann, or Subarna Jurong Consultant, Messrs. Herringschnecht India Limited, are inadmissible in evidence, and the contents thereof are incorrect. Now, pausing here for a moment. In the absence of oral evidence, it was decided by the parties that all reports relied on by all parties would be admitted into evidence. Thereafter, of course, it was for the tribunal to weigh the balance of probabilities on the basis of the reports. The first allegation is this is inadmissible in evidence. It is denied that the aforesaid reports do not indicate or suggest any failure or default or negligence or omission on the part of the claimant as alleged. Now, so far as these reports are concerned, they do not suggest any failure on the part of the claimant or the respondent for your lordship. And it is only a bare denial to this effect, no specifics. It only says it is denied that the aforesaid reports do not indicate or suggest any failure or default or negligence or omission on the part of the claimant. Then, if your lordship skips over the bare denial portion, it is denied that there was no default in the tunnel machines or there was no default in the tunnel boring machines at the time of the incident, or that there was no operational mistake, or that the probable cause of the incident was any unforeseen geological condition, or that the cause of the incident was unexpected high water pressure. After receipt of the report submitted by Geoconsultant Charles Mann, Subarna Jurong, and Herringschnecht, the engineer of the respondent issued a letter dated 11th November 2019 disclosed by the claimant, denying the contents thereof. It is denied that the report made over by Dr. John Endicott did not indicate or suggest any default or omission on the part of the claimant as alleged or at all. The respondent was under no obligation to make over the report submitted by the Dr. John Endicott to the claimant. In those circumstances, the report dated 4th August 2020 made by the claimant was incorrect, denied that the incident of ground settlement was due to unforeseen.
No, the reports were given to them.
Well, they got all our reports, but when we asked for a report of the Dr. John Endicott committee, that was not given to us.
John Endicott committee was their report.
Yes. This is report. So, contemporaneous report was not made over to us. They say respondent was under no obligation to make over the report submitted by Dr. John Endicott to the claimant. In those circumstances, the request dated 4th August 2020 made by the claimant was incorrect because they say we were under no obligation to give you the report. Denied that the incident of ground settlement was due to unforeseen ground or physical condition, or that the same was not for any reason or default on the part of the claimant as alleged. Denied that the report submitted by the alleged experts proved the cause of incident or proved the cause of ground settlement, or that the cause of ground settlement was account of unforeseeable geological condition, or that the cause of ground settlement was an account of unexpected high water pressure, or that the cause of ground settlement was something which was not known, or that the properties of the soil at or around the location was different from the property of the soil examined or envisaged earlier by rights, or that there was no default of the tunnel boring machine, or that the same would be evident from the site inspection report, or that there was no fault or default or omission on the part of the claimant, or that the claimant cannot be held liable or responsible for the incident of ground settlement, the bare denial only. And then if your lordship sees a copy of the method statement for TBM tunnel construction showing suitability of TBM is annexed here too, and marked with the letter RD19. What they say, I don't want to trouble your lordship with the report. A method statement for TBM tunnel construction showing suitability of the TBM is annexed. So, they accept that the TBM was a suitable machine. Then says denied and default. Denied that there was no fault or failure on the part of the claimant. Again, bare denial. Then please see the last 3 lines of para 86. The respondent allowed the claimant to recommence or complete the residual works of TBM2 pursuant to order of 11th February 2020 passed by the Honorable High Court. It did not direct that you get the work done by the claimant itself. It's only said you can recommence. Then 87 and 88 are the 2 other paragraphs. Denied that there was an inference or inclusion can be average. Inclusion should be arrived at. Favor of the pleading statement of claim. Lordship will see, it is really bare denial all through.
Yes, mostly.
All through just bare denial. Both paragraphs 87 and paragraph 88. 88 I shall draw your lordship's attention to. With reference to paragraph such and such of the statement of claim, that says it's denied that clause 14.1 and 14.2 of the general conditions of contract are distinguishable from 4.23 of the general conditions of contract, or there is any merit or justification, or that the incident dated August 31, 2019 occurred on account of unpredictable or unforeseeable condition, or that the incident is covered by 4.23. Matlab, that is the unforeseeable condition clause. In the present case, there has been omission and default on the part of the claimant. In those circumstances, it is evident that there has been omission and default on the part of the claimant, etc. Well, it is really my general denial. I do not want to trouble your lordship with that. If your lordship will just kindly allow me to read page 6185.
Yes.
About 10 lines from the bottom of the page.
Yes.
Well, this is their contention. Well, I shall just read from a few lines before that. Well,
yes.
The contents of the letter issued by the claimant on 22nd September 2020 are false and correct, same are denied, disputed. Clauses 14.1 and 14.2 of the general conditions of contract are applicable in view of the fact that the claimant is entirely responsible for the incident that occurred on 31st August 2019. Denied that the respondent or the engineer of the respondent has inferred any unfounded view or that there has been no omission or non-compliance on the part of the claimant. It is denied that the engineer of the respondent, myself, is not entitled to apply clauses 14.1, 14.2 of the GCC. Now, my lord, I shall just take your lordship, my lord, very quickly to 14.1 and 14.2 to show your lordship as to what, my lord, these are. That your lordship will find at page 63 of the contract. This is the risk and responsibility clause.
This is not 00295 of that.
Well, this is volume 2 GCC. Well, at page 63, clause 14.
There's a clause 14.0 in my. Sorry, I was looking at the special contract.
As part of the general conditions.
This volume, this part 2 of the contract agreement.
Yeah.
What is the bottom page? I'll just fix it through. Sorry, yes, got it.
They are relying on these two clauses. The indemnity provisions.
Mr. Shah, I'll just come back in 5 minutes.
Well, our case was that, my lord, this is something that we could not really fathom as to
Yes.
why this accident happened. And my lord, my learned friend's case is that no, it was on account of improper greasing, improper operation
Yes.
of the machine. My lord, these are the two conflicting, my lord, views on why the accident occurred.
Right.
Of course, as we find, my lord, from the records, that, my lord, there were contemporaneous reports that were filed at the time of the accident. And, my lord, although there are bare denials of, my lord, what the reports said, my lord, the reports did not ultimately indicate that there is any fault on my part. It is only, my lord, subsequently that, my lord, the reports were prepared, which my learned friends say they were not considered by the tribunal.
Yes.
Well, that is the part that I shall address your lordship on. But, my lord, what is very important is, my lord, all the reports were admitted into evidence. Now, my lord, after that, my lord, it is for the tribunal to weigh the pros and cons and decide, my lord, which report to accept, which report to, my lord, rely on, which report not to rely on. Now, my lord, in the course of things, my lord, if my learned friends say that, my lord, my reports were not considered, it will be perhaps, my lord, an incorrect way of stating things, because, my lord, they were considered but not found to be relevant and hence not taken into consideration. So, my lord, the law says that, my lord, if today vital piece of evidence is ignored, then, my lord, of course, it is ground for setting aside the award. Now, my lord, today, my lord, if vital evidence is considered but not found to be relevant or not found to be, my lord, there's sufficient material to place reliance on the report.
It is the assessment of the tribunal,
That's
which we can.
Now, my lord, that is, my lord, what has happened. My lord, I will not trouble your lordship with, my lord, that part of the award, because, my lord, Mr. Ghosh has placed those on the last occasion. And your lordship has seen that, my lord, rightly or wrongly, the tribunal has, my lord, gone through the reports and found that we don't find, my lord, any reason to rely on these reports for whatever reasons have been then, my lord, listed. Now, my lord, the question is whether that will answer, my lord, the test of, my lord, ignoring vital evidence. Evidence, my lord, considered, looked at, but not found to be, my lord, sufficiently, my lord, reliable for the reasons expressed, which may or may not be good reasons to a court of appeal. Well, that, my lord, in my respectful submission, may not be, my lord, the ground to set aside.
Unless that reason for not looking into it is so shocking to the conscience or so perverse that no reasonable man could.
No, well, not looking into it, no, it is looked into, but not, my
But
lord.
discarded on a ground. Suppose I discarded the report because the respondent has filed it, or just
No, no.
because I don't like it. That could be one of the grounds. But if the ground is shocking to the conscience, also we can look into that.
Yes, my lord. Now, my lord, if your lordship will now, my lord,
There
so
has
far
to be a nexus between the ground and the,
yes,
I mean,
my
cause.
lord, that is the nexus that I shall.
But it has to be very stark. Otherwise, we cannot.
Now, that is, my lord, what I shall try to demonstrate before your lordship. Now, my lord, so far as the, my lord, tribunal is concerned, the tribunal has not, my lord, limited itself only to the reports. It has, my lord, considered the entire facet of the matter. And, my lord, it is, my lord, upon, my lord, deliberating all the other facets of the matter, that it has now, my lord, looked into the reports and, my lord, questioned the report. Now, so far as the reports are concerned, my lord, for example, IIT Madras, my lord, the report proceeds not on a physical examination.
Mr. Shah, before going to that, should you just complete the risk and responsibility so that?
Yes, my lord. I'm sorry.
Because that
Yes,
argument would be an independent argument.
Yes, my lord. Yes. Well, that was page 63, I think.
Yes.
Yes.
Just after you complete this, then you can start with those arguments.
Yes, madam. Yes, madam. Sorry. The contractor shall indemnify and hold harmless the employer, the engineer, the designated contractors, representatives, and employees from and against all actions. It should be, I don't know what sits, proceedings, claims, damages, losses, expenses, and demands of every, should be suits, proceedings, claims, damages, losses, expenses, and demands of every nature and description by reason of any act or omission of the contractor, his representative, or his employees in the execution of the works, including professional services provided by the contractor or in guarding the same. Indemnification obligations shall include but not be limited to claims, damages, losses, damage proceedings, charges, and expenses which are attributable to sickness
So
or
you
disease or
see, it
death.
was not by reason of your act or omission, therefore this does
That's
not
it.
apply.
Now, my lord, 14.2 may be a little more relevant.
Hmm.
The contractor shall take full responsibility for the care of the works or any part thereof, including full responsibility for the care of any work being manufactured or stored off-site for inclusion in the works or in the course of transportation to the site, and for the care of the contractor's equipment, temporary works, plant, and any other material whatsoever on the site to be delivered to or placed on site in connection with other purpose. Contractor shall take this responsibility from the commencement date until the date of issue of taking over certificate, when responsibility shall pass on to the employer. If the employer engineer issues a taking over certificate for any section or part of the works, contractor shall cease to be responsible. So, Malad, this ultimately talks about the responsibility of the contractor, and Malad, the contractor's responsibility for taking due care in the course of the works. And Malad, there's 14.3, which talks about employer's risks. Malad, these are really in the nature of force majeure risks. Employer's risks or loss or damage of physical property in India and death of personal injury occurring in India for war, hostilities, revision, riots, etc., etc. And whether there are consequences of employees' risks, which are not, my lord, really important.
Act of God is omitted.
Yes. Well, that is, my lord, of course, a force majeure event in any case. And, my lord, so far as limitation of liability clause is concerned, 14.6, it says, except as otherwise provided in these conditions, neither party shall be liable to the other party for any loss of use of any works, loss of profit, loss of any contract, or any other indirect and consequential loss. Well, that is the limiting of liability clause. Now, my lord, if your lordship sees, well, so far as the site is concerned, well, I never really had an opportunity of assessing the site before undertaking the work. I was only relying on the representations made by the employer and on the basis of reasonable expectations of what to encounter underground. Well, since your lordship is on the contract provisions, may I just show your lordship two more conditions of the contract? These pertain to site data. One is at page 22 of the general conditions of contract.
Yes.
This is clause 4.9. The employer shall have made available to the contractor with the tender documents such relevant data in the employer's possession on hydrological and subsurface conditions. The accuracy or reliability of the data or the studies or reports and of any other information supplied at any time by the employer or engineer is not warranted with respect to the viability of his design and execution of the works, and the contractor shall be responsible for interpreting such data. Contractor shall conduct further investigation considered necessary by him at his own cost, and any error, discrepancies if found in the employer's data at any stage will not constitute ground for any claim for extra time and costs. So, this warranty, is not a warranty in fact, because it says you shall conduct your own study.
Yes.
And it will not constitute a ground for any claim for extra time and extra costs. So, extra cost for extra work that I'm required to do. Then, there's a deeming provision. Contractor shall be deemed to have obtained all necessary information as to risks, contingencies, other circumstances which may influence or affect the tender of the works. The contractor shall also be deemed to have inspected and examined the site in its surroundings. Kindly see, these are all deeming fictions. Shall also be deemed to have inspected and examined the site, its surroundings, the above data and other available information with respect to the viability of his design and execution of the works. And
as per 4.9e, that employer shall have made available to the contractor with the tender documents such relevant data in employer's possession on hydrological and subsurface conditions.
Yes.
So you never, took any demur at any point of time that these were not provided.
No. They were provided. These are
So this also includes hydrological and subsurface conditions.
Yes, now, so far as these data are concerned, today, I am not undertaking at the time of bid. I am not undertaking any subsurface study. Now, I have to necessarily rely on that data.
Their data.
Yes. But so far as this is concerned, this is ultimately, there is a caveat that I am giving you the data, but don't rely on my data. I am not warranting for the conclusiveness or correctness of the data.
Yes.
Now, my lord, these, my lord, have been subject matter of other cases. My lord, there are 2 American Supreme Court judgments, at least US Supreme Court, which I don't wish to trouble your lordship with. My lord, but they have said, my lord, these are, my lord, where you don't have an opportunity of undertaking an independent study at the bidding or tendering stage. My lord, these are in the nature of, my lord, warranty conditions. But, my lord, that is not to be, my lord, ultimately gone into in this proceeding at least. I had occasion to cite those, my lord, judgments in another, my lord, proceeding. So, my lord, that is how I remember them. Justice Perrin's judgment in the US Supreme Court. Now, my lord, so far as this is concerned, this is one, and my lord, the second, my lord, provision, well, it is clause 4.9. This is of the special conditions of contract. This is SCC page 6. The running page is page 73. Or is it page 79, Naki? 79. This is the SCC clause. (4.9), page 79.
Yes.
Well, side data.
Hmm.
The geotechnical and other related data provided by the employer are based on the investigation conducted by KMRCL and for reference purposes only. The tenderer should satisfy himself with the data furnished and make his own investigations if required for submitting his offer. Any change in design or construction methodology later during execution on account of the change will be borne by the contractor. Contractor shall not be relieved from any risk or obligation imposed on or undertaken by him under the contract on any such ground or on the ground that he did not or could not foresee any matter which may affect or have affected the execution of the works or compliance with his other obligations. Now, this ultimately, therefore, in 2 separate clauses, one in the GCC, one in the SCC, well, it says that these are information provided by the employer.
And make his own investigations. If
But
required.
it ultimately said, now I don't have any stage of making an investigation here. At the pre-contract stage, post-contract, I can only discover what is there as I go along the route. And it is then that the clause for act of God or any force majeure situation or an unforeseeable condition, which may also be a force majeure situation. Well, it surfaces here.
But aren't there ultrasonic methods to assess the density of the soil or whether there is water underneath? These are probably there. Well, sonar.
Well, I'm told
Engineers
that
should be able to.
I'm told that normally it is to make boreholes to understand the soil character, and that is how it is done.
So you had that opportunity, investigations.
No, so far as this is concerned, so far as boreholing into the surface is concerned, kindly also bear in mind that so far as the route is concerned, the route was being changed from time to time. Now, I shall just show you, Lordship. I should just to amplify what I'm saying. If your Lordship will kindly take up volume 41 once. Which charta কোথায় রাখলেন?
41. No, 49.
I'm sorry, volume 42.
Oh, 42.
Well, this is the GC report. 6864. Well, if your Lordship sees, page 6864.
Yes.
Well, may I read from 6863? Well, this is their report, prepared, more than 2.5 years after the incident. But, nonetheless, I show you, Lordship, what it says. 6863. Leakage and replacement of tail seal brushes prior to the incident. Were very telling. There were replacement of tail seal brushes prior to the incident. A properly functioning tail seal arrangement will prevent the ingress of water, soil, or grout into the TBM during tunneling. Prior to the incident, both TBMs experienced unusual amounts of leakage of soil, water, grout in various amounts. Tail seal brushes were replaced twice before the incident, each time having been used only for about 500 meters of tunneling. The brush seals are not designed to be replaced during tunneling, normally lasting distances in excess of 3 kilometers. Prior to the incident, during tunneling, the amount and frequency of leakage from all tail seals increased, and twice for each TBM, it was decided to stop tunneling, inspect, clean or replace brushes and replace with tail seal grease. Well, this is very important. And repack, I'm not replace. Replace brushes and repack with tail seal grease. Only the first 2 rows of brushes can be accessed when the TBM is underground. The outermost row of brushes are required to remain open as a seal and cannot be inspected for damage. Before the incident, there were stoppages to carry out this operation for TBM 1. Well, at first ring, first ring was from 22nd May 2019 to 29th May. Then 7th July 2019 to 13th July 2019. And then, my lord, third was planned after building ring number 1239 on 31st August 2019. That's the date of the accident. Now, my lord, what is very significant is they say that, my lord, tail seal brushes were replaced twice before the incident. And, my lord, the idea was to replace them and repack with tail seal grease. My lord, now, my lord, repacking with tail seal grease just before the occurrence of the event, my lord, my learners would have to say that we did not know that it was being repacked with tail seal grease, or it was insufficiently grease, or we did not know that it was being insufficient grease and we did not raise any objection or had no occasion to raise any objection. But that is not what is being said. The GC is reporting that, my lord, tail seal brushes were replaced, and, my lord, it was at the time of replacement repacked with tail seal grease. Then, my lord, after that, lordship will kindly see. So 2 stoppages, 2 replacements, third planned stoppage and replacement. There were stoppages for TBM 2 as follows. Now, my lord, this is the other, my lord, machine. First ring, my lord, there was again, my lord, replacement on 11 June 2019. Second ring, my lord, that is, my lord, prior to the incident on 5th August 2019. So, my lord, in both cases, my lord, it is happening. So, my lord, it is not as if, my lord, this is a problem that is happening only with TBM 1. My lord, this is a regular feature. You go along, you, my lord, anticipate the amount of, my lord, resistance that you encounter in the course of tunneling. Accordingly, you decide to change the tail seal.
Mr. Shah, you are arguing on change of routes.
Yes, my lord. If you lordship now see 6864, next page.
Yes.
Now, my lord, kindly see here. My lord, this is, my lord, how, my lord, ultimately, my lord, the route was changed. Kindly see, my lord, there are 2 curves. Your lordship has, my lord, the diagram at 6864. My lord, this is Esplanade at the start, and, my lord, the end is Shialda.
Yes.
Now, my lord, here, if your lordship sees, my lord, the machine has to operate through this route. It cannot, my lord, veer away from the route. Now, my lord, it has to be therefore steered through these, my lord, channels only. And, my lord, so far as
there aren't any channel. You are making the channel.
That's it. It's steered through this, my line. So, my lord, this is a route planning that I've been given.
Yes.
And, my lord, the route was changed. My lord, if your lordship sees, my lord, location, brush, yes, kindly see, my lord, here.
Brush change locations.
Brush change location 2019.
The route was never changed.
No.
The route was originally from Shialda to Central. Later on,
We don't get that from here.
from Central, it has gone to Esplanade.
This change is brush change location.
That's right. Now, my lord, the accident occurred, my lord, at this, my lord, juncture, at this curve. My lord, the second curve, 31st August 2019. This is where, my lord, the accident occurred. Now, my lord, there is some pleading of, my lord, change of the route. Well, that has been in fact noted in the arbitral award. Well, I should show you lordship from there. Well, what I am trying to, my lord, only emphasize before lordship at this juncture is that, my lord, here, my lord, there is, my lord, a risk, my lord, that is ultimately to befall on me. My lord, if today I am responsible, but if today that it is something which is beyond my, my lord, contemplation,
yes,
my lord, which would either fall, my lord, within unforeseen, my lord, situations, or, my lord, within the force majeure situation, then I am absolved of the responsibility.
Yes.
Then, my lord, the loss must lie where it falls. Now, my lord, it is in this context that, my lord, now I will request your lordship to kindly have a look at the award and see, my lord, how, my lord, the tribunal has proceeded in the matter. My lord, to, my lord, straight away, my lord, take your lordship through the relevant provisions if your lordship will kindly have a look at the award, my lord, which is at, my lord, volume 2.
এটা থেকে মার্ক করে যাচ্ছে হ্যাঁ
Of the petition. Of the petition.
এটাতেও আছে yes very well Mr. Shah, if you can refer to the internal pages, that would
Yes, my lord. This is internal page
I have the
15.
award separately also. Page 15.
15.
Yes.
Lordship will find claimant's case in brief.
Yes.
Now, my lord, I will not trouble your lordship with the initial paragraphs. Then please see, my lord, straight away, paragraph 32. My lord, your lordship was asking me about the route change. My lord, I could not immediately remember.
Yes.
My lord, this
Yes.
is the let paragraph 31. The claimant further stated that the UG project was neither homogeneous nor uniform in nature. Every succeeding stage in construction process was dependent on completion of the preceding stage. Any departure from timeline of completion upset the schedule activity, etc. Then second paragraph, 32. However, the respondent did not make available the work front, decided to be implemented, realigned route in line with the construction sequences approved. For commencing construction of the work for both sectors, that is from Subhash Sarovar to Shialda, phase 1 and Shialda to Central phase 2. However, the respondent was facing problems in implementing the underground metro along Bibi Ganguly Street between Mahakaran Metro Station to Shialda due to existence of high-rise buildings, heavy traffic, road blockage issues, besides non-availability of land required for Mahakaran and Central Station. Thus, the respondent, in view of above difficulties as well as based on the DPR prepared by RITES for proposed realignment of route for phase 2 on 30th July 2014. Detailed investigations were carried out by RITES during February 2015, which included field investigations for the guidance of the claimant, and the claimant was required to do their own self-investigation in the course of execution of design-build contract. The DPR prepared by RITES Limited was made over to the claimant by the respondent by a letter dated such and such. The major proposal being modification of original route of 1.25 kilometers under Bibi Ganguly Street to a route of 2.49 kilometers. Besides, this revised route, instead of going to Central Station, was now proposed up to Esplanade Station. On 25th August 2015, the respondent instructed the claimant to take action on the change in the employer's requirements as above and requested the claimant on 2nd December 2015 to submit its technical and financial proposal for the altered route. The claimant observed that the route was passing through dense and dilapidated old buildings. The claimant also specifically observed in the DPR that condition of all the 223 buildings and structures lying within 25 meters beyond the realigned route were highly dilapidated condition and were very high risk to high risk category. Well, this is, my lord, with regard to the change of route. And then, my lord, if your lordship now sees, my lord, paragraph 37, my lord, this is how the machining or the boring proceeded. The work of tunneling for this phase was commenced from Esplanade side using two separate tunnel boring. Well, just pausing here for a moment. Well, when there's route change and well, there's realignment, well, the question is, well, today, do I have well, independent right to well, carry on underground boring activities well, for these routes? Well, please also well, bear in mind that well, these are very highly densely populated areas. And well, that is why well, there was a realignment of the route. The work of tunneling for this phase was commenced from Esplanade side using two separate tunnel boring machines on and from 25th January 2019 and 18th February 2019 respectively. The TBMs were declared fit for operation by the OEM based on the site acceptance test on 28 July 2018, and GC also issued the go-ahead mandate for commencing the operation in terms of serial 12 at page 0051 of volume 3 of the contract agreement. So, my lord, all these, my lord, ultimately tunnel boring proceeded with the concurrence of the
They have
GC.
shown nothing to indicate that, to substantiate that before 31st of August, any point was raised by the GC or from their end regarding any irregularity on your part regarding non-greasing, change of brush, or anything of that sort.
Well, to the best of my knowledge, no, but I shall not just, my lord.
Probably till now I've not
No,
found
my lord,
anything
there
of
is
that.
nothing. My lord, to the extent that I have, my lord, been able to identify
Only
from the
post
papers,
facto the accident, these things are.
that's right. That's right.
Hmm.
The TBMs were declared fit for operation by the OEM base, my lord, that is, my lord, by the original manufacturer,
Yes.
and the GC issued the go-ahead mandate. Both TBMs were running parallelly on the realigned route, having a gap of around 300 meters, and have been perfectly operating since commencement. Till 31st August 2019, the tunneling work has been absolutely uneventful. The claimant also asserted that as per the instructions of the respondent, the claimant also arranged evacuation of the buildings above the tunnel route and kept the residents in nearby hotels as preventive measures until such time the TBM passed through the areas. My lord, kindly note this. My lord, these were, my lord, anticipated risks, and to, my lord, provide for these risks, they were shifted. The residents were safely rehabilitated to the respective houses after completion of tunneling operations in the respective areas. The tunneling work in both tracks has been progressing smoothly until the evening of 31st August 2019, except for minor leakages on 20th August 2019 and 23rd August 2019, which was also witnessed by the GC and the respondent. And the claimant was given clearances for advancement of further tunneling in each case. Till that time, previous drives from Subhash Sarovar to Shialda had been successfully completed by the claimant. The claimant also submitted condition survey of around 663 numbers buildings to the GC. As per the claimant, the condition survey considered 83 buildings as severe and very severe category. Also, many buildings were already declared condemned by the Kolkata Municipal Corporation. As per the claimant, based on the joint inspection with the GC, the tailskin brushes of the TBM were replaced twice on 29th May 2019 and 12th July 2019. The GC in its letter dated 28th August 2019 indicated non-availability of spare brush. But actual fact was the location of TBM on 28th August 2019 was not safe for maintenance, and the claimant was instructed to adopt required measures and continue till the best stoppage was reached. For repair is reached. The location for stoppage of TBM1 for change of tailskin brush was jointly decided by the claimant and GC for inspection of the brushes, which was to be done only once the TBM reached the predetermined spot where it will be a safe to stop the TBM for required inspection. GC was unsure of any difference in subsoil and site condition of two locations of TBM1 on 28th August 2019 and 31st August 2019, thereby implying that TBM1 location on 28th August 2019 could have been more unsafe than the zone of TBM1 location on 31st August 2019. Thereafter, your Lordship will kindly see paragraph 40. Respondent contends that the TBMs were required to contain adequate provisions for safety of the workmen and application of safe methods of tunneling. They were also required to be fitted with adequate tail seal arrangement to prevent the ingress of groundwater or soil and or grout along the shield traveling in the TBM. However, on 31st August 2019, the TBM reached the predetermined location to carry out maintenance. At about 6 p.m. on the set date, the westbound tunnel in Bobazar area encountered huge inflow of water mixed with mud and soil inside the TBM1, causing severe ground settlement in the area and further resulting damage to the buildings above the location of the incident.
So you had reached that predetermined location where it was scheduled to be.
Yes.
The brush change was
My
scheduled.
lord, we had stopped for the change of the brush.
Right.
But my lord, at that point of time, my lord, huge body of water was
This occurred.
encountered, and my lord, this caused the incident. Now, my lord, important, my lord, what the tribunal notices, what the respondent admits, or the petitioner of your lordship admits, is, my lord, change of tail seal brush with, my lord, stacking of greasing at that relevant point. And my lord, the entire allegation now is that, my lord, there was insufficient greasing because, my lord, the condition or quality of tail seal brushes has not been faulted. And it is the same tail seal brushes that were being used earlier, used subsequent, my lord, to the accident, and, my lord, using the TBM2.
So actually, if you see from from another perspective, I mean, the accident occurred when you were not while you were boarding, but you had stopped at the predetermined, at least reached the location where it was determined jointly that a change would occur.
Yes, yes. And my lord, it had stopped for the purpose of the change.
Of the change.
Now, my lord, one of the allegations is, my lord, we did not have adequate stock of steel.
Yes, that was also.
But my lord, with the greatest of respect, my lord, when it stopped on the two previous locations, brushes were changed. My lord, when, my lord, it has determined this predetermined location, my lord, for change on that date. My lord, today it is not said that, my lord, we could not carry out the change because of absence or lack of, my lord, brushes, and that is why, my lord, the machine, my lord, ultimately subsided.
What is there to substantiate their allegation? What is there against you on that count that something was argued by Mr. Chaudhary, something was to arrive?
My lord, there were some stocks, my lord, that we had ordered that way to arrive, but that does not mean that we did not have stocks to carry out the change at the predetermined location.
Okay.
And my lord, that is really not, my lord, ultimately the my lord, declared cause.
One of the allegations.
Well, it is only an incidental, my lord, allegation. It is not, my lord, the main allegation. At least, my lord, that is not the allegation that was before the tribunal. Now, my lord, the tribunal is now, my lord, going into the question as to, my lord, whether, my lord, this could be the cause of the incident. My lord, now, my lord, we dehorse or shown off all the reports. Independently on the fact situation available before the tribunal, it is making an analysis of, my lord, the situation. My lord, the paragraph 40, I'm sorry, paragraph 41. However, my lord, paragraph 40 says, my lord, it was stopped for, my lord, the change of brush.
Yes, yes.
41. However, on 31st August 2019, when the TBM reached the predetermined stoppage location to carry out the maintenance, at about 6 p.m. on the said date, westbound tunnel in Bobazar area encountered huge inflow of water mixed with mud and soil inside TBM 1, causing severe ground settlement in the area, further resulting in damage to the buildings above the location of the incident. Residents were shifted to nearby hotels by the claimant with help of local administration. Shortly after the incident, few buildings above the tunnel collapsed. Few other buildings developed damage due to subsidence of ground. Ground settlement continued for over 10 days. Finally, the same dropped to zero. In the aftermath of the tunnel water ingress incident on 31st August, Calcutta High Court, my lord, took out the directive that work would not commence without leave of court. Shortly thereafter, after the incident of ground settlement, respondent took decision to pay 5 lakhs to each person or family affected by such ground settlement. Decision was also taken by the respondent to pay 50,000 to 5 lakhs to each shop owner affected by the incident. Total sum disbursed by the respondent was 12 crore 73 lakhs. Respondent also informed the claimant with its letter dated 7th September 2019 that as per clause 15.3 of the contract agreement provides for insurance liabilities to third parties for loss, damages, death or bodily injury, which necessarily implies that such amount will be realized from the insurance company. This amount of 12.76 crores was recovered by the respondent subsequently from the TPL policy, where the respondent was also a joint beneficiary and the same was being renewed from time to time. Meanwhile, claimant also undertook the causative analysis of the incident and engaged 4 experts for ascertaining the cause of the incident of ground settlement. The claimant asserts that none of the said reports even remotely suggested any failure, default, negligence, or any other variety of omission on the part of the claimant. Dr. Florian Kren of Geoconsultant clearly inferred in his final report that the properties of soil at and around the location of this incident is different from that examined or envisaged earlier. And this is where the change in route, my lord, comes in, my lord, becomes of relevance. Mr. Charles Mann, an independent assessor of TBM expert, inferred that there was nothing to disprove the conclusion that the TBM hit a large water body that was unexpected and unforeseen during the TBM excavation. Subarna Jurong Consultants Private Limited, tunnel design and drawing consultant.
Up to 47, Mr. Shah, you have already read the list of the reports. That's right. 48 may be important because it was their contemporaneous report.
That's it. That's
in the
it.
court, which also did not attribute any fault to you.
That's it. Shortly after the incident, 4-member expert committee was constituted by the respondent on 22nd September 2019. Well, this is the Dr. John Endicott.
Yes, yes.
With Dr. John Endicott as chairman to provide technical advice to the respondent on the matter relating tunnel incident issues, including technical advice on ground settlement, TBM issues and recovery of works, etc. Committee submitted its report on 14 December 2019. However, this report also did not indicate or suggest or contain any firm or specific cause of the incident or default or omission on the part of the claimant. This report was also placed with the Honorable High Court for necessary clearance for resuming the work of balance tunneling. The claimant stated that to the best of his knowledge, no other fact-finding committee was constituted by the respondent to ascertain the cause of ground settlement or fixed responsibility thereof. Well, just pausing here for a moment. Well, had in this report any fault been attributed to the claimant, well, in that case, certainly the work would not have been allowed to be continued by the claimant. And then, it records, however, as per the claimant, a request to the respondent to supply a copy of the report was made on 11th June and on 4th August, which remained unanswered. The respondent, apart from the report of Dr. John Endicott, also submitted a report of IIT Madras to the Honorable Calcutta High Court for recommencing the work. Honorable High Court was pleased to pass an order on 11th February 2020 allowing recommencement of work. Based on this, the respondent, via its letter dated 14th February 2000, instructed the claimant to recommence the tunneling work and specifically tasked the GC to ensure adherence to the recommendation of the expert committee as well as IIT report religiously on 24/7 basis over and above the already established protocol for supervision by GC and not allow any type of ad hoc measures. Pursuant to instructions of respondent via its letter dated 14th February 2020, claimant recommenced the tunneling work for eastbound tunnel using the same specifications after modifications with additional safeguards, measures, etc. So, same specifications, then only with additional safeguards. And the same has since been completed on or about 7th October 2020 without any incident, except for soil ingress at 1 or 2 locations. May I just pause here for a moment? So, the work using the same machines, with the same tail seal brushes, with the same greasing, only with a few additional safety features added at the request of the expert committee. Work is allowed to be proceeded with and completed. The westbound tunnel where the incident of water ingress happened was recommended from the opposite side, that is from Shialda to Bobazar, using TBM of the completed tunnel. Also, reasonable expectation of the claimant that TBM since stuck in the affected tunnel would be retrieved back through the recovery shaft as suggested by the expert committee of the respondent. Claimant pleads that the incident of ingress of water in the tunnel and ground settlement had occurred as a result of unforeseeable physical condition, as for which the claimant cannot and should not be held responsible for and be made liable to consequences arising from the incident in any manner whatsoever. As per the provisions of the contract, GCC clause 4.23, the claimant is entitled to and the respondent is liable to pay all additional costs and expenses incurred and are being incurred by the claimant arising from the incident. Here, this is the basis of our claim. But most of the claims, except for what was the directly paid by us to the residents of the settlements, that is what was allowed. Claimant also expressed apprehension of repudiation of insurance claims in the event of random and baseless allegations of the GC or the respondent against the claimant with regard to the cause of accident. Now, this is the claimant's case. Then, the respondent's case, your lordship will see. That's from paragraph 56. I will request your lordship to, have a look at paragraph 63 onwards.
Yes.
The entire site and location for design and construction of underground section from Central Station to Subhash Sarovar was made over by the respondent to the claimant. The TBMs deployed by the claimant were required to possess backup equipment, spares and consumables, etc. to complete the said work within the time specified. TBMs were also required to be fitted with adequate tail seal arrangements to prevent the ingress of groundwater or soil and or grout along the shield traveling in the TBM. Thus, the claimant was obliged to provide a tunnel boring machine which could overcome ground conditions. The TBM was required to be designed to prevent ingress of groundwater. The respondent further stated that for the water to enter into the TBM, the groundwater must be higher than the water resistance of the seal. The deepest point in the alignment being 25 meters, the water resistance of the seal of the TBM should have been 37.50 meters. Thus, the TBM deployed by the claimant could withstand a pressure of 37.50 meters. On and from August 29, 2019 onward, it was becoming evident that there was influx of... these are exactly what has been stated in the statement of defense. I don't want to trouble your lordship with that. Then I straight away request your lordship to come to paragraph 68. Respondent further states the engineer of the respondent had carried out an analysis of the grease consumption record supplied by the claimant from the commencement of tunneling ring 1 to the point of tunnel incident ring 1239. Detailed analysis is shown in the appendix 2 of the tailskin brush seal greasing investigation report prepared by the engineer based on data supplied by OEM. The report shows that the claimant has been consistently pumping insufficient volume of grease into the grease chamber and had not rectified the mistakes even after previous brush seal changes. Now, my lord, pausing here for a moment. No, my lord, mistake was pointed out. So there was no cause for any rectification. And my lord, the reports were made available contemporaneously. And my lord, no fault was found with, my lord, the stacking of the grease. On the contrary, at the time of the two, my lord's change of tail seal brushes in August 2019, it was found that, my lord, they were also adequately stacked with grease. And that is, my lord, the report that I was showing you, Lordship, the GC report. 69, the respondent has brought in two contradictions in their statement. My lord, this is, my lord, important. Respondent has brought in two contradictions to their statement, stating first that there was a deficiency of as much as 73% of grease volume, giving indication that the claimant has been consistently pumping insufficient quantity of grease into the grease chamber, while on the other hand, the respondent has stated that average volume used over the length of tunnel was 97% of the required amount. Well, this I have shown you, Lordship. This has been interpreted by the respondent as large volume of grease pumped by the claimant in an attempt to prevent leakages after the brushes were damaged. This resulted in filling the voids behind the TBM with grease instead of grout, further impacting the problems. Thus, once the groundwater entered the TBM, the groundwater could easily push the grease out in void and increase the open path. Well, just again, reflecting on what I have already stated. Well, they say first that there is undergreasing, and then they says overgreasing to prevent leakages after tail seal brushes were damaged. Well, there was no occasion for tail seal brushes to be damaged because there were two changes, well, just before the incident. Third change is scheduled. So, my lord, pumping in, my lord, excess amount of, my lord, grease to prevent, my lord, leakages, that could not have been the case. Thus, the respondent further stated that it is well known that tunneling is a high-risk activity. Prior to commencing a tunnel drive, a risk assessment is required to be prepared for assessing the risk, assign an order of severity and consequences in order to plan the mitigation measures. The claimant on 18th May 2018 submitted a method statement. In the case of risk assessment for tunnel construction, the claimant did not indicate any cause but only included control measures and further control measures. Thus, mitigating the causes has significantly compromised the assessment. Well, considering the risk assessment with respect to the failure that occurred, water and soil ingress through all the tail seal brushes, the same was not assessed by the claimant. The claimant was also ill-equipped to control the leaks or excessive settlement after the uncontrolled leak. Before the tunnel incident, the contractor had replaced the brushes twice and was preparing for a third replacement. TBM is not designed to have brush seal replacement whilst on ground. Such frequent replacements are extremely unusual in TBM tunneling. As an experienced contractor executing a design-build contract, it was incumbent on the part of the claimant to carry out thorough investigation regarding change of brushes. Claimant is entirely responsible for ground settlement, which has resulted in void loss. My lord, here, my lord, up to now, my lord, your lordship has seen that there is, my lord, repeated inconsistencies in the stand. My lord, one is, my lord, they say that, my lord, tail seal brushes are required to be changed. My lord, this is a safety feature. My lord, two changes are occasioned under the inspection of, my lord, the committee. No, my lord, disputes raised. Nothing said why are the tail seal brushes being required to be changed so frequently. My lord, not the case. My lord, third change is scheduled because, my lord, they consider it necessary because we are passing through a very high risk zone. And, my lord, the stand that is now taken is tail seal brushes should not have to be changed so frequently. Then, my lord, the stand taken is that there is insufficient greasing and there is excessive greasing. Well, these, my lord, have to be reconciled at some point of time. They have to, my lord, the twain shall meet at some point of time. Then the respondent decided to form, my lord, this is where we come in here. The respondent decided to form and engage an expert committee following the mishap and take an opinion. This is, my
The
lord.
twain may not meet in the Kipling, but has to meet in the coupling at least. Coupling of the railway coaches. So then Dr. John Endicott comes in again.
After Asimov and Kipling, we now with
No, now we are traveling.
this is the John Endicott Committee, and then Mallard
Yes.
says, upon the opinion, such opinion was obtained by the respondent from an expert committee headed by Dr. Don Endicott, Hong Kong-based, renowned, etc. Upon consideration of the report, the permission of the Honorable Court, Mallard, then that is received. And then Mallard 73, further structural stability report was obtained by the claimant. 23 number of structures were to be completely demolished. This has been done by the claimant. Out of remaining 73 buildings evacuated, 27 were later found to be unaffected, and 23 number of structures had to be repaired. This is in progress. Mallard, this was to be done with the concurrence of Mallard, the respondent. Now, Mallard, the issues, Mallard, that were raised by the respondent, that is at page 75. Mallard, these are Mallard technical issues.
Need not.
No.
You can come to the decision portion also.
Yes,
subject to. If you have anything to say, you can.
Mallard,
Because-
assessment of the arbitrator starts at paragraph 77. Now, Mallard, explained by the claimant, Mallard, I don't think, Mallard, I need to take your lordship there at all.
No.
Then, Mallard, if your lordship sees, Mallard, the discussion on GC. Mallard, that is at page 243 or 242, I'm sorry.
Give the internal pages, please, sir.
Mallard, internal page is, Mallard,
Bottom.
32.
That is page
Mallard, internal page
30.
32.
32, right? Yes.
Mallard, here your lordship will find, Mallard, this is, Mallard, the claimant's, Mallard, the composition of the GC at paragraph E. Myself, comprising of 5 globally reputed engineering consultants, was appointed by the respondent as general consultant. GC in short. The duties and responsibilities and authorities of GC were expressly provided in the CA. The constitution of GC is under. Mallard, I will not trouble your lordship with that. Then F. Duties and functions of the engineer are specified in the GCC clause 2, read with subclause.
This you placed also, Mr.
I have placed.
Shah. Yes.
Yes. Now, Mallard, then Mallard G. As per the contract, the claimant is obliged under the contract to follow the employer's instructions. Mallard, these are also, Mallard, matters which I have placed to your lordship.
Yes.
Then, Mallard, so far as the alternate route is concerned, this is the deliberation. Mallard, please see, Mallard, internal page 34. N, clause N.
Before
Claimant
that, L is also in your favor, that it is thus clearly evident that best and seasoned brains available globally and expert engineers were entrusted.
That's it.
Because he ultimately believes those reports.
Yes.
This may be Germany. Then
Yes.
page 34, yes.
And then, Mallard, I'll skip over, Mallard. Well, there's a change in route, Mallard, that is ultimately reflected on. Mallard, paragraph N. Respondent has been exploring change of route. Mallard, this talks about the change of route. Then paragraph 79. Mallard, this is the alternate route. Mallard, that also I have, Mallard, placed before your lordship. So, Mallard, the route was changed. I'll just read it, Mallard, short paragraph. Instructed the claimant to take action on the change in the employer's requirement, detention, introduce deletion of the existing alignment. Deletion of the existing alignment of route from Shialda Central, and in its place, introduce a new route for East-West Metro from Shialda to existing Esplanade Metro Station in place of Shialda to Central. So, Mallard, this is the change in route. Then, Mallard, here, if your lordship will now have a look at paragraph 84. Mallard, this is with regard to the tunneling operation that is carried on. But I have spoken about this earlier.
Yes.
Then, Mallard, the background of the matter, as explained, your lordship will find from paragraph 92. Mallard, again, this is, Mallard, something that should not immediately, Mallard, trouble your lordship.
Exactly, yes.
The tribunal's assessment, Mallard, at paragraph 93.
Right.
Now, Mallard, so far as tribunal's assessment is concerned, Mallard, first assessment, Mallard, with regard to the GC and, Mallard, the ground settlement, etc. Mallard, may I just read this part? I think it's important. Mallard, paragraph 93B is, Mallard, the constitution of the GCC. Then, my lord, site could not be made available immediately. That's paragraph D. Then, my lord, paragraph E is important. There can be no doubt that the work of tunneling is also one of the most dangerous occupations, including more occupational fatalities than any other organized industrial sector. Accordingly, the claimant was also required to engage qualified and experienced engineers and support staff. Initial underground route of UG Package 2 was all along beneath the roads. However, as per revised DPR submitted by RITES, the proposed alignment of the route for Phase 2 from Shialda to existing Esplanade Station was proposed through densely populated habitat with several buildings aged about an average of 100 years or so. This further compounded the criticalities involved with the design and execution of work. Thus, the original route from Shialda Station to Central Station, which was a length of 1.25 kilometers underneath Bibi Ganguly Street, was revised to Shialda Station to Esplanade Station of length of 2.49 kilometers under densely populated buildings. As per DPR, this is handed over. I don't want to trouble your lordships. Well, then these are buildings in very high risk and high risk category. Then J. Thus, it cannot be said that the respondent, upon due consideration to all the findings and observations of the DPR prepared by RITES, did not take a calculated risk and reposed full faith in the technical capabilities of the claimant and supervising GC engineer in keeping with the probable consequences as categorically cautioned in the DPR. Well, they were proceeding with caution. And then, my lord, we are talking about the incident of ground settlement, which your lordship will find from paragraph 94 onwards.
Yes. Your respective views and rejoinder.
My lord, what happened, my lord, as an aftermath of the incidents? Then, my lord, 3 independent expert reports submitted. That, my lord, your lordship will find. My lord, High Court and everything else. Clause paragraph E, 94E. That is at page 45. Well, this is the reports that the claimant obtained from 3 independent experts that I've already told your lordship.
Yes.
Then, my lord, the respondents' views are from paragraph 95 onwards. Well, these are the same views that have been expressed earlier, so I will not waste your lordship's time. Then the claimant's rejoinder, well, is at paragraph 96 on. So, my lord, the entire, what I'm trying to show to your lordship is all the views are discussed.
All the reports also in a nutshell.
That's it. Well, since Mr. Ghosh has placed these, I don't want to trouble your lordship.
And you also assured that to save time on
Yes,
these,
I will not.
you would be pointing out the gist of this which you
Yes,
did. So the report gist, how does the arbitrator proceed about it?
Yes, now, my lord, if your lordship will kindly have a look at 97.
No, that is the start of all the reports being discussed.
Yes. I do not want
No.
I do not want to take your lordship through that.
I don't want to get under that tunnel.
No.
Tunnel.
No, my lord, I do not want to. My lord. Now, my lord, all that I'm trying to say.
Internal page 77 assessment. Sorry, you are saying something.
No, well, these are, my lord, brief discussions with regard to the reports.
Yes.
So,
Brief.
my lord, all the reports are, my lord,
These
now
are discussion, not a brief discussion.
discussion. Now, my lord, here, my lord, each of the reports have been, my lord, taken up for consideration.
Yes.
And, my lord, each of the reports have been, my lord, discussed in some detail.
Now,
my lord, the first part of the reports, my lord, up to, my lord, paragraph 103, your lord will find the reports of, my lord, the claimants, my lord, consultants.
After that, there.
Then, my lord, very important, my lord, there's a note on, my lord, the dispersiveness soil at the shaft by GeoConsult. My lord, this is
This
important.
was by whom?
104.
No, this was you produced this.
Yes, my lord. Yes. Yes, my lord. I'll not, my lord, read the report, only kindly see the heading.
Yes.
Ultimately, the report concluded that, my lord, the nature of soil was very dispersive. My lord, nature of soil accounts for a lot, my lord, in, my lord, subsoil or, my lord.
Yes, absolutely.
So, my lord, that is important. Now, then, my lord, kindly see, there's a survey report done by the original equipment manufacturer, that is Herenschnett, that is paragraph 105. My lord, again, I will not place it. Then, my lord, the 2019 report of Dr. John Endicott. My lord, this was, my lord, important because this did not, at the relevant point of time, which was, my lord, more contemporaneous.
Cast any aspersion on you.
Yes, that's right. Now, my lord, after that, my lord, this is discussed at some detail. Then, my lord, we have, my lord, the 2020 report by IT Madras.
Their reports start from this.
Yes, well, Now, my lord, their report, these are their initial reports at the time of the incident.
Acha. Yes, they did.
Not, my lord, post-excavation.
But 1 year after.
1 year after.
Not 1 year, 4 months, 5 months after.
Yes, my lord. My lord, then the IIT Madras Review Expert Committee report. My lord, this was, of course, on the proposal to resume tunneling. That is the heading at 107.
Yes, right.
Now, my lord, one thing I'll place from this, my lord, if your lordship will kindly see, just, my lord, paragraph B, 107B.
Yes.
My lord, IIT Madras report, my lord, this is the 6th line from the top of page, my lord, from the top of
70.
paragraph B.
Yes.
My lord, IIT Madras report stated that it is clear that there is a stratum with significant non-plastic fine /silt/clay sand in the soil fraction in the soil around the tunnel depth. And then, my lord, paragraph C. The study of the report revealed certain additional works of pressure grouting, dam grouting work to improve stiffness of soil strength. So, my lord, the soil strength was being, my lord, sought to be improved. To, my lord, as a condition for resuming the work. The IIT Madras team reviewed the proposal and approved the proposal of pressure grouting work, dam grouting being undertaken to improve soil strength and stiffness in the Bobazar area above and below affected the TBM with increased monitoring and agreed to the proposal of resuming TBM2 with additional precautions like new tail seal brushes, additional grease supply lines, cover plates for tail skin gap, additional grout holes, bullflex, emergency, etc. Now, my lord, just pause here for a moment. But it is not said that, my lord, the old, my lord, system was, my lord, incompetent. It is just saying that we want to introduce new additional safety features. So, my lord, what it says, to improve soil strength is one, then additional precautions like new tail seal brushes, additional grease supply lines, cover plates for tail seal gap, additional grout holes, bullflex seals for emergency. These are all additional items, my lord, which were not a part of the original contract. And, my lord, these were only additional safety features. Then, please see 108. This is the 2022 report.
Yes.
Now, my lord, these are the reports. These are the reports that were relied on by the petitioner. My lord, here the first report is of IEST Shibpur. My lord, IEST Shibpur, my lord, here, please see, my lord, this is a discussion on the report. So, my lord, it is not as if the reports are not considered. What the reports, my lord, proceed to say is first, my lord, discussed. My lord, kindly just allow me to, my lord, place a few portions from here. 108A, the report pertains to analysis of soil samples and review of pre and post incidental geotechnical investigation reports. Disturbed samples were given by KMRCL to IIST Shibpur. Disclosed objective of the report was to analyze the soil samples given on 7th December 2021 to IEST to review the existing pre and post incident soil reports, comparison and development of soil stratification in the retrieval shaft location, with an objective to reveal the parameters to be used for further analysis. Now, my lord, that is an analysis that is done. And then E, the consultant has concluded that it is revealed from all the exploration reports combinedly that the soils available at the tunnel alignment level are predominantly sandy, silt, and very low plasticity to non-plastic nature. Consultant, then F, consultant also opined that there is no major variation in soil properties between those reports at various stages and the present samples collected from TBM cutter head and tail seal locations. Well, lord, pausing here for a moment, well, lord, now, my lord, your lordship has seen that there is a root variation also. Now, my lord, soil samples are collected. Well, lord, today, well, lord, the dispersive nature of the soil is something that is commented upon by the John Endicott report, by, my lord, the geoconsultant report, and, my lord, now they also say, but they say that it is not different from what was there before. Now, my lord, here, the question is, my lord, at this point of time, my lord, what is the evidentiary value to be attached to this to find out as to, my lord, as to whether the fault was ultimately with the tail seal or, my lord, with the nature of soil or with, my lord, influx or inflow of water at very high pressures or, my lord, large volumes of water. Now, my lord, then please see, my lord, how it's dealt with. However, as per the written notes of arguments of the respondent, has made a statement against the counterclaim number 4 that the respondent, for the purpose of defending the claims made by the claimant and for effective adjudication of the arbitral reference required assistance from Dr. John Endicott, Dr. N.K. Pichumani, and Guy Bridges. Apart from independent experts, the respondent has also appointed institutional experts for reports and views in order to defend the claims made by the claimant in the present arbitral reference. This report is one such listed report as per the statement of the respondent. Thus, it is not an independent report and prepared subsequent to the commencement of the case for the sole purpose of defending the case. This raises doubts about the intent and evidentiary value of the report.
This is not such a sound ground.
Well, it may not be.
Just because they have said that this has been prepared, experts have been appointed, experts gave the report to defend their claims, obviously to defend their claims.
No,
Does not mean that automatically.
there is, of course, one thing. So far as the nature of soil is concerned, it could have been done immediately, contemporaneously. For that, you did not have to excavate the TBM. Now, so far as this is concerned, this is a study that is undertaken after 2 years. And this is a study that is undertaken by IAST, who compares some soil samples to come to one conclusion. Let us forget about what the tribunal said. They say that we find that the soil is, this is what it says, that the soil is
sandy and silty and
yes,
plasticity, low plasticity.
Yes, predominantly sandy silt with very low plasticity to non-plastic nature. Which is really commenting on the dispersive nature of the soil. But they say that we don't find that it was very much different from what it was before, without reflecting on the fact that there was a change in route. And in any event, the question is ultimately, there were two incidents, that two impactful events, I would say. One is there was definitely a huge inflow of water, which had nothing to do with the nature of the soil per se. But it was because combined with that, because it was of the dispersive nature of the soil, that ultimately this led to the sinking of the TBM and consequently the caving of the overground. Now, here, of course, that the report is discussed. The ingredients of the report are highlighted. But it is said that we don't find...
There is an assessment of that only on the ground that this has been prepared for the sole purpose of defending the case.
That, your lordship may look at it very differently. As a court of appeal, of course, your lordship. But the question is it ignoring vital evidence? One is no evidence at all. And two is ignoring vital evidence. Now, your lordships will see what would be the impact of this report. The report says that we have investigated the soil character, found that the soil character is dispersive, but find that it is more or less in tandem with what was there previously. Of course, what we also have on record is the fact that there was a change in alignment also. And
a change in alignment is not important because it is compared with the previous reports at various stages. So this sticks to the previous reports obtained for the alignment route on which you worked.
What is there?
Change of alignment is
what
not.
Is there, is the dispersive nature of the soil. That is on record.
Yes.
It may be the same character of the soil that was previously also discovered in the course of investigation. That is one part of it. The second part of it, of course, this coupled with the huge inflow of water, which was not expected or which was not precedented.
That is always there.
Now, so far as this is concerned, the question is, therefore, how would it ultimately result in perversity to the extent of affecting the decision of the tribunal, which tribunal with competence or with independent character could have reached it, because it is something that no person of reasonable prudence could have arrived at this conclusion. So this does not ultimately reflect on anything. It is only confined to soil character. Now, the next report is the IIT Madras report, paragraph 109.
Yes. Today, after recess, I have appellate side, so we'll continue.
My difficulty is
next 2 weeks.
Next week I'm not in Calcutta.
Next week Friday is a holiday.
Yes,
holiday also.
Yes, the next week I'm in difficulty, as I indicated in the 4th April.
We'll keep it on 28th then, if you don't have any difficulty. 28th.
28th, I'll be very candid. I have a visa appointment, which I have to go for. I can't miss. My daughter now, stays abroad, so it's important.
Hard in part. on the prayer of learned senior counsel appearing for the respondent, comma, the matter is adjourned till April 4th,
I'm
2025
very grateful.
for further hearing.
Very, very grateful, my lord. Very grateful.
Sorry, Mr. Bachawat, nothing could be done.
My fault. My fault.
Not your
entirely.
fault at all.
My
But
fault.
I could not reach it. I indicated to you, Leonard Junior, that I might not reach
Something
it.
I did something stupid. I put in eye drops outside before coming in, and I lost that time. Just that much. And I told them to start.
Yes, exactly. Yeah. Anyway,
Sign of distinct aging, my lord.
Yes, yes, definitely. Definitely.
I haven't heard anything.
Definitely.
এটা একটু stable করে সংগ্রহ। We'll continue with, we'll take up the appellate side matters after recess. So you need not keep waiting. I mean, Call on the list.
My lord. Sorry, you are not mentioning.
No, I'm not mentioning.
Mention.
My lord, I'm seeking permission to inspect the file of item number 2 in original side.
I just said when the officers are there only then I can.
Unless I get the permission from your lordship, the officers, they are not allowing me to see the file.
Tell them I've given permission.
My lord, I have get
Yes.
with your lordship.
Call.
Item number 1.
Lord, in this matter for the petitioner,
Yes.
was it query that what is happening in the division bench. Honorable division bench was pleased to dispose of the appeal with the view that since the out of 99 petitioners, the maximum.
What is this
98
application for?
my lord,
Well, this is the main writ petition from appeal from an interim order holding that the writ petition is maintainable.
Oh.
We preferred an appeal, and the main was kept pending.
Oh, this was that matter.
that
Housing, yes.
now what has happened out of 99, 98, they have been given the flats. Now, in view of that, the Honorable Division Bench held that in the view of that, the issue is issue regarding the maintainability of the petition is academic. And therefore, the Honorable Division Bench has kept the issue left and also disposed of the writ petition saying that the rest of the part, that is the monetary compensation, that in view of the Honorable Division Bench, that monetary compensation may not be considered by the
Writ court.
writ court.
Right.
That is the, in the view of that, it has been disposed of.
So nothing remains in the writ.
Yes, my
Well,
lord, the
nothing
writ
is
petition has been disposed of by the Honorable Appeal Court. In view of that, my lord, your lordship will, it's disposed of.
What is the order of the?
My lord, this is the order.
And that has been
On,
subsequently modified.
Yes, on my lord,
because
since he has
that is
given,
a modification.
my lord, the third, actually, my lord, on 24th February, when
Yes.
the order was passed, it says that the appeals and connected applications are disposed of. So I said the observation of the division bench was you also treated the writ petition to be disposed of.
Right.
That I mentioned on third, and it was clarified on third, my lord, that the last two lines.
So I'll just record on the basis of this.
That's last two lines of third.
Right.
Third
And
March.
also records that 890, they have been
It's a-
given the.
Need not. I have no scope for that after the
Fine.
disposal. An appeal was preferred against an ad interim order passed in connection with the present writ petition, which culminated in a disposal by an order dated February 24, 2025, which was subsequently modified by an order dated March 3, 2025, where the division bench was pleased to observe, inter alia, that the writ petition itself was also deemed to be treated as disposed of. Pushed up. Hence, nothing further remains to be adjudicated in the present writ petition. Pushed up. Accordingly, in the light of the observations made by the division bench in MAT 591 of 2023 and MAT 1996 of 2022, WPA 2615 of 2021, an application was also pending, along with the connected application bearing CAN 1 of 2021,
Those for expeditious disposal.
stand disposed of without being orders to cost.
Grateful. my lord.
Here for the petitioner, my lord.
Yes, Mr.
My lord, this matter was adjourned, my lord. On our prayer, my lord, both of us, my lord, prayed because there was a review pending.
Yes.
Now, my lord, it was appeal pending, my lord. The appeal was being heard by my lord division bench, my lord, presided over by Justice Tandon. It may take some more time to dispose of the my lord appeal.
Not much more time, we hope.
Yes,
No, for that, not much more time, but for disposal, I don't know, my lord.
it will take some time.
And first time, my lord, on a lighter note, I saw Mr. Chakravarti representing a contemptor coming with a smiling face.
All right. So when should you keep it? Adjourn sanitizer or adjourn I may die?
My lord kindly keeps it after 2
Adjourn
months.
sanitizer with liberty to you to mention whenever, whatever. order
Very
is
well,
passed.
very well.
Since an appeal is pending and in the process of being heard before the concerned division bench against the parent order, in respect of which the present contempt application has been filed, the present contempt application and the connected rule be adjourned sine with liberty to the parties to mention for inclusion in the list as and when a substantive order is passed in the said appeal. Pushed up. There was no direction for personal appearance for the present.
It was, my lord. The lady was there, my lord, virtually. Lordship has dispensed with the appearance.
Very well. We need not pass in further.
Yes.
It has already been dispensed with on the
Right.
Grateful, my lord.
Thank you.
Item number 5. My lord, I am waiting for the petitioner.
Yes.
That in earlier occasion, your lordship directed to serve the copy of the application.
Yes.
All the opposite.
All have been served.
My lord served. Some my lord received and one refused.
Refused. And what else?
And my lord one only out of delivery.
Out
Only
of?
one out of delivery. My lord SO out of
Out
delivery.
for delivery.
That is, my lord,
Which one is out for delivery?
my lord, that is 12.
12 was represented in the code below along with the others.
My lord, only one and in my lord appearing. 1 and 9 appearing before the code below. And this others, my lord,
Affidavit of service filed to be kept on record, full stop. Insofar as respondent number 12, opposite party number 12 is concerned, comma, it is submitted by learned counsel for the petitioner that the track report indicates that the postal track report indicates that the item was out for delivery. So insofar as the others are concerned, comma, either the service has been affected or the track report indicates refusal by the concerned opposite party. Since it is further submitted that only the opposite party numbers 1 and 9 are contesting at the present juncture in the code below, comma, further service on the opposite party number 12 is dispensed with and the matter is taken up for hearing. Yes, what is the matter?
my lord, here my order 26 rule line application has been rejected only on the ground that I filed one writ application before this honorable high court and prayer is same. For that reason, my application has been rejected. If
What is this? What is the suit for and what is the
for declaration and permanent injunction.
declaration of your title?
Yes.
And why did you pray for that investigation?
My lord, if your lordship can see your lordship's earlier order, your lordships in earlier occasion already my lord willing to grant me relief.
Let us just.
For that reason, your lordship directed.
Just give me half a minute, I'll just check. Yes. The present challenge has been preferred against an order whereby the application filed by the plaintiff stroke petitioner under Order 26, Rule 9 of the Code of Civic Procedure for holding a local investigation to ascertain the location of a passage, comma, which is the subject matter of dispute in the suit, comma, was dismissed. First up, the dismissal was on the sole ground that a writ petition is also pending before this court on similar cause of action. First up, however, comma, I find from the records and from the submission of learned counsel that the writ petition was filed in respect of an alleged inaction on the part of the concerned municipality and does not concern the merits of the present suit. Moreover, comma, in the suit, comma, a declaration of title and consequential reliefs have been sought, in aid of which the local investigation was sought. First up, next para, the writ court not being competent to grant the reliefs sought in the suit, comma, it cannot be said that the scope and purport of the two litigations are same. First up, hence, comma, hence, next para. Also, comma, I find from the schedule of the local investigation application that the local investigation is germane to decide the issues involved in the suit, comma, since the suit pertains to a dispute regarding a passage, comma, which has been claimed to be a private passage of the plaintiff, whereas the present, whereas the local investigation application was to ascertain the location of the property by comparing with the RS and LR Mousa maps, as well as to ascertain whether the said passage is a part of the suit property and whether construction is being made thereon. Accordingly, I find that the local investigation is necessary for a proper and complete determination of the disputes involved in the suit and ought to have been allowed by the learned trial judge. Hence, comma, CO 3724 of 2024 is allowed, comma, thereby setting aside order number 41 dated August 22, 2024, passed by the learned civil judge, Junior Division, Second Court at Serampur, District Hooghly, in title suit number 470 of 2021, and directing the learned trial judge to appoint a commissioner to hold local investigation in terms of the prayers made in the application under Order 26, Rule 9 of the Code of Civil Procedure, filed by the plaintiffs in connection with the suit. There will be no rise to cost. যেখানে plaintiff বলেছি সব plaintiffs হয়ে যাবে।
And I represent all of them.
You represent all of them?
And I represent.
যেখানে প্রথম সেন্টেন্সে বলেছি একদম প্রথম সেন্টেন্সে চলে যাও। ওখানটা কি বলেছি?
I have taken instruction. I have already filed the
record. So far as opposite party number 12 is concerned, it's submitted by Directive to the petitioner. So the postal track record indicates that the item was out for delivery.
তারপর
So far as others are concerned,
তারপরে সেন্টেন্স
since it is further submitted that all the opposite party numbers 1 and 9 are contesting at the present juncture in the court below, further service on the opposite party will be dispensed with and the matter is taken up for hearing.
Is dispensed with full stop the and the matter is taken up for hearing together. Full stop the at this juncture, comma, learned counsel having instruction, learned counsel appearing for the opposite parties submits that he has instruction to appear for all the opposite parties. Full stop. Accordingly, the revisional application is being taken up for hearing. Thank you.
My lord, my lord has left any scope for rehearing, or my lord had directed?
No, I've directed the investigation to save time in the suit.
Opposite party.
Yes, my lord, I am for the petitioner husband.
Yes.
Quantum of my lord maintenance.
Appearing for the first time?
First time, my lord. Yes, but my lord, the quantum of maintenance, my lord, that was my lord challenged before your lordship. No,
You're for the caveator?
No, Mr. Bhattacharya is for the caveator, my lord. I'll
Mr. Bhattacharya.
I'll just, my lord, inform my lord what has
happened. Mr. Bhattacharya.
Shona Bhattacharya. My lord, what has happened, my lord, is, my lord, during the cross-examination stage, my lord, the parties are almost at a stage of settlement, my lord. They are, my lord, on the verge of, my lord, withdrawing the suit, my lord, and filing a fresh, my lord, application, my lord, under 13B, my lord.
Withdraw this revisional application.
My lord, no, my lord, I have the instruction is, my lord, to pray for a longer adjournment, my lord, before your lordship, so that, my lord, it can be withdrawn. The suit can be withdrawn first.
Learned counsel for the petitioner submits that the parties are in talks of settlement and the suit may be resolved amicably between the parties. Full stop. Accordingly, an adjournment is sought. Full stop. Hence, let the revisional application stand adjourned and be listed in the monthly list of April. Listed on April 11, 2025.
Good. Great.
For the petition. It's appearing for the first time, Your Lordship.
I
would pray for an innocuous prayer, Your Lordship. This is in 2011 appeal, Your Lordship. We're in 2025.
Any
expeditious hearing will do, Your Lordship. This is the first time I will serve and come back.
No, interlocutory applications are pending.
Yes, local application is pending, and the main title appeal is also pending. It was in
what applications are pending in connection with the appeal?
Your Lordship, we have 151 application over there that is also pending.
For what?
We have prayed, Your Lordship, that suit to be an expeditious hearing over there in the lower court as well. That has been taken. In 2024, we have prayed. It's in 2025. After that, they had adjourned 3 times because of this.
151 application was filed for what? In the appeal?
Not on our behalf, Your Lordship.
What is the application for?
Yes. 151, they have filed, Your Lordship, for protection against us. That's the last 150.
Protection is injunction.
Yes. The injunction is not granted. There is no injunction in this matter, Lordship. In title appeal, there is no injunction. We are enjoying the property.
No, not that. I'm asking you what is the stage of the appeal is the hearing in the appeal has started?
No, Your Lordship. We have annexed all the orders. It's not
in
if Your
connection
Lordship
with
can see the last order once.
in connection with the appeal, only the application under section 151 is pending.
Yes.
No other application
No
is
other.
pending. Let us see the last order here.
Yes, Your Lordship. Kindly see the last page, Your Lordship. That is order dated 21/12/2023. And the
It says hearing of petitions. What are the petitions?
We have it's been served only one petition, Your Lordship.
In view of the innocuous nature of the prayer made, comma, service of notice on the opposite parties is dispensed with. Full stop. What was the appeal against?
It was a title suit, Your Lordship.
Your suit?
Yes.
Dismissed?
No, no. We have been granted order in our favor.
They have preferred the appeal.
They have preferred the appeal.
Full stop. The
Additional District and Session Judge Chandanagar.
present revisional, the present petitioners filed a suit which was decreed in favor of the petitioners, against which an appeal has been preferred, which is pending since the year 2011. Full stop. Next para. I find from the certified copies of the orders passed in the appeal annexed hereto that the appeal has been kept inordinately pending, full stop, at the present juncture, comma, an application filed, respondent number 4 has filed, you have filed. Respondent number 4, you are the respondents there.
Yes, we have filed.
One application under 151 has been filed by respondent number 4.
There are two applications. We have filed one application and they have also filed one application.
You said there is only one application
Yes,
pending?
on our behalf, there is only one application.
My question was not on your behalf.
Pardon, Your Lordship. One application for our end is pending.
ওটা ছাড়লাম কি বললাম লাস্ট কথা এটা তো হয়ে গেল তারপর at the present juncture, comma, two applications are pending in connection with the appeal, comma, filed by either of the parties thereto. Full stop. Next para. Accordingly, CO number 3743 of 2024 is disposed of by requesting the learned additional district and sessions judge at Chandannagar, District Hooghly, to dispose of the pending applications in connection with title appeal number 17 of 2017 before the said court as expeditiously as possible, comma, positively within 6 weeks from the date of communication of this order to the said court. Full stop. The learned appellate judge shall, comma, thereafter, comma, endeavor to dispose of the title appeal itself as expeditiously as possible, comma, preferably by September 30, 2025.
I am for the petitioner, my lord. Last occasion, your lordship heard this matter, but due to paucity of time, it has not been completed, my lord.
Right.
My lord, that, my lord.
Who is appearing for the Mr. Gopal Ghosh is appearing? Yes.
Here, my lord. My lord, before he starts, my lord, taking cue of his submission on last occasion, my lord, I be permitted to kindly draw your lordship's attention. 3 deeds. My lord, he is disputing schedule. It is his stand in the court below.
Mr. Poda, please remind me that I have forgotten the matter. What is the challenge against?
Yes, challenge against identity order I obtained.
Injunction.
Restraining the defendant opposite party to interfere peaceful position over my property.
What is your suit for?
Suit for declaration and injunction that the opposite party defendant having no right to disturb my peaceful position.
What is the declaration?
My lord.
What is the declaration?
Declaration he has no right. What? I am the owner.
That your title?
Yes, I am. Title is not disputed. I produce the
Then what is the declaration for?
Declaration for injunction.
Let me see the prayer portion of the plaint. There cannot be a declaration for injunction. Where is your plaint?
23. 23.
Your title, they have no title.
Yes, yes.
Very well. Ad interim injunction granted. Then what happened?
and my lord, additional injunction granted, my lord, but when injunction came up for hearing,
yes,
after having an interim order of injunction, my lord, at my instance, at the plaintiff's instance, one application for order 30 local inspection sought for, and that was allowed. And my lord, in that local inspection, at my behest, I my lord, my lord, open up all the premises and all the doors and everything. My lord, though you notice, my lord, the defendant not though present but not endorse their signature. But what is the crucial in the report? The commissioner said this is a structure G plus 1 plus 1.
Your injunction was for restraining them from doing what? Making construction, changing nature, character.
Disturbance over my peaceful position.
Right.
And later on, it was found that later on, during the pendence of the suit, they evicted myself and my tenant also. And tenant
have evicted already.
Already.
So what is the
during
scope of
the pendence of the suit?
So scope of
The
injunction?
pendence of the injunction application.
What is the scope of injunction now? What is the scope of injunction?
Yes,
If they have
mandatory-
evicted you.
Yes, evicted you.
Not
Evicted
you, not
me.
me, you.
Evicted me.
Yes.
Now, my mandatory, I have, since the order has been, my lord, injunction has been, my lord, dismissed, rejected, then I preferred one appeal. And misappeal also, my lord, rejected. On the ground that there is a discrepancy in my plaint assertion and the report of the commissioner. It says that it is G plus 2, and in my application and in my lord plan, there is a G plus 1 sanction, and physically there was found some construction over the roof of.
Oh, you say there is an attic.
Yes.
Which was considered.
Yes. Now,
But if you have been ousted, then where is the scope of grant of injunction?
suit is pending, my lord. If, my lord, suit is
You are not
pending.
in position. I shall give an injunction so that they may not disturb your position. Your relief lies before the trial court. Your relief lies before the trial court in seeking a mandated injunction now. Because you are not ousted in violation of an injunction order. You are ousted when there was no injunction.
By violation of the order of injunction.
Then you go before the trial court and file an
This is
application.
on page 118. Page 118, it is submitted by the learned advocate of the defendant that the plaintiff is forcefully possessing the suit plot in spite of ownership of the defendant over the suit plot. My lord, so, my lord.
When did they oust you? Where have you you have filed an application under Order 13 Rule 2A?
Yes. That is pending.
What is that? So where is the scope of grant of injunction? Even if you win this revisional application, how can an injunction be granted at this point of time? That has become infructuous.
My lord, this in another way, roundabout way, declares that I am not the owner of the property. It decided the finality of the suit in an injunction application.
We'll say that observation will not be binding at further stages of the suit. That comment I'll make.
My lord, only on the ground of, my lord, that schedule, there is a discrepancy in the schedule in my application, in my plan, and the report of the commissioners. Only this, my lord.
Understood, Mr.
And my lord, I am drawing your lordship's kind attention that they are claiming that this is they have constructed on their land. It is our allegation. That is after they took possession. My lord, kindly see, my lord, his deeds, my deeds, his deeds. It is existence that I am on his southern side. It is in his deed. Oh, deed number page double.
Revisional court cannot go into that fact-finding inquiry. Let us see the finding of the appeal court.
No, just able to finding.
No, not only on the number of floors, also that the boundaries are not tallying.
Yes, I am coming on boundaries. I am coming on boundaries. Please kindly see. Kindly see my deeds. Page 55.
Actual finding of the appeal court cannot be interfered in 227. We cannot compare deeds sitting here. That was done by the appellate court. It was said that the building plan shows in the northern side.
Illegally came into that fine. Illegally. When my lord deed is present there, my lord very deed is saying, I am on the on my northern side, Ashok Khara's plot is there.
Yes.
Number one. My lord, when Ashok Khara, in Ashok Khara deed, my existence in his southern side.
All right.
Correct. Up to this, it is correct.
Only the building plan is wrong.
No, plan is not wrong.
That is the finding. Building plan in the name of plaintiff shows on the northern side land of Dinesh Datta.
Yes, because in the
a bit softer.
In the meantime, my lord, there was a dispute with his land with other one. He preferred one suit against others that I annexed, my lord. And in that suit, though initially he obtained order of status quo, thereafter, my lord, that suit was culminated into dismissal. And since after the dismissal, in his place, another plot holder name is there.
Your building plan shows that in the northern side there is someone else. It's your
Someone
building
else.
plan.
Because he is not there. Because northern side, as per my deed, northern side, in my northern side, my Ashok Khara, and in his deed on his southern side, my name is there.
Yes, but court finds that building plan in the name of plaintiff, your name,
yes,
shows that on the northern side of your land, the land of Dinesh Datta is there.
Yes, because Dinesh Datta and others, they encroach upon their land, his land, and he filed.
Ashok Khara.
This Ashok Khara, and he filed a suit.
The ghost is for Ashok Khara.
Yes. No, not now. Ashok Khara's transfer. Ashok Khara's
transfer.
Yes. So, my lord.
All right.
So, my lord, kindly now, my lord, kindly see the deed through whom the present opposite party claiming that they purchased from Ashok Khara. My lord, kindly see.
That building plan is on the basis of a subsequent decree obtained by Dinesh Datta.
No. Building plan is after dismissal of that suit initiated by Ashok Khara against 2025 defendant,
including Dinesh
Datta. Yes,
including Dinesh Datta.
Including Dinesh Datta. So that suit culminated into dismissal. So he was aloof from the pictures. And his place in my
Ashok Khara's claim suit for title declaration regarding that northern land.
Yes,
that was dismissed.
Yes,
on the basis of that, Dinesh Datta, the winner.
Yes. Dinesh Datta came on my.
But the property boundaries are the same.
Yes.
No.
Dinesh Datta came to existence on my northern side at the time of submission of the building plan. Now, my lord, kindly see.
Mr. Poder, if you grant an injunction to you,
my lord,
how will it?
I am coming later on, my lord. Kindly see the deed through which peasant Akram, opposite party, he is claiming. My lord, kindly see.
Akram?
Yes. The peasant opposite party who obstructed, who evicted me, who, my lord, obstructed the order of injunction.
So violated. Akram purchased from Ashok Khara.
Yes.
Lord, kindly come to page 200. Deed is there.
214. Kindly.
200 kindly come first. 200.
214.
By
দাঁড়ান না, আমি তো বলি না।
আচ্ছা ঠিক আছে বলে নাও ভালো করে।
214.
My lord, that Ashok Khara, he by two sold it. He sold, my lord, 1.5 decimal to 2 persons. Total plot, as he claimed, 3 decimals, and he sold by 2 deeds 1.5 each. My lord, kindly have a look, 214. It is the first deed.
You also purchased from Ashok Khara?
No. Vishwaswat is the original owner.
Yes, page 214. What is that?
214. My lord, kindly see the schedule.
Yes.
উত্তর অত্র দাগে ক্রেতার নিজ পার দীনেশ দত্ত।
Yes.
উত্তর।
Yes.
Now দক্ষিণ প্রদীপ সামন্ত। I was in southern side. If it is the first deed, then Dokhi on the southern side, Ashok Khara's name should be there. If it is the first plot, out of total 3 decimal, if it can be divided, then Ashok Khara will remain. And if it is second plot, then Ashit Khara's name will be there. My lord, kindly see here on the southern side, Pradip Samanto. Now, my lord, kindly see second deed. It is in respect of 1.5 decimal. In his 2 deeds, out of 2, in one deed, on the southern side, I must be there. but that is not there. Well, second deed ta bolo. 200. Now, my lord, kindly see page 200. It is another deed. Who is on উত্তর অত্র দাগে দীনেশ দত্ত, দক্ষিণ অত্র দাগে আমার নিজ। অত্র দাগে, this is the first deed. দক্ষিণ অত্র দাগে আমার নিজ. That means, my lord, if that is divided by half, then it is true. He on southern side Osit Khara's land. Now, my lord, remaining portion, when my lord 214.
Both the deeds Uttor Dinesh Datta is shown.
Yes, but on the south,
maybe
south, my existence was on the south. It is admitted from his deed. His parent did, kindly see Asot Khara's deed.
What is that?
What the Asot Khara deed? Or 20. 20. My lord, kindly come to page. No, 20. No, 51. 51. And my lord, kindly see his schedule. My lord, kindly see 55. 55. My lord, got it?
Got it.
Kindly see. Last line.
Yes.
Uttor oidag nijo. Uttor sold out. Nijo. That is Uttor nijo. Sorry. Uttor nijo means the owner, the vendor.
Yes.
Now, purbo সরকারি রাস্তা admitted. পশ্চিম খাল, দক্ষিণ অসিত খাড়া. So, my lord, if in his deed on his southern side existence of Osit Khara, my client, his plot is there. So where he gone in these two sale deed? So the sale is void. Sale is not on his plot. My lord, this thing, my lord.
The rest of the plot descriptions are same.
Which plot, my lord?
The rest of the descriptions are same.
Yes. And my lord, the dispute, my lord, started. My lord, kindly see, he filed the suit. ওটা পেজটা বলো। ও যে মামলাটা করেছিল সেটা পেজটা বলো। My lord, he filed a suit complaining, my lord. 101.
But these sale deeds, which you showed first,
yes,
by that Ashok Khara had sold to Ashok. Who was Ashok Khara? He's related to you?
Yes, my elder brother.
So Ashok Khara is shown in your deed. You are Osit Khara.
Osit Khara on my northern side. Ashok Khara is there. It is admitted.
This is Ashok Khara deed at page 55.
Ashok Khara deed. In Ashok Khara deed, Osit Khara is on the southern side.
Right.
So he must be there in the sale deed executed by Ashok Khara.
In your north, he should be there.
Yes. No, I should be on the south, on his south.
If you are on his south, he is on your north.
Yes.
Then on your north, Ashok Khara should be there.
Yes. And that is not showing in his two deeds through which this present Mr. Ghosh's client is claiming that we purchase it. It is our house. We raise construction. It is our allegation. It is not that. It is not coming. Oh, which property they said he sold. And at the same time, if he fight out a case for his position, and that goes for dismiss on.
So these two subsequent deeds which you showed me at 200 and 214.
Yes,
these are regarding the same land he is transferring again.
Yes. Only he purchased only 3 decimal. I also
so after selling to you, he is selling to them again.
I am not claiming through Osit Khara. Ashok Khara, I purchased from Vishweshwar Das. He also purchased from Vishweshwar Das. And other also purchased from Vishweshwar Das. We all purchase. After purchase, my lord, what happened? His plot of land, which was situated on my northern side, his plot of land, some other plot holder, they encroached Rasta, my lord, road, my lord, constructed. My lord, so he filed a suit and obtain order of status quo. Nobody can construct. and that was maintained. And when his suit was dismissed, then my lord, I also constructed.
If you were in the south of Ashok Khana's land, then you should remain in the south of Ashok Khana's land when he sells it to Dinesh.
Yes.
Sells it to him. After.
Yes.
Then why you are bothered with north? Then we should see Ashok Khana's subsequent sale deeds, the south of that, because you are in his south.
Yes.
Am I clear?
Yes.
You are Ashit Khana.
Ashit
Ashok Khana is in your north.
Yes.
So
I am on his south.
You are on his south.
South.
So the other two sale deeds, 200.
There is no on the south. There is no existence of myself.
In one deed, these 200 and 214 pages.
Yes.
These deeds also should show that you are on the south.
In one, because the deed was, well, kindly say deed the
divided by half.
Yes, yes. In first deed, that the Nijo on the southern side, Nijo, that is okay. In the second deed, on the south, there must be my lord Ashit Khara. So it is my lord manipulated. So manipulation starts from Ashok Khara. So how he can claim? My lord, I purchase.
We don't. Ashok Khana is selling his own property.
Own property.
So how are you?
If the schedule is not tell you, how it can be said that it is my question to myself.
Your property remains with you.
No, I am not on the south. So which property is sold? I am not on his.
Which is your purchase deed?
Yes, I have annexed.
What is that?
Yes.
Your land will be decided on your purchase deed.
Yes, yes. My lord, page, my lord, it is 17.
17.
17.
Where is your schedule?
Yes. Page 20. Last line. উত্তরে দাগে দং অশোক কুমার খাড়া, দক্ষিণ নিজ, দ্যাট মিনস ভেন্ডার, পূর্ব সরকারি রাস্তা, পশ্চিম খাল.
You are seeking declaration regarding this property now?
Yes, I constructed over this property, obtained plan, my lord, all the machinery.
Plan shows that on the north is
because in the meantime his suit has been dismissed, my lord. There was problem on his plot. He had not got possession of.
Where is your plan? Where is that plan?
Yes. Panchayat issued me, my lord, permission. What about Panchayat? It is there, my lord.
Page 22. Capital A.
Point. Yes, it is Abedan Patra. 22A, 22B.
Where is it shown that Dinesh Dutt is on the north?
Yes.
That's up to the first level. Page 22A.
উত্তর চতুর্সীমা, উত্তর দীনেশ দত্ত. It should be Ashok Kumar Khara unless he has.
Where is that? Which page?
My lord, চতুর্সীমা, just below the আবেদন পত্র. Below the চতুর্সীমা, my lord. Page 20.
Yes, চতুর্সীমা.
Yeah. On left hand side, উত্তর দীনেশ দত্ত. They are disputing that this is a different plot because Dinesh Datta came into existence because he has been dispossessed.
Let us suppose for the timing you are right. But
Yes.
At best, we can, even if you win here, we can set aside the decree and. But
no, there is no decree.
I will set aside the appeal court's order and but can't grant injunction because you are out of person now.
My lord, for that reason, I have to.
That will tantamount to granting you mandated injunction which is beyond the scope of the appeal.
My lord, if the defendant by violating the order of they admitted,
you have to get that order before the trial court. You have to satisfy the trial court that they violated.
My lord, in this juncture, High Court hands are not tight, my lord.
Fully
when
tight.
My lord, High Court, my lord, appreciated.
Are fully tight.
When High Court, my lord, it is
right behind our back. Behind our back, there is no law. There is no High Court.
My lord, my house has been practically robbed. My house has. My lord, there are some photographs I shown, my lord.
Sir Poddar, even if I fully sympathize with you, you have already filed 39(2)(a). Have you asked for mandatory injunction for restoration of possession? Go and file that before the trial court. Otherwise, this revisional application is meaningless. Even if you win the injunction application, then nothing happens. Ad interim violated. Ad interim order was violated, and you were he took possession according to you.
Yes, but it is their admission. It is their admission. It is their admission that
as of today you are not in possession. So on the date of the injunction application being refused, when it was refused by the trial court,
yes,
you are still in possession.
yes, yes. At the date of
When the lower court, the trial court, first
yes,
court,
yes,
it refused the injunction, you are still in possession.
yes, on that day.
No.
You are in possession.
On that
This
day.
application of Authority Rule 2A, kindly see the date and interim order date. It was not there. In fact, it is our property.
My lord, at that point of time, I was there. My lord, I realized, my lord, some document, my lord, my tenant, my lord, complained to the police station that at the instance of the opposite party, they were disturbed and they were dispossessed.
Dispossessed after the injunction application was refused.
After the injunction, yes, my lord.
If that be so, that is not in violation of any injunction order.
No, my lord, kindly see, my lord, the order of injunction, my lord, kindly see.
If you are
My lord,
dispossessed
kindly-
after your injunction application
my
is
lord, kindly
dismissed,
see the refusal
Mr.
order.
Poddar, if you are dispossessed after your injunction application is dismissed, on the date of disposition there was no
No,
injunction.
no. First order, kindly see the
The
order.
number of no's do not make a difference. It still remains no.
118. No, my lord, it is submitted by the learned advocate at the time of hearing of the hearing of the injunction application on contest.
If you get back possession,
My lord,
then
kindly see, it is submitted by the learned advocate of the defendant that the plaintiff is forcefully possessing the suit plot in spite of ownership of the defendants over the suit plot. It is the assertion of the defendant at the time of hearing of the injunction application.
what is that? Where are you reading?
My lord, page 118. After ad interim, I was dispossessed forcefully.
What is the date of disposition according to you?
Date of disposition, order 30, rule 2.
Get it, Lord.
Where is that?
At page 45.
20th November 2022.
Where? Which page?
Page 25. Page 45.
143.
Page 45.
You the photograph. Well, there is a photograph date. But there is a complaint, my lord, to officer in charge, my lord. There is the date is there, my
43
lord.
is their
11
objection.
November.
43 is their objection.
My lord, 139, my lord, kindly see the complaint to the police by
No,
the
page 40,
tenant.
please come to page 45, your own application. You say 20th of November 2022, you have been dispossessed. And where is
Yes.
the order of the trial court?
My lord, order 13, rule 1 and 2, my lord.
Mr. Ghosh, where is the order of the trial court?
That is at page 118.
But unless you get an order of restoration of possession, you have not even filed for restoration. Get an order from the trial court then.
Page
We can keep the
37 is
revisional
my
application pending for that.
Page 37, application of my lord, violation.
You have this is application for violation for contempt. You
Yes.
can be sent to jail for this. But you have not asked for restoration. Go and file that application. If you get back restoration, then we'll consider the veracity. Otherwise, even if you win the revisional application, if you hold that the appellate court order is bad, we cannot restore back possession in connection with a restraint order, prohibited injunction. Do you get my point? We'll adjourn this. I'll say that. I'll give the reason. Learned counsel for Mr. Ghosh will keep this pending. I'm not adjudicating on merits.
Just pointing out from the Lord, not only Dinesh Datta on the north. Lord, your
No,
lordship,
on merits, even if you
No.
adjudicate today,
Lord, kindly see the plan that is not relating to his deed. Lord, it appears not kindly
if it did not relate to his deed,
Page
then that could not form a basis of the appellate court's order.
No, Lord, it has been recorded by the trial court.
They have filed their own title deed.
Not title.
From the title deed, the land is very clear.
Yes, yes.
They are making construction
No,
on that.
but-
Why shouldn't the injunction be
No, in
granted?
fact, it is case that we are in possession, but on the not Dinesh Datto, in that building. We have purchased. From the our deed, it will appear that on the not Dinesh Datto. That is also Khada's deed.
Your purchase is subsequent to his purchase.
No, earlier. No, kindly see what.
Your title deed is earlier than his.
Yes.
What
And
is the
it
date of your?
Rather, no, it is unpartitioned property.
What is the date of your purchase?
Lord, your lordship, kindly see. Our date of purchase is. I'm just ready.
It's 27th April 1992.
92.
92.
And your purchase, Mr. Poddar?
My lord, 20 same date.
Same day.
Same date.
Same day. And no, kindly see.
Vendor should be given a price for this.
Lord, ki unpartitioned property. Kindly see once more my satisfaction.
I constructed.
22C.
I constructed. How can we?
If unpartitioned property, then
Injunction cannot be granted.
Why not?
Lord, kindly see, Lord. Kindly see, Lord, 22C once.
That was not the premise of this.
Lord, kindly see the what plan he has sanctioned. 22C.
At this point.
That is not other property. Just for my satisfaction, man, kindly see.
I am not here to satisfy you,
22C.
Mr. Ghosh.
22C.
Learned counsel for the petitioner submits that the
Well,
present
no
revisional
further
application
transfer,
has
my
been filed against an order whereby the miscellaneous appellate court affirmed an order of dismissal of the petitioner's application for temporary injunction. Whose of next para, in the same breath, it is pointed out that during pendency of the injunction application in the trial court, the plaintiff stroke petitioner was dispossessed by the respondents, which contention is denied by learned senior counsel appearing for the opposite parties. Whose of next para. However, fact remains that admittedly the plaintiff stroke petitioner has been dispossessed, and as such, at the present juncture, even if the revisional application is allowed and the appellate court's order is and the orders of the courts below are set aside, no temporary injunction can be granted to protect the possession of the plaintiff stroke petitioner, since the petitioner is not in possession. Full stop. We also find that although an application under Order 39 Rule 2 capital A of the Code of Civil Procedure has been filed by the plaintiff petitioner in the court below, there is no subsisting application for restoration of possession, alleging that the possession has been alleging that the petitioner has been ousted from possession in violation of an order of ad interim injunction. Push up next para. Accordingly, the revisional application, even if allowed, would inure to no one's benefit, since the court would be powerless to grant injunction protecting possession which is no longer there. Full stop. Accordingly, the revisional application is adjourned sine die with liberty to the petitioner to mention for inclusion in the list. Full stop. Liberty is given to the plaintiff stroke petitioner to file an appropriate application for seeking restoration of possession on the ground of having been ousted in violation of an ad interim order of injunction. Full stop. Next para. It is made clear that if such an application is filed, the learned trial judge shall decide the same without being influenced unnecessarily by any of the observations made by the orders impugned herein or in this order. Full stop. Subject to such application being decided, leave is granted to the parties to mention the matter for inclusion, mention the revisional application for inclusion in the list.
No transfer in the meantime. If you want to transfer,
Nothing. Next. Yes.
But I am appearing on behalf of the husband petitioner.
Lordship, in this matter, I'm appearing on behalf of the respondent. Lordship, my senior, I'm being led by Mr. Abhishek Tuha. So he is in New Delhi. So for his personal difficulties, he could not come to the court today. Lordship, if see any day next.
What is the impugned order?
My lord, it was allowing the alimony penalty like a application of the alimony penalty application under section 36 of Threshold Marriage Act of the wife, in spite of placing several proper documents which are also before your lordship, The husband has a net income of 1,62,000, and how much he is expending behind the family? 70,000 he is paying. And the wife has independent income of around 60,000 per month. That document also was placed. That was
You are earning how much? 1 lakh.
1,62,000.
And she's earning 60 something. And she has been granted alimony?
50,000. And that from the date of execution of the matrimonial suit. That's in 2019.
Alimony application was filed later.
Immediately after getting obtaining the summons of the suit.
Acha, and is there any child?
There is a child. May I draw your lordship's attention?
For the child also something should be given.
Yes, I'm giving my lord. My lord, can you come to paragraph 4 at page 6 of my application?
Let us see the impugn order first. But she's asking for time. What can we do? We'll restrain you from executing the order in the meantime. Don't execute the order. Because next week, next Friday is a holiday. And adjournment is, yes?
It's not 21st. I won't be able to decide in the
Then no injunction.
No, my lordship.
If it's on their prayer, then I grant. Then no injunction. On the prayer of the caveators to opposite party, the matter is adjourned for the day. Next. Affidavit of service filed to be kept on record. Yes. Call on the next.
In the same position.
No.
We go down the list.
Yes.
Well, I've got a petition. Kindly short pass over, my lord.
No passover. Move the matter. I'll dismiss it for default if you don't move it. Motions have been assigned to this bench. We are stuck up with the motions. That's why you are taking motions first. I am not the motion bench originally. He may be engaged. You should be prepared in the matter. What is the matter about? You should start the matter. Then I'll dismiss for default. Assigned matter, no time. We'll give you a 10-minute passover. If she does not come in between, at 3:10, we'll take up the matter. Passover. 3:10 ডাকবেন আমরা. We'll dismiss for default otherwise. Yes.
Your lordship, I am appearing on response from a bank for short passover.
No passover. Yes, what is the matter?
Samrita Sen was.
Your lordship, this is a
My lord, I appeal for the petitioner.
Yes, Mr. Gupta, what is the...
I appeal for the petitioner.
Yes.
This is a contempt application. My lord, on the last occasion, your lordships lordship refused to permit them to use an affidavit. They said that they would be coming with affidavit in.
Why are you taking steps?
I am humbly praying for just short passover.
No passover. Why are you taking steps?
Yes, your lordship, I will.
Despite the section 13(4) notice having been set aside, why are you taking steps in pursuance of that?
I
Use the mic.
I will file one reply to this lordship. Kindly give me 7 days time.
No question of reply. What is your answer? Otherwise, I'll issue a rule. Answer the rule directly. Your client will be personally present.
Yes, your lordship.
This court set aside an order, a notice under section 13(4) of the SRPC Act on whatever ground. And you have been issuing publications, publishing notices in newspapers for sale.
Yes, lordship. Only one thing I need to.
What is your instruction on that?
Instruction on that it will be we will withdraw this notice, your lordship.
Why did you issue the notice in the first place? Even if you withdraw now, you cannot purge the contempt.
Your lordship, kindly make it not to your lordship.
No question of making it not today. You are appearing in the matter.
Yes, I before the respondent, my lord.
Yes. Notices were set aside, 13(4) notices. Why are you making paper publications for sale?
Well, only one thing, my lord. It
Yes.
has gone down as sale. My lord, they had published. I have annexed the notices also. These are measures under the act by taking possession.
Anyway, whatever steps you are taking in terms of the section 13(4) notices, why are they not contempt?
My lord, may I indicate very briefly, my lord?
Take your breath and then indicate.
My lord, at the very outset, my lord, irrespective of the fact whether contempt has been done or not, my lord, I tender my unconditional apology on behalf of my client, my lord.
But why?
Irrespective. Admittedly, my lord, I must be fair. at least in respect of one of the Mumbai property, my lord, which forms the subject matter of the 25th November 2023 notice. That property admittedly has been proceeded with. I have no justification to give, my lord, at this present
If
juncture.
you have no justification, then you should go to jail.
My lord, the only justification perhaps I can give, my lord, is that kindly takes, my lord, the 25th November 2023 property deals with a partnership asset, my lord. This is a partnership asset where, my lord, the petitioner is one of the partner. If my lord gives me leave, my lord, I can place judgments which say, my lord,
You cannot reopen the veracity of the order. You should have preferred an appeal against the order.
certainly, my lord, that I have no justification as I, my lord.
What have you done in violation of that?
My lord, that 25th November 2023 notice, my lord, admittedly the property has been proceeded with. That, my lord, will see from the contempt petition itself. There's another property, my lord. There are 2 notices were impugned in the writ petition.
File an affidavit in opposition within a fortnight and don't proceed further.
Certainly, my lord.
Learned counsel appearing for the
one
response.
thing in the lordship's last audit has gone down as sale, it possibly should be measured. Measures under the submission. It has gone down as sale.
What have you done? You have posted a notice for sale, published a notice for sale.
Possession notices, my lord, were issued.
Learned counsel appearing for the respondent bank, a respondent contemner, submits that at least regarding a Mumbai property, which was a part of the notice under section 13 within bracket 4 of the Surface Act, which was set aside by this court, a notice of possession has been issued. Full stop. Learned counsel, on behalf of the alleged contemner, tenders unqualified apology for the same. Full stop. Next para. Be that as it may, the alleged contemner shall file an affidavit in opposition to the contempt application, explaining such prima facie contumacious action, within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Next para. The alleged contemner shall remain restrained during pendency of the contempt application from taking any further step whatsoever in terms of the notices under section 13 within bracket 4 of the Surface Act, which were set aside by the order dated February 5, 2024 in WPA 27463 of 2023. Full stop.
Only one submission.
The matter
These
shall next
notices
be yes, yes, please.
Well, these notices were not set aside. Previously, notices were set aside because of section 95-96 of IBC. This is a subsequent notice, despite the all actions being set aside.
Can you let them come up with the
Your Lordship, affidavit of service be kept.
affidavit of service file today be kept on record. The matter shall next be listed on April 11, 2025. Next.
Alleged contemner, my lord. I have already filed my affidavits on January 10, 2025, my lord. On that day, petitioner has not appeared.
They are seeking adjournments.
And the order has been complied. On 10th January, my lord,
in the affidavit of opposition, you have mentioned that, no, in that you have mentioned that the order has been complied with.
Yes, my lord. On 10th January, at the time of call, my lord, no one has appeared. This is the second time.
Opposition, which page you have pointed out?
I am showing you.
You are Mr. Guho. You are Mr.
No,
Chaturvedi. Chaturvedi. Mr. Chaturvedi, what was the order?
My lord, order
directing you to assess and disburse compensation.
Yes, my lord.
You have
Order-
disbursed.
Yes, my lord. And
What?
the registered has been. This is the documents, my lord. After
Just show me that in the affidavit of opposition. We'll just.
yes, yes. Affidavits on behalf of the my lord, Saurabh Bose.
Saurabh. Yes, Saurabh.
Paragraph, my lord.
Show me the receipt for payment or something
Yes,
of
my lord,
that.
yes.
Only that.
This is the receipt, my lord.
No, you have not annexed that to the
No,
opposition.
sir. After that, my lord, it has been sent to me.
These are photocopies.
Yes, my lord.
So we'll keep these on record.
Yes.
None appears for the alleged contemner, none appears for the petitioner at the time of call, full stop. It is seen that on the last occasion when the matter was called on for hearing, that is on January 10, 2025, as well, comma, an adjournment was sought on behalf of the petitioner. Full stop. Despite the extension of time till the time for filing reply till the next returnable date, comma, till date no such affidavit in reply has been filed, comma, nor is the petitioner represented. Full stop. Learned counsel appearing for the alleged contemner hands over photocopies of documents indicating that the compensation amount has been disbursed to the petitioner in terms of the order under contempt. Full stop. Such documents are kept on record. Full stop. In view of the contempt having been purged, comma, by compliance with the order in question, comma, there is no further necessity to keep the contempt application pending. Full stop. Accordingly, CPAN 164 of 2022 is dismissed as infructuous. No address to question. Next.
Right, any
Number 13.
We have been for the list contemner, Your Lordship.
I beg to appear for the applicant, petitioner.
One is Lordship affidavit, and there is some limited affidavit which some documents are not annexed as per direction, Lordship. That's why we annexed.
You have not given copies to them.
We prepared an affidavit reply, but without consulting the supplementary.
The affidavit in opposition filed today and the reply thereto be kept on record. Full stop. Learned counsel for the alleged contemner seeks to file a supplementary affidavit. Full stop. Such leave is granted and the supplementary affidavit is kept on record. Full stop. A copy thereof shall be served. A copy thereof right now is served here and now on the learned advocate for the petitioner. Full stop. The petitioner is granted of. You can file rejoinder thereto within a week.
Yes, yes.
Is
one submission, in Lordship. We have collected the amount of.
Is granted at time is granted a week's time for filing rejoinder to the said supplementary affidavit. Yes, what do you say?
Lordship, we have collected the amount of 8 lakhs rupees lying with us, Lordship, to hand over the degree holder, Lordship.
Do that in the meantime. That's not the entire amount.
No, not the entire amount. Part
So without prejudice to my rights and
yes, definitely. And learned counsel for the alleged
Yes,
learned counsel for the alleged contemner submits that the alleged contemner you have what is this?
8 lakhs rupees, Lordship. Different checks, Lordship.
You have given.
No, we have sent a letter.
You are ready with the checks?
From the office.
Demand draft is lying with them.
Learned counsel appearing for the alleged contemner submits that a part of the amount as directed by this court is in the hands of the alleged contemner and can be disbursed right now, for which certain demand drafts have been prepared in the name of the petitioner. In the event the petitioner approaches the office of the alleged contemner, comma, such amount shall be paid to the petitioner. Next para. A communication in that regard is handed over in court indicating the particulars of the said demand drafts and the amounts concerned. Next para. The petitioner is granted liberty to approach the office of the alleged contemner. If so approached, comma, the alleged contemner shall disburse. If so approached during office hours of the said office, comma, the alleged contemner shall disburse such amount of rupees 8 lakh in terms of the particulars as depicted in the communication handed over and kept on record in court today, comma, without prejudice to the rights and contentions of either of the parties in the contempt application.
Only one indulgence. I'm taking 1 minute.
Yes.
On 3rd March 2025, they have given Millard the entire amount which I am supposed to receive. Not entire, the 8 lakhs.
Not 8
No. On 4th March, Millard, they immediately 1 day after, they said, I have disagreed to accept the check. It is the notice of the auction. Maybe they kindly see the 4th March.
The learned counsel for the petitioner submits that although the petitioner was given the communication handed over in court today on March 3, 2025, comma, by a subsequent communication, it was indicated that
Well-
since the petitioner is not agreeable to receive such amount, comma, the same was not given to the petitioner. Full stop. Be that as it may, comma, as indicated above, comma, the petitioner shall approach the office of the alleged contender afresh.
Yes.
And the acceptance of the said sum by the petitioner will be without prejudice to the rights of parties. Full stop. The application shall next be listed on March 21, 2025 for passing further.
Deeply obliged.
Lordship,
Probably you might have refused because that was not the
Lordship, you give this
interim.
matter after
Maybe.
9th Lordship.
No,
9th
3rd
April,
March,
because
then
the Lordship,
next day. 3rd March they communicated.
Lordship, we have also issued a proclamation of sale, Lordship, that is fixed on 9th April, your Lordship.
How does that matter? What is the
For the remaining amount, your Lordship.
No, we'll keep it on 21st.
Lordship.
First give this amount, then we'll consider.
Lordship.
Deeply obliged.
Thank you. You have filed your opposition. Yeah, that we have recorded. পাসওয়ার্ড ম্যাটারটা রাখবেন না 14 ডেকে দিয়েছেন দিন খেয়াল করা উচিত ছিল ইয়েস মিস্টার ঘোষ হোয়াট ইজ দ্য ম্যাটার
I am looking for the alleged contenders.
Yes.
This is exception to the report. It exception to
Got a copy of the exception?
Yes.
দিন ওটা What have you said in the exception, Mr. Ghosh?
Yes, Lord, we have stated that the report submitted by the Lord, the officer, Lord, he has said one thing, Lord, they have taken two defense to avoid contempt, to, Lord, to get rid of the contempt. First thing, Lord, that cradle guard didn't fell down in 2018 April, and the cradle guard has been placed touching the roof. So far that is concerned, the special officer has given the report that it touched the parapet wall. That is roof. Lord, parapet wall is roof. Property was constructed in 1958. And their stand is that recently construction has been made, that's why it has, the distance has come down. It is not a fact. The report also supports that it touches the parapet wall. Parapet wall is part of the roof. It is not only height is 2.5 feet, 3.5 feet. That is normal. And our building height is 9.5 feet. Totally is less than normal. Admittedly, it touches. Lord, your Lordship kindly see, your Lordship passed the order. Your Lordship kindly come to the contempt application, your Lordship's order. Contempt application.
Remove the cradle guard and reposition sufficiently above the top of the roof.
Yes. Lord, this order was passed and your Lordship gave a specific time limit. Because matter is very serious matter, Lord, the current Lord. Then Lord, we communicated the order. It was passed ex parte because in spite of service of notice, they didn't appear. Thereafter, Lord, after second letter, they responded that we are going to file a review application against that order and therefore we are not going to comply. Lord, review application was filed saying that we have practiced fraud upon this honorable court. That review application ultimately same grounds were taken and your Lordship has been pleased to reject this review application. Now, Lord, the contempt application, they have filed their opposition as Lordship directed. Lord, your Lordship can see the opposition, they have taken two stand that cradle guard never fell down and there was question of restoration did never arise, and the in view of other stand is that in view of construction, it has the level of the height has come down. Your Lordship kindly see that this in terms of the division bench order, the cradle guard was
as per the photograph,
yes,
there is no space further to lift the cradle guard because it will touch the wire then. If you see this photograph,
Lord, photograph will not see
photograph will not
disclose the real picture. Lord, they have stated
photograph will not real photograph is the picture.
Lord, they have given the measurement also. You'll also from the report it will appear.
2.5 feet. Photograph, what can be better than the photograph?
It can be done, Lord, above 2.5 feet. They have, according to their suggestion own, it can be done. And Lord, in the affidavit also they have said that it can be
Lifted.
Lifted.
No, my lord.
Yes,
Where
no,
have
I'll
they
show.
stated?
I'll
Which-
show.
Show it.
Yes.
Where they have admitted.
In affidavit, it has been said, not in the report. my lord.
Report also.
No, if in your affidavit you have stated, then
80 centimeters. 80
it is touching their.
Yes.
I will come to that. I will come to that.
But kindly,
So we are in contempt. You cannot revisit the order. You have to leave the credit card. And the building appears to be quite old. Not recent construction.
Well, your lordship kindly see from the records itself. I will show from the your lordship kindly. It is the consistent stand that there was construction is old. My lord, your lordship kindly see paragraph 23 of the writ petition. My lord.
Lord, before that,
We
Lord,
cannot go
let me
behind the
confirm.
order.
My lord, kindly see it
Let-
reflects the
Lord-
true fact. It was a single story. That is why
Lord-
writ petition was moved. It
How
was
about
his claim.
It is
was
still
his
now
claim.
single story.
It is not a single story.
Lord, let me,
This
Lord,
kind of statements are made, my lord.
Lord, let me finish, Lord.
It has
Let him finish then. Yes.
Let me finish. Lord, the kindly see.
Let us see from the report what they have said.
Yes. Lord, your lordship, report according to letter of mental history.
Let me just find out the report first.
Lord, got the my lord, got the report.
No. এই রিপোর্টটা বার করে দিন তো
এইরকম দেখতে হবে
রিপোর্ট ফাইল করেছেন ওটা বার করে দিন ওদের দেখে নিন একবার খুলে আলাদা করে দিন ওটা Yes, Mr. Ghosh, in the report where I have this stated, can be lifted about minimum clearance.
Lord, your lordship, kindly see.
$800 it can be.
Yes, 800. 800.
No, my lord.
Yes, that is there. And Lord, so far the construction is concerned, your lordship kindly come to.
My lord, may I
paragraph
read the whole paragraph?
I am ready for you.
Well, either both points have to be raised. If sag is, it will increase possibly, my lord, tension will increase, my lord. This other both points will have to be raised. Both points if are raised, then minimum height is being reduced on that from the top. This point was missed in the affidavit. This when the officer went to inspect, he pointed it out. And my lord, during inspection, they did not raise even. They were told to give their objections. No objections were made.
We are not expert.
It is touching a corner of a
Yes,
pillar.
And Lord, so far construction is from.
No, it has been repeatedly said that construction has not.
At the same time, let me finish, then you will have your chance. Also.
1500 of one wire of cradle guard crosses over the petitioner's building. Yes, Mr. Ghosh. Finish.
Kindly see, Lord. So far, Lord, kindly come compliance with paragraph 5.
Yes, yes.
Your Lord, second paragraph, during inspection on 20th November 2024, it is observed that the cradle guard does not touch the surface of the roof of the petitioner's house. The wire, in fact, is touching a corner of pillar of the parapet wall, which seems to be constructed after installation. Parapet wall after installation 58 you have constructed. How we can say all these things? And Lord, that apart, Lord, they have in their affidavit specifically denied that it never fell down. In 2007, it was, Lord, set up in terms of the Honorable High Court's order, Division Bench order. Lord, till 2000, from 2007 till 2018 April, until it fell down, we never made any complaint. 2018, Lord, serious matter. That's why immediately, by verbally we intimated. They didn't take care. After repeated representation, ultimately they came and Lord, they placed it in such a manner. And accordingly, we had to approach, repeatedly say that you do it properly. They didn't.
You are placing the second paragraph, yes.
Yes.
What about the second paragraph?
Cradle guard is situated about minimum clearance of 28 mm from the live wire and 950 mm from petitioner's roof.
What are you placing?
Huh?
Which portion are you placing?
No, this is the last paragraph.
Compliance of para 5, you are reading the second paragraph.
Yes. Third paragraph now.
No, what is the meaning of the second paragraph? I don't understand.
Second paragraph, Lord, the cradle guard process of the petitioner
Does not touch the surface of the roof, but in fact,
yes, it touches the corner.
wire is touching a corner of a pillar of the paragraph, not the cradle guard. The wire itself.
Yes, cradle guard. Cradle guard. Cradle guard or wire?
Let us take it to be cradle guard.
Wire. Cradle guard is not made of wire.
Right.
That's
In fact, it's touching a corner of a pillar of a parapet wall, which seems to be constructed after
Yes.
installation. 1500 millimeter of one wire of cradle guard crosses over the petitioner's building.
Yes.
Actual contact part is 340 millimeter. The cradle guard is situated in about minimum clearance of such and such from the live wire. 950 millimeter from the parapet wall. But this appears to be contradictory then.
Yes.
This is not a roof. This is a parapet wall.
Yes. It has processed
Your roof.
across the roof.
Have you annexed any photograph?
Yes, also. But I have also an explorer in reply. With reply, we have annexed some photographs. Right?
Mr. Dasgupta, apparently there is contempt. You have admitted that it is touching the parapet. We don't find any evidence that it has been constructed newly. Not also apparent from the
It is
photograph.
evident from the record. If your lordship kindly sees what I am showing, kindly sees what I am showing. my lord.
Yes. Yes, Mr. Ghosh, take your seat. Yes, Mr.
My lord, kindly sees what I am showing.
Yes, go.
Well, from the writ petition, my lord, it was his own prayer.
Yes,
So
what was
page,
his-
page 23. Well, the whole purpose was, his initial prayer at that time was that I cannot raise my height of my building because of the high tension wire. This solution was found, and my lord, he agreed to this. Your lordship, 23 is the original order. In view of the fact the petitioner now wants to raise further floors.
Lord, that is
My lord,
that was
Mr. Ghosh, please don't comment. You are a senior advocate now. Please take your seat. Yes.
In view of the fact that petitioner now wants to raise further floors on his existing construction, and in view of the fact that the high tension line is already running over his land, for which raising of further construction is not possible, the secretary WBSCB as well as the divisional railway manager shall the division is directed to consider a representation of the petitioner and and the representation after giving opportunity to the thereafter you can next page lordship need not go through. This was the solution advised. The cradle guard possibly he had possibly advised to remove the line, possibly.
Let us
Subsequent,
come to the order date 9th of 9/11/2006,
my lord, order dated.
page 29 of the writ.
My lord, kindly see
That was the premise of my
yes,
order.
yes, my lord. Previous page, my lord, kindly see. Previous page, the chart is, it was a single story house.
No, that is a representation of a house. This is not the
My
photograph
lord,
of a
kindly
house.
read it with the original order. He wanted to raise. That is what I
In
placed.
the original order, there is no mention about how many floors there were already.
My lord, in fact, my lord, then, my lord, in view of the fact the petitioner now wants to raise further floors on his existing construction.
Right.
It was a single story house.
No, that's what you were saying. It nowhere mentions it was a single story house. He wanted to raise further construction over his present construction. That was the finding.
My lord,
The number of stories of the construction was never recorded. And the photograph says it's a pretty old building. And let us come to the and this photograph is representational. This does not say how many stories there are.
Well,
It's your own photograph.
No, my lord, subsequently, my lord, he has made construction of
Let
this
us see
parapet.
from the actual order, which was the premise of my order, whether there is any reflection of the number of stories. That was
No,
the direction.
your lordship's order, my lord.
No.
The-
Division bench order, page 29. Please
My
come
lord.
to that. That was the premise of my order. I directed implementation of this order.
Yes, my lord. Yes, my lord. Placing cradle card and a sketch map proposed by the page 30 has been placed before us with copy Mr. Ghosh. Mr. Majumdar has taken further written instruction from his client that in addition to that, the railway authority will also guard the said wire by fixing to 25 kV danger
Yes,
board. My lord. This was the part.
Let us see last paragraph of that page 30.
In view of such submission parties, we set aside the order impugned and instead of that, direct the railway authority to protect the safety and security inhabitants of the land and building of the appellant by placing cradle guard and also by fixing 25 kV danger same my lord, board on the fencing of the board as suggested in the sketch map. Now, my lord, during when the contempt was moved, whole focus was on the sketch map, my lord. If sketch map is sacrosanct, my lord, it is a single story building.
No, sketch map is a depiction of a construction. It's like a drawing by a child of a person. It does not say about anything about the stories.
My lord, initially it was, my lord, it is a fact. Let
Mr.
them
Bandabhat,
deny.
we are not so gullible.
My lord,
You are in palpable contempt.
My lord,
Cradle guard is touching his building and you are defending.
my lord, kindly see the cradle guard.
Specific direction was there
had-
that the cradle guard has to be there to protect his building from electrocution.
My lord,
And your cradle guard is touching his building and you are saying it's a new construction.
my lord, the new construction is the parapet wall, my lord, not the building.
Does not appear from the photograph it's a new
My lord,
construction.
kindly see my
You have to
affidavit.
prove it
Kindly
otherwise.
see it, my affidavit in opposition, my lord. I have given photograph. I have shown your lordship. There is one more photograph I can show, my lord.
In the opposition, what does it say? The photograph of what?
Of photographs of the building, which is of the whole wire, my lord, and the parapet wall, my lord.
Yes, your opposition of container number 2.
Yes, এটা আলাদা রাখো। আমি তো এক্ষুনি তো দেখলাম।
1 and 2, there are 2. Which one? Deepak Nigam and Gopal Bose.
But this is affidavit of opposition, my lord, this is one opposition, my lord. Affidavit in opposition, this is date.
Yes, it is touching this parapet wall. This parapet
yes,
wall,
yes.
if at all a new construction has been made, that's on the other side. That's not.
No, my lord. The parapet wall is.
This is by no stretch of imagination a new construction.
My lord, because the whole yes, so kindly see the on page 7, page 7, page 7, my lord, page 7, page 7, page 6 and 7, 6 and 7. My lord, a parapet wall, if there is no obstruction, will be in a single line, my lord. Kindly see this part, corner part. It is deliberately kept low.
But it seems to be very old, not recent construction.
Not, my lord, he is saying in 2018. 2018.
1958.
And he has constructed it before that. He is saying that in 2018, the cradle guard fell down. It cradle guard fell down, man.
What was the direction? Let us see. The cradle guard was already there when my order was passed.
Yes. That is not denied. He is saying that in 2018 my cradle guard had the cradle guard had fallen down on the roof. It was a specific case. It was on the it has fallen down on the roof. Lordship will pass a direction to raise the height. It is now touching the roof. And in first occasion, we had said, my lord, that it is not touching the roof, it is touching the parapet wall. He said no construction. He said no construction has been made. Now it appears that there is a parapet wall. There is a
No, there is no proof of new construction. You just
my lord, kindly see from the
tighten
photographs.
tighten the cradle guard so that it goes up above 800 millimeters.
My lord, it is technically difficult, very difficult, my lord. Otherwise, we wouldn't have resisted the contempt. There is no issue here.
No. And why shouldn't contempt rule be issued? You are in contempt already. It's touching the parapet wall. It's touching the building. There's no proof of new construction. No proof of new construction.
My lord, the parapet wall, if parapet wall is always in a straight line, my lord. I have never seen a parapet wall which goes to a certain height, then suddenly fall down to.
I have seen many parapet walls in old buildings.
Because of some circumstance, either there is a war or a wire, or there is some other construction.
Learned counsel for the alleged contemners seeks to impress upon.
Kindly give us leave to remove the cradle wall, cradle wire.
That will be more risky for them. You cannot use this as a warning against them.
No, but
they are not at fault. You are at fault.
It is not about, it is not about our unwillingness to do it. It is about.
Then you install a new cradle guard higher than this. Install a new cradle guard.
Technically, I have given the report of the engineer, my lord. The minimum height has to be maintained. Difference.
Learned counsel for the alleged.
But also one photograph. I've
seen the photographs.
I've shown, no, this one, my lord, where this was taken by the officer, not by the officer appointed by your lordship.
This is not on record. Why should I do that? Then counsels appearing for the alleged contemner seeks to impress upon the court that there has been a new construction by the petitioner, due to which the cradle guard, which was initially not touching the house of the petitioner, is now touching a portion of the parapet wall. Push up next para, however, from the photographs annexed to the affidavit in opposition of the alleged contemners, this court is not convinced that the parapet walls in question even seem to be new constructions. Moreover, there is nothing but the conjecture of the alleged contemners to establish or prove any new construction having been made by the petitioner after the order of this court, which is in contempt. Next para. In the order dated August 24, 2023, it was categorically directed that the railway authorities would remove the cradle guard and reposition it sufficiently above the top of the roof of the petitioner's property, as indicated in a sketch map annexed at page 28 of the said writ petition, and in terms of an order dated November 9, 2006, passed in MAT 1793 of 2003, at the earliest, positively within 2 months, after having come out unsuccessful in a review application and having permitted the said order to attain finality by not preferring any appeal at any point of time against the same, the alleged contemner now places reliance on a report by the expert appointed by the court to substantiate its case as indicated above. However, from the report itself, it is clear that the cradle guard does not touch the surface of the roof of the petitioner's house, but in fact is touching a corner of a pillar of the parapet wall, which according to the expert within double inverted seems to be constructed after the installation of cradle guard. Double inverted close, next para. The expert, the expert was appointed, in the absence of any suggestion being made by the petitioner, to be an officer of the alleged contemner. Next para. The conjecture as reflected in the report itself vitiates the independence of the expert as such. Full stop. It was entirely beyond the charter of the expert to arrive at a surmise that some new construction seems to have been made after the installation of cradle guard. Full stop. There is absolutely no basis for such finding, nor was the expert appointed to make conjectures as to when the construction was made. Full stop. The limited jurisdiction of the expert appointed was to ascertain the point as to whether the cradle guard could be lifted further towards the high tension wire so that it does not touch the petitioner's house any longer. Full stop. Next para. Hence, such surmise of the expert is ignored. Full stop. Next para. The other portion of the report clearly says that 1500 millimeter of one wire of the cradle guard crosses over the petitioner's building, and there is an actual contact part with the petitioner's building to the extent of 340 millimeters. Full stop. Next para. As per the report itself, the minimum clearance between 25 kV transmission wire and cradle guard has to be 2000 millimeter, whereas in the present case, the distance between the two is 2800 millimeter. Full stop. Hence, margin of 800 millimeter is still there over the recommended parameter. Full stop. Next para. The expert cites the risk which can ensue if the sag in the cradle guard, which apparently caused the touching of the same with the petitioner's house, is to be removed, the wire is to be raised by 800 millimeter, either by reducing the sag, which would increase the tension, or by raising the height at the support tower of both ends, which would decrease the clearance at both ends. Full stop. Next para. Since the second option is not feasible, as it will decrease the clearance level between the wire and the cradle guard beyond permissible limits, the alleged contender is directed to immediately resort to the first option, that is to increase the tension of the wire of the cradle guard, which is at present touching a portion of the building of the petitioner, to the extent of 800 millimeter above its present situation. Full stop. Next para. Since admittedly there is a sag in the said wire of the cradle guard, no detriment can occur to either of the parties or to public safety if the sag is removed by ensuring that the touching wire, that the wire which is touching the building is made taut, T-A-U-T, by reducing the sag. Full stop. Such work shall be done within a fortnight from date, and a report of compliance in that regard shall be filed by the alleged contender on the returnable date. Full stop. The matter shall next be listed on March 21, 2025. Full stop. It is made clear that in the absence of any proof whatsoever that any new construction has been made between the order of this court dated August 24, 2023 and the present date, the pretext of not having removed the cradle guard further above taken by the alleged contender is disbelieved. Full stop. Hence, in the event it is found on the next occasion that the alleged contender has not complied with the direction given in this order, the alleged contenders shall run the risk of being penalized for contumacious violation of this code. Parties shall act on a server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. The exception to the report filed by the petitioner today be kept on.
May I pray for a little more time, because I do not know how
much
much time.
ওটা 2 weeks fortnight 3 weeks করে দাও, 3 weeks করে দাও, returnable date 28.
I will take instruction if they say it can be done.
3 weeks ওটা fortnight 3 weeks, within 3 weeks, আর returnable date হচ্ছে 28. Pass format. Yes, Mr. Ganguly. What is the matter?
But I'm for the judge.
There is no caveats. You are moving for the first time. Yes. What is that?
My lord, here, my lord, the suit was for declaration and for permanent injunction. Degree was passed, my lord, in the favor of the plaintiff degree holders, my lord. Now, my lord, challenging that order, my lord, a appeal was prepared, my lord, the trial court's order was affirmed. My lord, I filed a second appeal due to my lord, technicalities. The second appeal, my lord, my lord, was dismissed.
Declaration and permanent.
Now, in the
Technicality means?
my lord, the certified copy of the original judgment and degree has to
You
be
must have been permitted to file that. You did not
My
file.
lord,
That's why it was dismissed.
But I could not, in time, my lord, I could not get that. My lord.
So
My
there
lord,
is no appeal now. You
Yes.
lost your
Yes.
suit. Yes.
Now, my lord, in the execution, my lord,
Yes.
kindly come to page 30,
30.
my lord,
Yes.
Annexure C.
Right.
My lord, here, my lord, the degree holder filed an application under Order 13 and Rule 7. My lord, thereby trying to, my lord, go beyond the degree which has been passed by the learned trial court.
What was the points of
Kindly come to page 31. The my lord, the things, my lord, which has to be done by the commissioners, my lord, is predicted here, my lord. Nalishi cost also.
No, execution.
Yes, in the execution proceedings.
No. Once again, sorry, I understood you incorrectly. It was there. The opposite party was a plaintiff.
Yes.
Or declaration was granted, and permanent injunction.
Restraining me not to disturb their position.
So what is the alleged violation? I mean, execution of injunction portion. Declaration, there cannot be an execution.
There is no, my lord, violation. They say,
according to them, what is the?
my lord, they say now a new cause of action, my lord, came into place.
Where is their execution petition?
My lord, at page, my lord, in connection with the execution petition.
No, in the execution, what they have said.
Execution, my lord, I have.
Either the tabular statement or something
I
like that. The violation must have been mentioned there.
One second.
Must have been violation of the injunction. Declaration in that effect.
Well, there was no.
Yes, they have also alleged in their Order 13 and Rule 7. Let us please place the Order 13
Yes,
and Rule 7. 30.
Kindly see, my lord, Ukto Jari
শান্তিপূর্ণ দখলে বাধাবিঘ্ন সৃষ্টি.
Now, my lord, what he intends to, my lord, have this investigation, my lord will find at page 31. নালিশি ক তফসিল সম্পত্তি উপস্থিতে খ তফসিল সম্পত্তিতে বর্তমানে কিরূপ অবস্থায় আছে তাহা দেখিয়া রিপোর্ট দিতে হইবে। নালিশি খ তফসিল পূর্বে প্রান্তে কোনো টিনের গেট বসাইয়া খ তফসিলের ভূমিতে প্রবেশ অবরুদ্ধ হয়েছে কিনা, অর্থাৎ খ তফসিলের পূর্বান্তে কোনো গেট বসানো হয়েছে কিনা তাহা দেখিয়া রিপোর্ট দিতে হইবে। উক্ত গেটের এক প্রান্তে ক তফসিল গৃহে প্রাচীরের সহিত ও অপর প্রান্তের খ তফসিলের উপর দিকে দেওয়ালের সহিত অ্যাটাচ করা হয়েছে কিনা তাহা দেখিয়া রিপোর্ট দিতে হইবে। কমিশনার বাবু তার বর্তমান খ তফসিলের রাস্তার দিকে কোনো গেট বসানো থাকিলে তাহার বিবরণের রিপোর্ট উল্লেখ করিতে হইবে। কমিশনার বাবু তার কমিশন কার্য বিষয়ে একটি হাতটানা নকশা রিপোর্টের সহিত দাখিল করিতে হইবে। বাদী ডিগ্রির পক্ষে অপর যে সকল লোকাল ফিচার্স দর্শাইবেন তাহা দেখিয়া রিপোর্ট দিতে হইবে। Thereafter, I filed my objection to that effect.
But they have alleged that you are disturbing their position by affixing a gate or what?
Yes, my lord, this is their case, ma'am.
Then this local inspection is.
Now, my lord.
No, it's necessary then.
In the decree, my lord, nowhere, my lord, they have stated that I have obstructed, my lord. Kindly see.
Decree, how can they say?
No, in the application, they say in the application that, kindly see, my lord.
In their 39(7) application?
Yes, nowhere they have stated.
Yes, they have stated.
I have
জারি
obstructed.
মোকদ্দমা চলাকালীন বিবাদী দেনদার বাদীর ডিগ্রি প্রাপ্ত খ তপশিলের পূর্ব প্রান্তে টিনের গেট বসাইয়া খ তপশিলে বাদীর ডিগ্রিদারের দখলে বাধা সৃষ্টি করিয়াছেন. So they are now wanting to see whether that gate has been affixed by you. Quite correct.
My lord, my objection, my lord, kindly see, my lord.
Yes.
At paragraph 3, my lord.
3, yes.
My lord, that the instant execution proceeding has been initiated in respect of the degree of the perpetual injunction. The said order of perpetual injunction has been passed by the learned trial court to the effect.
This is not a new cause of action.
That the defendants are restrained permanently from disturbing the peaceful position of the plaintiff. Naturally, the decree
Not a new cause of
may put the order of execution only to the effect as provided in CPC, but not beyond that.
What is provided in CPC?
Pertinent to mention here that neither the degree holder has any right to ventilate or a new cause of action, nor the learned executor has any jurisdiction to put the degree into execution which is not within the schedule of the plaintiff. And whatever the degree was not for any removal of any obstruction. Now, the learned executing court has allowed that application. Impugned order, my lord, will find.
No. Order 20-32(5) permits the executive court to direct any act to be done to make it practicable for the decree holder to enjoy the decree.
My lord,
I'll quote that and say that this is right. Dismissed. The present revisional application has been preferred by the judgment debtor in a decree for declaration and permanent injunction restraining the judgment debtor stroke petitioner from disturbing the peaceful possession of the decree holder stroke opposite party in respect of the suit premises. Next para, in the execution case levied by the decree holder, it has been alleged that the petitioner is trying to disturb the possession of the decree holder by putting a tin gate on one side of the cost schedule property, which is a part of the decretal property. Full stop. In support of such execution case, a local inspection was sought to ascertain whether any such gate has been installed and on ancillary points. Full stop. Next para. Learned counsel appearing for the judgment debtors stroke petitioners submits that the decree holder is trying to make out a new cause of action in execution, thereby going behind the decree, which is not permissible in law. Full stop. However, upon a perusal of the decree, it is seen that inter alia, a decree of declaration was granted along with a permanent restraint order whereby the judgment debtors were restrained from disturbing the peaceful possession of the plaintiff in respect of the suit property. Full stop. Next para. Order 21, Rule 32 within bracket 5 of the Code of Civil Procedure clearly empowers the executing court, over and above the other measures for violation of an order of injunction such as attachment, etc., in lieu of or in addition to all or any of the said processes, direct that the act required to be done may be done so far as practicable by the decree holder or some other person appointed by the court at the cost of the judgment debtor, and upon the act being done, the expenses incurred to be ascertained and directed to be recovered as if they were included in the decree. Full stop. Hence, the executing court acted well within its powers in granting the prayer for local inspection to ascertain whether any gate has been installed, which is in aid of the execution case itself. Full stop. I do not find that the learned executing court went beyond its jurisdiction in such capacity in passing the said direction, since the executing court can very well pass necessary directions for removal of such tin gate, if at all installed, to block the ingress and egress of the our decree holders and consequentially to disturb the possession of the decree holder in respect of the decretal premises. Hence, there is no illegality or irregularity and or jurisdictional error in the impugned order. Accordingly, CO 3747 of 2024 is dismissed, thereby affirming the impugned order bearing order number 116 dated August 31, 2024, passed by the learned civil judge, Junior Division, First Court, Shodor at Bakura in judicial miscellaneous case number 84 of 2018 in connection with title execution case number 05 of 2018 arising out of title suit number 74 of 2003. Full stop. There will be no rise to cost.
Time for the petition. First day, order.
For the first time.
First time.
There is no other side.
No.
What is the contempt?
Kindly come to page
For
20.
the alleged contempt, my lord, we've preferred an appeal from my lord's order
That's still pending. It was item 42 on Wednesday. It's likely to be called.
You've got a copy of this?
No,
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 I haven't. It's
this
coming
is
up for the
first
first
day.
time. My lord will kindly
But
record
in
my.
the appeal, there is no stay, my lord.
No, that will be done.
We'll give you till 21st.
My lord, could it only be till April? My lord, we'll take our chance. It's like to be called in the next week. My lord, subject to the business of the honorable.
For the timing 21st.
Grateful, my lord.
Learned counsel for the petitioner. Now, at the outset, comma, when the contempt application is sought to be moved, comma, learned counsel, who will be your advocate on record?
My lord, Mr. Shanton Bose. My lord.
Mr. Mukhopadhyay, comma, learned counsel, having instruction to appear through his learned advocate on record for the alleged contemptor, comma, submits that an appeal has been preferred against the order under contempt, which is pending in the list of the concerned division bench. Full stop, next para, an adjournment is accordingly sought. Full stop. The petitioner shall serve a copy of the contempt application on the learned advocate having instruction to appear for the alleged contemptor. In the meantime, full stop. For the sake of propriety, comma, in view of pendency of the appeal, comma, the matter is adjourned till the contempt application is adjourned till March 21, 2025.
Obliged.
Grateful, my lord.
Obliged.
Give a copy to him. Copy has been served?
For the petition.
Yes, Mr. Arfin.
Yeah, my lord, we have filed an appeal, my lord, is pending, my lord, and
All appeals are filed after the contempts are moved.
my lord, content, my lord.
And
First, my lord,
all cases, all.
no stay application has been served even. My lord, earlier also, they have filed a review application and then wrong appeal before the wrong bench.
both have
In
been
this,
tagged
they
together,
are,
my
they
lord,
are,
and it was
they are
supposed to be
purchasing
taken
time.
up, my lord, next week.
The order is very innocuous order and my lord. and
What
then
was the order? What was the order?
the order was to allow to take poll as per the contract. This is a land users scheme. As per land users scheme, page my lord 19 of the order, my lord, can it turns to.
It was directed to be to appear in the list after notice is completed. You have completed notice. You have not even served them.
May I take
No, Lordship, I am for the advocate record, Lordship, I have served, Lordship. I served today, Lordship, day before yesterday, my eye operation, Lordship, I am not going to court, Lordship. But I served, Lordship. But no, the Chief Justice, Honorable Chief Justice said the fresh notice, the one that matter was listed, then matter will be listed. This is the order of
We would like to see that affidavit of service, but
Lordship, I have served, Lordship, the copy, Lordship.
you are saying that he is denying. Petitioner is saying no copy.
No, served, Lordship.
The memo of appeal. There is no stay application.
Lordship,
You have not filed any stay application?
That is my point.
Lordship, from the review, I filed the stay application, Lordship. Both are listed, Lordship. Both are listed along with the from the review and
they are appearing in the list before the division bench.
Yes, Lordship. The order by my learned junior may show the order by the division bench, Lordship.
Who is the junior and who is the senior?
Narul
is you. You are Narul and you are his junior, he's saying.
But he is the advocate record, my lord, but my lord, he is conducting it, my lord.
He is asking you to show us that it is appearing before some court. This does not say. It is appearing before the bench today.
Lordship. Not today, Lordship. The matter was appeared because the
when will it appear next?
Division bench says serve notice and come.
Mr. Let us, Mr. Adafin is addressing us. Let us speak with him. We cannot speak with both.
Lordship.
Yes, Mr. Arfin, this is an order dated 26th of February 2025.
Yes,
it does not fix a date for hearing of the appeal. It says that after service of notice is completed on all the respondents, it will be listed, which is quite uncertain. What steps have you taken after this?
They are not interested to get.
Show us that you have served on them.
Now, my lord,
Have you filed any stay application?
I did not. I was not served with any stay application.
Now, the difficulty is, my lord, Mr. Vijay Kumar, my lord, is the advocate on record, my lord. He is drafting, my lord, and he is conducting that part, my lord. That's why, my lord, I could not.
Learned counsel for the petitioner submits that the alleged contemners are taking the
Lordship, due to eye operation, I am not going to court, Lordship.
Taking the matter casually, and no copy of any stay application has been served with the appeals allegedly filed against the parent order which is in contempt. Full stop, next para. Learned counsel for the respondent, learned counsel for the alleged contemner submits that the learned advocate and record appearing for the alleged contemners has undergone an eye operation and is unable to furnish appropriate affidavits of service showing that copies of the memoranda and the stay applications in connection with the appeals have been served on the petitioner. Full stop, let the matter be adjourned till March 21, 2025, when the appellant shall satisfy this court as to due steps having been taken for service of copies of the memoranda of the pending appeals and the connected applications on the petitioner, as well as for enlistment of the appeal before the division bench. Full stop. In the event the matter is not enlisted before the division bench before the next returnable date, appropriate orders may be passed against the alleged contemners. Keep this with you. This does not prove anything. It has to be at least on the list on the next returnable date. Because that will only happen after you complete service. Let us come back 14th. Next Friday is a holiday. So you have to come back on 21st. Next.
In this matter, my lord, I appear for the petition.
Who is for the respondent? You.
I'm for the contemner 2. The contemners. On 10th of January, my lord has been pleased to pass an order. Pursuant to that order, my lord, the district magistrate Purba Bardhaman has been made party as one of the contemner, and the service has been effected.
But with regard to Purba Bardhaman, I have instructions to appear on behalf of them as well. Firstly, Paschim Bardhaman has paid the ex gratia part with regard
This is
to
the affidavit of
1987 to 2024, which amounts to 32,000 and odd, that has already been paid. There were three parts which was left due. First is ex gratia. Now, second is payment with regard to the earlier other parts. There was TDS deducted. His contention is TDS could not have been deducted since this is a retirement dispute. But we say that TDS was deducted as per the statutory norms of the government. He can immediately file for refund and would get subject to his filing of the return. TDS part, this is our specific instruction. And with respect to GPF, we say that he was forced to retire in 1987 when this district was not even born. He retired in 1987 in the district of Bardhaman, not Purbo, neither Paschim. So after his retirement, he has availed this jurisdiction only on the point of his residence. He resides within the jurisdiction of Paschim Bardhaman. And as such, he had filed this writ petition and orders were passed directing the DM of Paschim Bardhaman to release his benefits. No iota of papers with regard to his service period are available with Paschim Bardhaman. Whatever we could gather and pay, where upon getting the records transmitted, upon the instructions received from the contemner number 2 to us, we could clear rest of the part. With regard to GPF, neither the writ petitioner could provide us with any concrete calculation of his GPF dues, nor we could find any documents with regard to calculation of his GPF records.
You have the period of his service. Otherwise, how could you disburse the others?
We have the period.
Why can't you calculate the GPF at the rate of
his service, last drawn amount, his promotions, nothing are on record with us.
What are the we could have asked him to do?
Yes, he had provided us a calculation, and on that basis, we have given rest of the amounts.
GPF also, why not?
GPF, he has not calculated and given us any tabulation.
What do you say? GPF calculation, what is your calculation?
My calculation is nothing. The National Commission for the Scheduled Caste has passed an order directing them to comply with the order. That has not been complied with. They admitted the actual dues, what my client is entitled to. That has not been paid. Therefore, the writ petition was moved. Writ petition, my lord, kindly have a look to my lord's order, page 123 of the contempt application.
Order was directing us.
Now he is going behind the decree, my lord. But the path, my lord has been pleased to pass an order. Repeated directions has been made to clear the GPF amount as well as other dues, my lord. That has not been.
Deny that. Not even I'm trying to evade.
You know, they said Purva Bardhaman should be made a party. Now he has been made a party. He has been added. Service has been affected.
Arrears of GPF to be calculated by you. You have the service period, calculate the GPF.
Do not have his record. Let him.
What records?
Records of.
How could you disburse the other components of the?
On the basis of his calculation provided by him.
No.
What further record is required for calculating GPF? You are the authority. You must know. You must know from your records. What was the? You ascertain from your records.
He did not have the record.
Records of what? His service period is with you.
With regard to his service period, those lie with Purva Bardhaman, not with.
You are appearing for both.
Now I am appearing. For
Yes.
both.
Let both the district magistrates be present, Mr. Doctor. There is a limit to the patience of the court. No, definitely not. Both of them will be present in court and they'll personally explain why they're doing this. This poor person is not getting his patient. No, definitely not, Mr. Doctor. There's a limit to lenience. We have been lenient enough. Let the district magistrate be behind the bars. Let them understand what is the taste of the jail food and then they will disburse his amount. Otherwise, they'll attach their salaries while they're in jail. Mr. Doctor, no, they'll be present in court. Yes, please take down an order.
Kindly hears me for.
Ridiculous pretexts are being taken by the alleged contemners. Full stop. On previous occasions, an argument was made that since the initially Purva was added, Poschim was added. Initially, that since the district magistrate Poschim Bardhaman was not impleaded as a party and the dues of the petitioner were payable by Poschim Bardhaman, the dues of the petitioner could not be disbursed. First up, today when the matter is called on for hearing,
Poschim was there.
Next para. Today when the matter is called on for hearing, learned counsel having instruction to appear for both the alleged contemners, that is the district magistrates of Purva Bardhaman as well as Poschim Bardhaman, submits that they do not have the particulars which are required to disburse the GPF component of the petitioner. Push up next para. However, it is beyond understanding as to why, despite having disbursed the other components of the retirement benefits of the petitioner, the GPF amount payable to him could not be calculated. Full stop. Since the service tenure of the petitioner is before the authorities and the calculations are only required to be made mathematically on the basis of the GPF amount statutorily payable for the relevant period, the alleged contemners cannot take shelter under the petitioner having not furnished such calculations to the alleged contemners. Full stop. In fact, in the order under contempt, there was specific direction by this court that the GPF amount will be calculated by the respondent therein and shall be paid within a limited period to the petitioner. Full stop. It is, thus, clear that both the alleged contemners are in tandem in ensuring that the dues, specifically directed by this court, are deliberately not being paid to the petitioner. Full stop. Accordingly, a rule do issue calling upon the alleged contemners to show cause as to why the alleged contemners shall not be punished for deliberate and contumacious violation of the order of this court. Full stop. Such rule is made returnable on on April 11, 2025 at 2 p.m. when both the alleged contemners shall be personally present in court. Please put in the requisites for.
I am appealing for contempt number 2, my lord. In the last occasion, I have submitted the office of the contempt number 2 has no role to play.
Next matter. Both of you will come.
I am not appearing for the district magistrate, my lord. I am for the office of the principal accountant general. On the last occasion, I have submitted a document, my lord, from which I have requested the concerned district magistrates, my lord, that GPF account is.
How many contemners are there?
There are
now there are 3.
Now there are 3.
You are number 1.
Number 2. We have no role to play.
Jeta rule issue korlam against alleged contempt numbers 1 and 3.
I am grateful.
Only one thing, my lord.
Nothing, Mr. Lord. Let them come. They will explain. You don't have to take the trouble. Next. Yes. Yes, Mr. Mr. Ali, should I pass any order today? Because there's a resolution of the bar. The other side is not present. That's why I'm asking. If you want, I can take up. I don't have anything. I'm taking up matters, but and I'm not bound by the resolution of the bar also. But morally, I'm bound. Maybe legally, I'm not bound.
Personally, I appreciate it.
Mr. Ali, if you want to proceed, I will take up expertise. I don't have any qualms, but I'm just giving it, asking you whether you.
I leave it unto your lordship.
Because they're appearing. If it was expertise, definitely. I'll record that none appears for the alleged containers at the time of call. Full stop.
No.
Affidavit of service filed today be kept on record. Full stop. Let the as a last chance to the alleged contemner to appear and contest the matter. The same is adjourned till March 21, 2025. 14th is a holiday, so therefore. Next.
This matter I am paying for not to my lord.
On the prayer petitioner?
Yes, my lord.
On the prayer of the petitioner, the matter is adjourned for the day. Give your name, give your name.
Man, this is first time appearance.
First time, yes. What is the contempt?
Matter about credit card fraud, my lord.
Credit card fraud. What was the direction by this court?
My lord, direction by this court not to take petitioner have zero liability because fraud report as per the guideline of the RBI. Now, my lord, subsequently they have issued a notice for settlement at the Lok Adalat. And
So after filing of the contempt.
no, previous.
So then?
But after passing order, main order.
No, settlement. If you are not willing to settle the matter, then inform.
Petitioner have zero liability as per the guideline of the RBI.
No. The order was restraining the respondent bank from making any claim on the basis of the amount which was fraudulently debited.
Yes.
They have made a claim. Yes.
No, what they are doing is, my lord,
Yes.
my lord comes to my lord regularly, my lord sending SMSs,
Yes.
my lord phone calls, alerts, my lord they are, my lord, and my lord we have sent emails also, my lord, of the order, my lord, and furthermore, my lord has directed them to my lord settle the credit score, my lord, in civil, my lord.
They have not
Which
done.
They have not done. It's my lord.
A prima facie case of contempt has been made out inasmuch as the alleged contemner. How many contemners?
My lord, there are 14 contemners.
Several. Alleged contemners have not complied with the order dated December 7, 2023, whereby the respondent bank in the said writ petition was restrained from making any claim from the petitioner on the basis of the amount which was fraudulently debited from the account of the petitioner on the strength of the petitioner apostrophe credit card, as well as directing the respondent bank to reverse the adverse civil listing of the petitioner on the ground of the amount covered by the said fraud within 24 hours. Full stop. It is alleged by learned counsel for the petitioner that neither has the adverse civil listing been reversed, nor has the order of restraint been complied with, since repeated phone calls and short SMSs are being sent via social media to the petitioner to pay up the amount on the basis of the said fraudulently debited amount. Full stop. Accordingly, the petitioner shall serve copies of the contempt application on the alleged contemners, indicating that the matter shall be listed next on April 11, 2025, when an affidavit of service to that effect shall be filed by the petitioners.
Okay.
Thank you.
Manaship, one small indulgence, Manaship. Manaship, item number 18, Manaship, I have filed the affidavit in exception to the report, Manaship.
আচ্ছা এই 18 এ এফিডেভিট অফ সার্ভিস বললাম যেটা আমজাদ দায় পেপার ওটা এফিডেভিট অফ এক্সেপশন হবে এফিডেভিট অফ এক্সেপশন ফাইল টুডে
Okay.
Yes.
I am for the petitioner.
You for the response.
I'm for contemner, alleged contemner number 4 and 5.
1 to 3.
Page 32.
All have been served. 1 to 3 have a role to play.
Yes, my lord.
1 to 3 have a role to play. You have allegations against them also must.
1 and 2, 1 and 2. 1 and 2 contempt application, my lord, 1 and 2, my lord.
Only 2.
Only 2 এখন present manager, my lord.
Are you sure you're not appearing in the wrong matter?
21 was Arup Pal.
Arup Pal versus Arup
বিশ্বাস
Bank.
You're for Axis Bank.
Arup
So
বিশ্বাস-
Arup, 1 is the manager and 2 is the second, the present branch manager. The previous branch manager and the present branch. So you're appearing for both.
Contempt application has not been served and 4 and 5 is in the read, your lordship.
Oh, yes. Serve a contempt application.
I already served, my lord. Kindly see the affidavit of service.
Lordship, I will.
Affidavit of service filed to be kept on record. Full stop, learned counsel appearing for the alleged contemners.
Explanation, I have got it. What is the explanation?
Learned counsel for the alleged contemners, however, is not equipped with a copy of the said contempt application today and submits that the alleged contemners have a proper explanation for not being able to comply with the order.
Lordship, we have already complied.
Have a proper explanation in as much as they have already complied with the order in question. Full stop. Accordingly, the alleged contemners are directed to file an affidavit of compliance disclosing the said alleged compliance on the next returnable date with an advance copy to the learned counsel for the petitioner. Full stop. The petitioner will be at liberty to use an exception thereto in the event the petitioner is not satisfied with the same. Full stop. The matter shall next be listed on March 28, 2025 under the same heading. Please do it at least by 21st. Within 2 weeks, please hand over this copy so that they can come up with a response. Both of you, please give names.
Well, I have the petitioner, Lord, appearing for the first time, my lord.
What is the contempt?
Page 23 is the impugned order. Page 25, my lord, the paragraph 11 is the directing portion. My lord, directed them to disburse the subsidy amount within 1 month from the
Not
date.
disbursed.
No, my lord.
A prima facie case of contempt has been made out inasmuch as, contrary to the direction of this court dated February 26, 2024, passed in WPA 10353 of 2023, for the respondent authorities to disburse the amount due to the petitioners under the subsidy scheme annexed at page 49 of the writ petition within a month thereafter, no such amount has been disbursed as yet, as alleged by learned counsel for the petitioner. Full stop. Next para. The petitioners shall accordingly serve a copy of the contempt application on the alleged contemner, indicating that the application shall be listed next on April 4, 2025, when an affidavit of service to that effect shall be filed by the petitioners.
Well, this is the first time. Yes.
First time?
Yes.
What is the contempt?
First time. My lord, in this matter, if your lordship kindly see, my lord.
Yes.
Page 21. Page 21, my lord. Lord, what happened in this case, my lord, railway authority floated an auction notice for the purpose of, my lord, parking lot at Sealdah railway station.
Yes.
Now, my lord, my client participated in the said auction and he was selected. Now, my lord, railway authorities ultimately handed over possession. Thereafter, just after giving possession, after 10 days, my lord,
So they were to take a decision on your request for reworking the amount and communicate.
No.
No communication, nothing.
They have communicated it much. Your lordship have gave positive direction
For 4 weeks.
Within a period of 4 weeks.
What have they communicated?
Now, my lord, they have communicated it after
9
9 weeks.
What have they communicated?
9 weeks.
They have taken a decision.
Yes.
Demand for money.
And my lord, they have waived only 4,32,000.
That furnishes a new cause of action. They have taken a decision.
No, my lord, that is not my cause of action. This is
we are taking up the contempt.
Practically, my lord, this cause of action is, my lord, your lordship has set aside the order of termination of my agreement. They have passed an order. Your lordship kindly see the page 22.
Yes, 22.
Page 20, paragraph 17.
Is hereby set aside, yes.
Yes. In spite of that, they have not allowed me to join. There are two parts in the order sheet, my lord. In the first,
Show me that. Which page?
two writ application was filed. One
So
writ.
show the annexure to your contempt application where their communication where they have
Yes,
prevented you from.
Yes, ma'am. Now, your lordship kindly come, my lord, page 30. Page 30, my lord.
They have not stated that you are not, you cannot continue.
Yes.
Where have they stated that?
That is, my lord, in view of the requested.
In this context, it is hereby requested to take over the possession of the aforesaid parking lot.
Page 32. Actually.
Page 30, they have stated take over possession. You have asked, they have asked you to.
My lord, your lordship kindly see, my lord. Page 32. Page 32, my lord.
32, yes.
Page 30. Competent authority has decided to appreciate about termination. Your lordship has.
But they gave you an offer to pay that amount.
My lord, that payment, my lord, your lordship kindly direct. Your lordship was previously.
You are appealing for the respondent. What is your defense?
My lord, they have came up with subsequent writ, my lord, and this is the order, lordship can see.
That is, my lord, challenging order.
And,
Read against what?
Huh?
This the same
Lordship,
cause?
lordship.
My lord, that is.
And they have, my lord has categorically stated to go before the civil court and
Oh.
to
That is
redress
with
their
regard to the amount.
No, the your joining is subject to that amount being paid.
My lord, your lordship have given a specific direction.
Termination was set aside by me.
Termination was
The
set
termination was on ground of non-payment also.
Yes.
Termination was set aside, but subsequently they were directed to to consider your request for reworking the amounts payable. Now, if you don't pay that amount and your challenge against that has not succeeded, unless you pay, why should you be permitted? That's a fresh cause of action.
My lord, kindly see, my lord, page 22, my lord.
I've seen page 22.
It's
It's not in terms of that termination. Now you're not being permitted to join Mr. Pine because of the subsequent cause of action of your non-payment of the outstanding dues. They asked you to join by the communication at page 30, subject to payment of this amount. Your annexure page 30.
My lord, kindly see, my lord, paragraph 19. Page 22. Page 22.
Yes.
So far, WPA 3683 of 2024 is concerned, since the petitioner request for reworking of the terms of the contract in view of the petitioner is not being in possession of the premises for a period.
Mr. Pine, you don't understand.
No,
I am not being able to make you understand. Your termination was despite the pendency of your request. You had requested for reworking. Without considering that, they had terminated. That is why I set aside. I set aside in one writ petition. In the other writ petition, I directed them to reconsider.
Positively within a period of
4 weeks, they have taken 9 weeks. For that, will not send them to jail. Contempt is not for that.
Not jail.
But they have reworked. They have considered and ascertained an amount and given you an offer, pay that amount and join. You don't pay that amount. Now their action is not in terms of the previous termination. Now you have been again not permitted to join because of non-payment of the fresh amount. And Justice Sinha has given you liberty to approach the civil court rightly. You ask for I'll give you liberty to ask for relief of being permitted to join in that suit also.
In that suit also.
The present contempt application has been filed.
Your lordship kindly pass that on.
Comma, being aggrieved by alleged contumacious action on the part of the alleged contemners to the effect that in the teeth of an order dated March 14, 2024, passed in WPA 3683 of 2024, along with WPA 5965 of 2024, setting aside the termination of the petitioner's contract and directing the respondent numbers 2 and 3 in the writ petition to ensure that a decision is taken on the petitioner's request for reworking the amounts payable by the petitioner, comma, within a period of 4 weeks, comma, a decision was taken only after 9 weeks, and the petitioner is not being permitted to join, comma, thereby flouting the order of this court setting aside the termination. To sub next para, learned counsel appearing for the alleged contemners appears and hands over a server copy of an order dated January 24, 2025, passed by a coordinate bench in WPA 29151 of 2024, wherein the learned single judge, comma, while considering a challenge by the present petitioner to the subsequent to the decision, to the fixation of the quantum payable by the petitioner, comma, pursuant to the order of this court, comma, an amount was directed to be paid by the petitioner. Full stop. In the said order, comma, the learned single judge observed that it will be open for the petitioner to approach the competent civil court for redressal of his grievances if so advised. Full stop. There were two components to the order of this court dated March 14, 2024. Full stop. By the first comma, the termination of the petitioner apostrophe's contract by the respondents was set aside on the ground that a pending request of the petitioner for reconsideration of the payable amount was not considered before such termination. Full stop. Next para. In the same breath, comma, the petitioner's request for reworking the terms of the contract regarding the amount payable by the petitioner to the respondents was directed to be decided upon afresh by the respondents. Full stop. Although somewhat beyond the time as directed by this court, comma, fact remains that the respondents have considered the request of the petitioner for reworking the payables and has communicated such order to the petitioner, comma, asking the petitioner to resume in terms of the contract subject to such payment being made. Full stop. Next para. Since a coordinate bench has already granted leave to the petitioner to approach the appropriate civil court challenging the quantum of the outstanding amounts as ascertained by the alleged contemners, and as the resumption of work by the petitioner in terms of the contract is only subject to such payments being made by the petitioner, comma, at this juncture it would be premature to hold that the alleged contemners are guilty of any contumacious act, comma, since the alleged contemners have reworked the payables in terms of the order of this court, but the petitioner has not yet paid the said amount. Thus, comma, the alleged contemners act of resisting the petitioner from resuming work in terms of the contract is not on the basis of the previous termination which was set aside, but due to the fresh cause of action of non-payment of the outstanding dues by the petitioner. Next para. However, comma, the petitioner would be at liberty to seek appropriate reliefs regarding resuming his work in terms of the original contract with the respondents, subject to the ascertainment of the amount payable by the petitioner to the alleged contemners, comma, in the civil suit, which shall be, you have filed a suit, which shall be filed in terms of the leave granted by the coordinate bench in WPA 29151 of 2024. Full stop. However, comma, I do not find any willful and deliberate violation on the part of this court, on the part of the alleged contemners in respect of the order of this court, and accordingly CPN 1728 of 2024 is dismissed without an order to cost.
Only difficulty, my lord, in spite of pending this application, my lord, they have already sued offer letter to other.
Make that injunction application in suit. We have given you liberty. That's an ancillary of if you claim a main relief regarding resumption of the contract subject to payment, you can ask for an injunction there in that regard also.
Again,
maybe some ad hoc. We won't say what order the court gives.
Grateful, my lord.
Yes, thank you.
I appear for the petitioner, my lord, in this matter.
Yes, sir.
My lord, Lordship had directed service by the order of 10th of January 2025
Yes.
My lord, this contempt arises out of an order of, my lord, 17th May 2024, passed in an application seeking implementation of a previous order in a writ petition.
What was
To
the nature of the order?
incentive scheme, issuance of RC2, my lord,
You have served on both.
I have served, my lord, affidavit of service is there,
Your
but
appeal
I
for
must
both.
also indicate, my lord, they have preferred appeal. In fact, when your lordship heard this matter on 17th May, the submission was made that there is an appeal pending. Lordship, in usual fairness, the learned, my lord, Advocate General, my lord, did not make submissions with regard to merits because the appeal was pending. Now, my lord, the appeal is still pending. I can, my lord, do one thing, my lord, subject to my lord's consideration. I am sure he's going to pray for time on that account. If lordship keeps it next Friday, which is next to next Friday, my lord, in that, by that time, we, my lord, hope that the appeal would be, my lord,
Appeal
decided.
is pending in the list. Item number?
Today, my lord, item number 56, 55.
56.
My lord, 55, 56.
It will be taken up within.
Justice Bosak is, my lord, heading the
Justice
division
Bosak,
bench.
yes.
So, my lord, we hope that
We Friday after next. Yes. It is submitted by learned counsel for the alleged contender that an appeal against the parent order is now pending before the appropriate division bench having determination. Push up accordingly. Add affidavit of service filed today be kept on record. In view of the prayer of the alleged contemners, the contempt application is adjourned till March 21, 2025. Next.
Number 26, Lordship's order has been complied with, my lord. We have paid
Your expression says that it has not been.
petitionary letter. Yes, the petitioner has write a letter, my lord, to ask, my lord, that they have received the money, and this is
None appears for the petitioners at the time of call. Learned counsel appearing for the alleged contemners submits that the order of this court has already been complied with, and a letter has been addressed on behalf of the petitioners to the executive engineer, the contemner, to the alleged contemner, acknowledging the receipt of the amount pursuant to the order of this court. A copy of the said communication made by the petitioners is handed over in court and kept on record. In view of the above, CPN 1927 of 2024 is dismissed as infructuous. Thank you, sir. Thank you.
Item number 27.
Your lordship, Shushmita Chatterjee.
You have forgotten the name, you are having to see your phone.
No, I have been instructed by his clerk.
Very well. Just not to record the order record.
Much obliged, your lordship.
For the petitioner.
For the respondent.
You are for the petitioner.
WBCC is the next matter.
There in any event, not today. No order need be recorded. Yes.
Item number 28.
My lord, item number 28, my lord. My lord, order has been complied in this matter, my lord.
You are for the petitioner?
Yes, my lord.
Learned counsel for the petitioner submits that the order of this court has been complied with and the contempt has been rendered infructuous. Accordingly, CPN 1976 of 2024 is disposed of as infructuous. No arrest to cause. Please just give your name. You are Mr.
Mashuk Rahman, my lord.
Pardon?
Mashuk Rahman.
Mashuk
Rahman.
Rahman. এই শোনো না ওটা যেটা আগেটা না লার্নেড কাউন্সিল মিস্টার মাসুক রহমান নামটা yes
and for the first time
appearing. What is the contempt?
Page 20, my lord, for damage compensation by fault of
not paid,
my lord, metro rails. There was region order was passed, my lord, after hearing region order was passed, that is the page 31, but asked me to produce the residence certificate. Thereafter, petitioner applied from the local councillor given the residence certificate which is produced before the KMC. Till now, they are not disbursing compensation. Page 31, my lord.
Directed to give an opportunity of hearing, production of documents shall not create special equity. After exercise is completed, shall decide. They have decided on your claim.
Not on condition to produce the residential certificate.
Where is the decision? Where is the decision?
My lord.
Where is their order?
My lord, page 31, my lord. Next, PC.
Subject to production of those.
My lord.
You have produced, you are saying, but they are not.
My lord. That is my page 52, my lord.
Very good. Learned counsel for the petitioner argues that in the teeth of the order dated March 13, 2024, passed in WP 828757 of 2022, directing the respondents therein to decide on the claim of the petitioner and thereafter, upon granting opportunity to the petitioner to furnish the required documents, to disburse the amount of compensation at the earliest, the alleged contemner, despite having given an opportunity to the petitioner to produce documents and the petitioner having produced all the necessary documents, have not disbursed any compensation in favor of the petitioner. Since the prima facie case has been made out, the petitioner shall serve copies of CPN 193 of 2025 on the alleged contemners, indicating that the matter shall next be listed on April 4, 2025 under the same heading, when an affidavit of service to that effect shall be filed by the petitioner.
Item 30 for two, I take not more than 2 minutes.
Item 15.
30 for 2 minutes. I'll not take more than 2 minutes.
29 ডাকুন 29 ডাকুন আগে হয়ে গেছে 30 yes
Page 20. By not taking, this is a first time. By not taking steps to survey
appealing
the
for the
Indian
other
question.
For the KMC, I'm appearing. I have instruction to appear, my lord. A copy have not been served.
Let us see whether there is in prima facie contempt at all. Yes. What is the contempt?
By not taking steps to survey the area in question within the fortnight from the date and thereafter to initiate due proceedings in accordance with the law for removal of unauthorized encroachment in the immediate vicinity of the transfer in question indicated on several photographs annexed to the writ petition.
What have they not done according to you? Up to what
They have
stage
not removed any all the encroachments under the transformer, which pose a serious threat of any type of explosion, fire, electrical hazards. It was, I mean, your lordship was directed to remove it within the fortnight, but they have done only 2 meetings.
No, I have directed to survey the area within a fortnight. They have to initiate due proceedings under law. Even under public premises eviction of unauthorized.
No,
nothing has been
nothing
initiated.
as such is there. There were some hawkers are there which ought to be removed. That is ordered. Kindly come to page number.
The petitioner has
29.
made out a prima facie case of contempt inasmuch as allegedly, the alleged contemners have not taken steps for removal of unauthorized encroachment in terms of the order dated March 6, 2024, passed in WPA 3984 of 2024. Pushed up. Next para. Learned counsel having instruction to appear on behalf of the contemners, alleged contemners, all are municipal corporations. So you alleged contemners.
I am for the CSC lordship. I am led by Dr. Madhusudan Shahara lordship.
1 minute.
Contemners are only the Kolkata municipal corporations.
You are not the contemner. If you want, we can add you as contemner. Alleged contemners seeks a copy of the contempt application. So accordingly, the learned advocate on record for the petitioner shall serve a copy of the contempt application.
On open court, I'm giving it right now.
Is serving a copy of the alleged contempt application on his counterpart having instruction to appear for the alleged contemners here and now. Full stop. In order to enable the alleged contemners to be properly represented on instructions, let the matter stand adjourned till March 21, 2025. At this juncture, we are not directing you to file an opposition. If you see that there is prima facie, you have taken steps. You can just
they have not taken steps.
Hand over. If you have done something, then hand over. If you want to rely on documents, previously hand over and then produce those. So that I can look into this.
I'm led by instruction Rudran there also.
He's in court.
Yes.
Give it.
Deeply grateful.
Thank you.
Thank you.
Thank you.